in my past life, by the way. So
As
I
do
know,
I.
yeah. So I know trials. I know murder cases. I know a lot of things. Just from
Unfortunately, from
very
the wrong end. Yeah, from the wrong. Unfortunately, we
yeah,
know them from the wrong end of things. But
right.
at the same time, you still get that experience and you learn how things work.
Yeah, and then you change and you progress and then you have your Jesus moment and then here we are. Now we're breaking it down from the other end.
Exactly. Yeah, I did that too, man. Like I said, I was on drugs for probably 10 years of my life. Heavy, heavy, heavy on. I mean, not like hardcore drugs. I was on pain pills.
Yeah.
But I got clean. I eventually hit my breaking point where I was just like, I'm tired of this. I was getting arrested and stuff. And nobody forced me to get clean either. I did it on my own. But I was
Right.
just tired of the constant cycle. Um,
Yeah,
and
for
yeah, I
sure.
got clean. Been clean for almost 16 years now. So, yeah,
Amen to
man,
that, brother.
that's right.
That's an accomplishment for sure. For me, I uh I dabbled. I Of course I was in the mix with dabbling with drugs, but mine was more so like, the street politics and getting caught up in the wrong crowds in California. I grew up in California for like, I would say from the beginning of when I was 8 years old. I moved from Minnesota because my dad had a job offer in oil and gas. So we ended up moving out to California and I ended up getting introduced to the gang culture in California and I ended up getting wrapped up with all that stuff and living a long life of incarceration, going to prison, county jail, juvenile hall. And the crazy thing is I didn't come from a family like that. My family was middle class suburban family and I just so happened to go to intermediate school in a neighborhood that, was quite a distance from my house, but it was the closest junior high school. And I ended up getting tangled up at a young age trying to fit in and all that stuff. And then it ended up in this long road of, fighting cases, armed robberies, and attempt to murder when I was 17 that I got self-defense for, thank God. And but I went through the trial process and all of that stuff on a couple occasions. So maybe I can get into that attempt to murder case that I beat and got self-defense later on if we have time. But yeah, man. And then I got out of prison in 2019, so I'm going on 7 years, discharged my number, ended up moving out of state because I felt like the Lord was leading me uh for change. If I wanted to change my life, I had to change my environment and my friends and the people I was close to and grew up with. But they all understood, because I ended up with two strikes, and anybody who knows California, one more and you're done. So it was really my time to go. So I ended up moving out of state, getting a good job in the oil and gas industry through a family member, and been striving ever since, man.
Yeah, that's what's up, man.
Yeah.
And it's definitely. I think you made a good move because, even like anybody will tell you, like if you really do want to make a change, you've got to change your whole environment. You can't go back to the same pattern, the same lifestyle you were living before, around the same people that were a bad influence on you before.
Right.
You've really got to make that. If you're going to make that change, it's basically starting a whole new life. You know.
Yeah. And the culture we grow up in, it's like we want to fit in and but to really make that change, you have to put your pride aside and like that loyalty to friends and sometimes you got to do what's best for yourself and separate yourself. Even you don't have to even be in the lifestyle we came out of or drugs or anything that you're struggling with in life. The best way to restart yourself is to really separate yourself, and some people are on a spiritual journey. For me, I had an awakening one day and I had my visitation and it changed my life forever.
Definitely, bro. Definitely.
But Tyler
Uh, did,
Robinson, free the Patsy though. Free the Patsy, brother.
Absolutely. Yeah, we gotta. It's all about freeing Tyler, man. So that's what it's all
That
about.
kid did not
There's
pull
an
no
innocent
trigger, bro.
man. No, there's an innocent man being charged, and it's wrong. Honestly, he shouldn't even be sitting in jail right now. They should have released him immediately with all the evidence we found.
Right. Yeah, there's so much evidence. I mean, it's see, yesterday I was like trying to pick apart, somebody made a comment in one of my comments and they said yesterday and this week is more so preparing what they want to present in trial for his case, like stuff that's like solid evidence. And I would say some of the stuff that the attorney was doing was probably good because if you remember, they were saying like, this stuff could be AI generated, and why are we going to use this in trial when this kid is fighting for the death penalty? So we want authentic video footage, not stuff that's been edited on the internet. And I understand that concept because there is a lot of videos that have been floating around that have been edited. And
And like for example, like one of the big things where this is important is the footage, the turning point footage, that was given to them by Terrell Farnsworth.
right.
Because we know for a fact that footage that Terrell Farnsworth, the back camera footage that he showed Candace Owens, that we've all seen now, that was
Right.
edited. They used, we were able to find out, I forget the name of the software, but he used this, he used the software to edit that footage and to crop it down. And also, there's software they use, you can take specific pixels out. So if there was something in there they didn't want you to see, he was able to actually go in and remove that without, right down to the pixel.
Okay, so
Um,
let me give you guys a better understanding of what a murder scene investigation looks like, right? So there was a situation back in the day where there was a murder at a bar, and there was an altercation that happened, a shooting happened in the bar, somebody was murdered, cops showed up, right? And any person that was still on scene that had seen the murder happen, or any video footage, anybody's phone, anything, everything was taken into evidence. Okay, the camera footage from the bar, there was that. Listen, if you take out a SIM card at a murder scene from a camera, that's tampering with the police investigation. Terrell Farnsworth should have went to jail that day for taking that SIM card out of that camera. And there was cops all over. Remember the cops that were canvassing the scene, bro, that were walking through like the little steps of the right above where Charlie was at, and they were canvassing for things. Terrell Farnsworth should have never had that SIM card. The cops should have been the first ones with every bit of piece of audio, video evidence in there. That should have been completely taped off. Whether they were TPUSA or not, everything in that scene was evidence. Terrell
Absolutely.
Farnsworth should have went to jail. He tampered with the police investigation. That was sketchy in itself. Period. Terrell Farnsworth's done all kinds of weird stuff that day and after, but that specific thing right there, if I would have did that, if I would have took a piece of the SIM card out of a camera on a murder scene, I would have went to jail. You would have went to jail.
Oh, absolutely, 100%. It was tampering with evidence. It was also, contaminating the crime scene because he went through trampling all over the crime scene. He picked up the chairs, used the chair, stood on the chair that Charlie was killed on to take the thing out, and then, like I said, taking it out. That right there is destruction of
That's crazy.
evidence, tampering with evidence. Contaminated the crime scene, all these things. He should have been charged with all that stuff. He was not charged with any of it. On top of that, the things we find out later about him, about his connections to the Mormon Mafia, and that his stepfather actually has Thunderbird Electronics, owns Thunderbird Electronics, which
Right.
makes the little it's like explosive, the little electronic explosive triggers or whatever.
Hmm.
his company makes them. So for we don't even know for sure, but his he could have been involved in the making of the explosive that they used to actually kill Charlie.
Yeah.
And then not
Do
only
you
that,
remember? Right. Go
but
ahead, bro.
but Tyler, I mean not Tyler, but Terrell Farnsworth's stepfather also what is part of Duncan Aviation. He used to be the vice president of Duncan Aviation as well, which is where those coincidentally, that's where those Egyptian jets were that day on the tarmac in Provo.
All right. Oh no, don't talk about the airplanes, man. It throws the internet for a loop, bro. You talk about those planes.
Oh, I know. They went wild over that, man. I've seen it. They've done it a lot worse since then, but that's the first time that I've seen such a massive, PR campaign to try to silence one specific topic.
Right. Yeah.
It was
Yeah,
crazy, bro.
yeah, there was all kinds of activity. I took a couple of months off of like the Charlie Kirk investigation. I seen a lot of character flaws in investigators, like people that were starting to look more like diversion agents trying to throw off the investigation of Charlie Kirk, and people with, certain ties to intelligence agencies and the military and stuff. And I'm like, you know what? I'm going to take a little step back and kind of see what's going on from the outside, see who's who and what is what. And there is a lot of disturbing deep military industrial complex ties and a lot of individuals even within TPUSA. There's, this is what people don't understand. TPUSA was not only created as, a Christian conservative movement, but it was created as an asset for the military industrial complex too, because if you think of it, the pro talking point of conservatism in the political realm, a lot of it is pro neocon, bro. And the foundation of TPUSA and what it was created on was like what the pro Israel narrative, right? So they've been pushing this for a long period of time now, and really TPUSA was a military industrial complex asset,
It
and that's just my
absolutely.
opinion.
No,
So
it's the truth. It's not opinion. It's the truth, brother. And
yeah,
they've actually Turning Point from day one. A lot of people don't realize it, but even more so now. But from day one, Turning Point has always been one, a surveillance operation, and two, it's been a propaganda operation, because that's what they want to target, the youth. They know that the youth is the future. The youth are the ones that they need
right,
to corrupt their minds early
right,
and get them fed the force feed them the propaganda.
right,
And that's what Turning Point was made for, and that's what they use it for.
right. Get the vote of the younger generation and have them on this pro neocon, pro Israel narrative. And I think there's been a great awakening in the past couple of years, ever since Charlie's assassination, the Epstein files have come out in the past year. There's been an awakening, and there's all kinds of theories surrounding the Charlie Kirk assassination, whether what we seen was a squib, whether it was a staged assassination. I can kind of see some theories on that, on how that could look. But you know, um, Charlie Kirk went against the program. And, when you think you're bigger than the program, which is ultimately the people who put the money in his pocket and in TPUSA, and he went completely against what his talking points were supposed to be, there were many reasons to silence Charlie. I mean, he was exposing the Epstein class. He was exposing the genocide going on in Israel. Those are not the talking points that his donors wanted him to be on, and he didn't
He was
stop.
against the war in Iran.
Right.
That's another big one. Yep,
Yep. So,
definitely.
I mean, there was many reasons to shut him up, and in a sense too, I've looked at it like You know, I think Charlie woke up to the money that he was taking and to into what they built TPUSA to be. And I think when we started to see Charlie Kirk speak out against these things, I think it was a form of his repentance. Like he was going to let his last days on earth be speaking the truth of what was going on, regardless of the outcome. He knew they were going to kill him for doing what he did. You don't just funnel hundreds of millions of dollars a year into an organization, kind of like Miriam Adelson, what she did with Trump, and we not expect for them to do what their donors want them to do. You know, when you take that kind of money, you accept it, there's no really turning back from that point. You're either with the program or you're going to get snuffed, and that's just how it works in this world, unfortunately. There is no repentance amongst thieves and murderers. It's like they're getting ready, huh? You're on mute.
Yeah, I agree, brother. The live stream just went up too, so that's good. That means we should be starting soon. We're about 6 minutes away. I prepared a monologue, so let me go ahead and read this monologue real quick, and then we'll get started.
Go for it.
Let me mute the. Oh, I already got the music muted. Okay, we're good. All right. Take a drink.
In a few, I'm gonna have to cut my camera for a minute. I just got to run my little one to a birthday party across the street, drop her off, and I'll be back. But I'll be on the live
Okay.
still. I'll be on. I'll just have my camera off.
Okay, you're fine. All right. So yesterday, the Tyler Robinson show trial officially began in Provo, Utah. And if day one was any indication, today is going to be more of the same. A carefully controlled performance rather than a legitimate search for truth. We're watching evidence like text message confessions get entered into the record, even though Tyler Robinson's defense team has never been allowed to properly examine those messages to determine if they were doctored or who actually sent them. The FBI and ATF still haven't been forced to turn over key evidence despite repeated discovery requests because the judge ruled it wasn't necessary at this stage of the process. Key witness testimony from Lance Twiggs is expected to be played, but once again, the defense will not be allowed to cross-examine him because the judge has decided it's not necessary right now. This is what a show trial looks like. What's especially troubling is that Robinson's own defense team has spent months trying to block the public from seeing the full evidence in this case. They've fought to keep cameras out of the courtroom. They've tried to close portions of the hearing, and they're working now to limit what the American people are even allowed to review, are allowed to review. That is how you fight. That is not how you fight for an innocent man. That is how you protect a broken system that fears real transparency. The judge has also shown a clear pattern of allowing evidence into this hearing that cannot be properly authenticated at this stage. Unvetted text messages, video statements without cross-examination, and materials that the defense hadn't been given an opportunity to challenge. This isn't justice being served. It's a narrative being protected. As Candace Owens pointed out yesterday, the entire process feels designed to lock in a story before the real trial even begins. We're watching emotion and theater take priority over due process. You can already see the paid influencers and media figures lining up to tell you that this unvetted evidence is overwhelming and undeniable. Sit back and watch the predictable show. The real trial, the one where both sides can actually test the evidence, where witnesses can be properly cross-examined, and where the defense is forced to fight instead of hide, that trial still hasn't started. Charlie's army is growing, and no matter how many procedural games they play, the truth will always prevail. And that is my statement for today, guys, leading us into day 2.
And I seen all kinds of Fed slop going on last night.
Oh, big time, man. And I tell you what, Andrew Colbert crashed out so hard yesterday. I mean,
he's tarnishing Charlie's
legacy big time, man.
Yep. They're looking all kinds of suspect right now.
Yep. Oh, before we start, just want to remind everybody too, obviously this channel is not monetized on YouTube, so there's no way to leave like an actual super chat, but we do have a buy me a coffee. We do have the buy me a coffee set up. So if you want to donate to the stream, you can scan the QR code right down there at the bottom left-hand corner of the screen, scan that QR code. And basically that you could send us a super chat that way. Anybody who donates to our Buy Me the Coffee link and leaves a comment, we will read your comment on air like a super chat during the breaks, when we get lunch, whatever. We won't read them during the actual trial, but when they stop for a break or when they stop for lunch, that's when we will read everybody's comments. So if you want to donate to the stream, you want to get your comment read, right there's the way to do it.
Yep. Support your free voices. You know, some of us have been battling social media demonetization, and you know, it's you know, we know who controls social media and who controls the media. So, you know, certain voices out there, you know, show your support any way that you possibly can, whether it's $1, $2, it doesn't matter. Everything helps.
Absolutely. And also, even if you can't donate financially, make sure, like if you're on X, repost the stream out. There is 30,000 of you watching already, which is tremendous. But I want all you guys, please repost the stream on X. If you're on YouTube, make sure that you like the stream, leave a comment. Yep. You know, you could even share it to other social media like your Instagram or Facebook or whatever. Share the stream out. We need more people to see it. It's important for people to actually get the real story and watch for themselves, as opposed to get the, you know, the Fed slop version that, you know, the mainstream media is going to feed these people.
Exactly. And we're going to give you guys the raw and uncut. We've been investigating this now since it happened, day one.
Exactly. Yep.
Especially Project Constitution there. He's TPUSA's favorite non-paid employee.
Honestly, they should put me on the payroll at this point. It's crazy. Yeah, they love me, man. They definitely love me.
I seen Erica Kirk's comment on one of your comments, and I'm like, oh man, he's just stirring up on the hornet's nest.
Yeah, that comment was wild. Go dusted Dorito fingers off your whatever. It was wild. All right, we're on, guys.
Can you hear the audio on that? I can't.
I can, yes. Can everybody else hear the audio?
Let us know in the chat if you guys can hear it.
Is there really no sound, guys? No sound? Okay, all right, hold on.
Courtroom protocol.
There we go.
Maintain security and decorum.
Okay, cool. There. Sorry, I had it muted. My bad.
The courtroom during proceedings will not be permitted to re-enter until recess. All counsel are expected to take reasonable measures to safeguard confidential communication. Such measures.
All right, good. You guys can hear it now. Awesome.
Protections on electronic. All right, is it the audio working?
No, it's them now.
All right.
Damn, I could have just blamed it on them the whole time.
There goes Mossad again.
Yep.
And just let me know when it appears to be working. And while we're waiting, if you have any water bottles or such, feel free to drink them. It is a little bit warm in here today, so I will be drinking from my water, so don't hesitate to use that if you need to.
Hey, I can, we did our morning. Okay. She's watching me? My biggest fans, my family. Hi, go, 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 go. Hi, go, 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 go. What?
And again, if you guys want to leave a super chat or buy me a coffee, you can just scan the QR code down the bottom left of the screen. You could donate, leave a comment, and we will read your comments out when we get a break.
Can you send them a link to the where this is being streamed so they have something to look at? I see. All right. All right, let's go ahead and continue. And let me repeat it just because the audio may have cut out. All counsel are expected to take reasonable measures to safeguard confidential communication. Such measures may include the use of screen protections on electronic devices and care to avoid the inadvertent capture of privileged or private discussions by recording equipment or by those present in the courtroom. Second, the court will address the camera operator and still photographer, and I will invite you to come forward.
And please repost this stream if you're on X.
All right, the purpose of this is to ensure clarity regarding the expectations governing today's proceedings. Could you both state your name for the record?
Yes, Trent Nelson with the Salt Lake Tribune as the pool still photographer.
Thank you,
John
Christy.
Wilson from KSL Television, video photographer.
Good morning to you both. Have you reviewed the court's standing decorum order?
Yes, Your Honor.
Yes.
Do you understand the requirements set forth in that order as they apply to your activities today?
Yes.
Yes.
Do you require
Probably
additional
not.
time to
Expect
review
much of
order
the
or to
same.
adjust equipment to ensure compliance?
No.
You know, Kathy
Do you
Nestor, the
anticipate any
defense is
difficulty
going to
complying with the order or today or with the court's instructions?
try to block
No.
all the evidence from being seen again.
All right. Well, thank you. I appreciate your
Thank you.
cooperation today.
Yeah, I mean, we want to see what they're going to be using, you know, in trial against Tyler Robinson.
As we begin this morning, the court wishes to acknowledge the importance of the safety, dignity, and well-being of all those who are present or who may be present during these proceedings, including the parties, counsel, witnesses, court staff, and members of the public. The court is also mindful of its solemn obligation to protect and uphold the constitutional rights of both Mr. Robinson and Ms. Kirk. In furtherance of those important interests, all persons attending these proceedings are reminded that
Screw
portable
Miss
electronic
Kirk. She's
devices
not a
are
victim.
not permitted
And
in
by the way, you
courtroom
mean
or on
Miss
the fourth
Fransby,
floor.
not Miss Kirk.
The
She
court
doesn't get
also
to call
expects
herself
every
Kirk
person in
anymore.
attendance will be treated with the dignity and respect to which they are entitled. Consistent with the court's standing decorum order, all spectators shall remain quiet, civil, and orderly during all times. Spectators shall not engage in conduct that is distracting, disruptive, provocative, disrespectful, uncivil, or threatening in any manner. Spectators shall not make audible comments of any kind, shall not shake or nod their heads, and shall not make gestures or other visible reactions during today's hearing. Spectators shall also not wear or display pins, buttons,
Man,
signs,
this judge is a
clothing,
tyrant. A lot of
photographs, or
rolls.
other
What the
items
hell?
expressing
For
support
real.
Don't breathe.
or opposing to any person connected with this case, or expressing any position concerning the status of this case as a capital offense. The court appreciates the cooperation of all present in maintaining a courtroom environment that is safe, respectful, orderly, and faithful to the rights and dignity of every person involved. Turning now to counsel. Before we begin, I wish to acknowledge the professionalism, civility, and competence demonstrated by counsel for both the defense and prosecution during yesterday's proceedings. It is evident to the court that each of you approach this matter with seriousness, preparation, and a deep commitment to your respected responsibilities. The court appreciates the care which you have taken in advocating for your positions and the respectful manner in which you have done so. Thank you. Do either party require the benefit of the record before we proceed?
The state does, Your Honor. Mr. McBride will address the court.
All right, and just as a reminder, the microphones at council table are turned off to prevent
Yeah, I
the
know. A
inadvertent
lot of
capture any
rules.
communication. So if you would like to come forward, thank you. And turning to Mr. McBride.
Thank you, Your Honor. Before this hearing, the defense moved
It's definitely a ride at that, too.
find Article 1, Section 12 of the Utah Constitution, Rule 7B, and Rule 1102 unconstitutional as it relates to the admissibility of hearsay and reliable hearsay at this hearing. The issue was extensively briefed and argued. The court denied the defense motion to exclude the use of reliable hearsay at the preliminary hearing. That ruling is at docket number 631. In addition, defense counsel filed a standing objection on July 3rd. That's docket 678. The standing objection reasserted the arguments made in defendant's previous motion. Defendant continues to make these same objections throughout the testimony of each witness. I believe both the state and the court and everyone present knows that the defense objects to the use of hearsay or reliable hearsay at this hearing. On the point of preserving the objection, that has been done. Defense counsel has filed their motion, they filed their standing objection. Throughout the proceeding, they have continued to make objections. At this point, further objection is unnecessary to preserve the record and causes undue and unnecessary delay. This is needless delay, and we'd ask the court to acknowledge and the record to reflect the standing objection. And we also ask the court to give an instruction that continuing objections on this ground are unnecessary. Of course, if it relates to some other ground or is some item that's particular to a particular statement, that objection may be appropriate. But at this point, we feel that the repeated objections that have been made and already been ruled upon are unnecessary and cause undue delay.
Thank you, Mr. McBride. To defense.
Good morning, Your Honor. Michael Burt for
Good
Mr.
morning.
Robinson. We have no objection to that procedure as long as the court makes a ruling that the objections are preserved. We do think it would expedite matters if we didn't have to repeat the standing objection. There may be particular objections that are not covered by the standing objection we've made, and so we ask permission to be allowed to make those objections as needed.
Thank you, Mr. Burt. Thank you to both sides. I appreciate the presentation and your
Yeah,
argument about this.
I am not
The court takes no
monetized on
position in
YouTube.
regards to whether the
If you wanna-
objection is
if you
made
wanna
again and
donate,
again or not.
Scan the
I
QR
leave that
code
to
in
the
the bottom
parties.
left corner of
I
the
recognize the
screen.
need
You
to
can go to the
expedite
Buy
this,
Me a
and if both
Coffee.
sides stipulate, I will adopt
You can
the
go to the Buy
request
Me a
that
Coffee.
the
It'll let
standing
you
objection
donate
as it
and leave a
relates to
comment, and we'll read
1102,
it out like a super
Article 1,
chat.
Section 12 of the Utah Constitution, and all relevant authorities that have been cited have been noted and the
Where it
standing
says
objection
send
by
a super
defense
chat
is
scan
in
here over
place.
there.
However, if defense feels the need to do that in order to protect the constitutional rights of Mr. Robinson, the court will not prevent that, nor stand in its way. This court is not, is acting in the role of a magistrate and will allow the parties to move forward as necessary. But as noted, I will make that note that the standing objection has been noted for all of the yesterday's proceedings and will be in place throughout the rest of the preliminary hearing. Anything further or any need for the record, given the court's statement?
Not from the state.
No, Your Honor.
All right, thank you. All right, the court acknowledges that the exclusionary rule is in effect. At this time, any witness who is subject to exclusion should be excused from the courtroom. And again, I will leave it to the parties to monitor the courtroom to ensure that if a witness has come in and they shouldn't be, that they are redirected. I
Yeah,
invite Agent Holt
basically.
to return to the stand
That's exactly what happened.
to resume direct examination. And Agent Holt, you are still under oath. Mr. Sturgill?
Thank you, Judge.
And before we begin, is there a way to dim these lights just a
And we
tad
left
like we did
off with
yesterday?
Agent Holt yesterday, giving testimony, and today we're going to pick right back up with him, and he's going to finish his
Thank you.
testimony.
All right, as of yesterday, there is also a water
Yeah,
bottle
he's
to
over
your
there
left.
saying every video
And
he's
if
seen
you
of
wouldn't mind just
Tyler
making sure
Robinson
that
was Tyler
microphone is
Robinson.
directly
Even a
in front
car
of you. We
driving
wanna make
by
sure
on the
that the
camera
record
footage.
picks
That
up,
was Tyler
your
Robinson.
testimony today.
Exactly, and we
Sturgill,
showed that
your
video.
witness.
You
Thank you,
can't make out shit. You can't make out
Agent
whether it's Tyler
Holt,
Robinson. You can't
we're
make
gonna
out
return
even what
to
kind of car it is.
What has been marked State's Exhibit 12.1. There was reference to it yesterday. And I'd like to ask you again, have you reviewed that exhibit? And if you wouldn't mind, just briefly remind us what that exhibit consists of.
The exhibit is a compilation or he's running a summary of videos from UVU campus security footage.
Turn his mic on, you morons.
And that's what I hear. So let's go ahead and
Yeah.
stop. I'm not hearing it, so I'm going to have you repeat. Let's test it. Go ahead.
Check.
All right, I believe that. Mr. Sturgill, if you wouldn't mind restarting.
I
so
can
the-
do that, Judge.
Thank you.
Maybe bring the mic from the base a little bit closer to you. I don't know if that'll help. All right, let's go ahead and go back
Put
to
it in your
what's
mouth,
been marked as
you
State's Exhibit
filthy
12.1.
animal.
I'd asked you a moment ago if you'd reviewed that exhibit.
Yes, I have.
Okay. And would you just remind us what that exhibit consists of?
It's a compilation of videos that were part of the overall footage that was obtained from the Utah Valley University as part of the investigation.
And does that compilation video, from your point of view, capture Mr. Robinson arriving to and visiting the UVU campus
It does, yes.
on September 10th through the 11th, 2025?
Correct.
Okay. And again, I asked you this question yesterday, but did you prepare that video compilation?
I did not.
Okay. Do you know who did?
The Utah County Attorney's Office.
Does that video, and I'm referring to 12.1 exhibit, State's Exhibit 12.1, does it include all of the footage collected by the SBI from UVU?
It does not, no.
Does that video, again, 12.1, include all of the footage you collected from UVU that captures who you believe is Mr. Robinson walking around campus?
Not all of the footage, no.
You reviewed this compilation with Mr. Olson, correct?
Correct.
And in its entirety.
Yes.
And he actually, and then you collected an 1102 statement from him.
I did, yes.
And I believe that has actually been admitted into the evidence as State's Exhibit 12.3. Did Mr. Olson refer to that exhibit 12.1 in his statement?
He did, yes.
Okay. 12.3. I'm going to put on your monitor State's Exhibit 12.3. And I asked that you scroll down towards the very bottom. And I would ask that you read from the statement specifically what Mr. Olson said about State's Exhibit 12.1. And I want to narrow your focus. So I'm going to draw your attention about 3/4 down the page. There's a sentence that begins on the left margin, "I have reviewed." Do you see that?
I do, yes.
Okay, would you please read that sentence?
I have reviewed States Exhibit 12.1, and the recordings are true and accurate, including timestamps, dates, and camera labels. The only changes are some zooms and red highlights, which were not part of the original recording.
Yeah.
Would
Have
like me to-
you, I'm sorry?
Sorry, I didn't know if you wanted me to continue. Or...
No, that's good enough. Have you had a chance, well, you reviewed the raw footage yourself, is that correct?
Correct.
And does that comport with your viewpoint of that exhibit?
It does, yes.
Have you had a chance to review what's been marked as States Exhibit 12.4?
Yes,
Okay, and when did you review that exhibit?
this morning
And who did you review that exhibit with?
with Kimberly Durfler.
Okay, was there any conversation about that exhibit?
No, I was just shown the video.
Nobody asked you questions or suggested anything to you?
They did not know.
Did you prepare that exhibit?
I did not.
Do you know who did?
The Utah County Attorney's Office.
All right. And I'm referring specifically to what's been marked States Exhibit 12.4. What is depicted in that video?
That video is, again, a compilation of videos from the overall footage that was obtained from Utah Valley University for September 11th and September 12th.
And how does it compare to what's been marked as States Exhibit 12.1?
It appears to be the same footage. However, on this particular version, there were no circles or blurs that had been made to the video.
How about zooming in and zooming out?
No, there was no zooming or zooming out.
Does it appear to be identical to the raw footage that you've seen that portrays this particular part of the UVU surveillance video?
It does, yes.
Judge, the state would move to admit what's been marked States Exhibit 12.4.
Your Honor, we just object to the publication of this for all the reasons we argued yesterday. We think this video is going to play a big role in the trial, and to allow the public to see it now would seriously impact our ability to get a fair trial, and we're asking the court not to publish it.
This is such
Thank you.
bullshit.
And Mr. Sturgeon, and to all counsel.
We need to
as it will
see
apply
all
to
this
counsel,
evidence,
when you are
especially the
moving a piece of
videos.
evidence, it's the three parts, whether admissibility into the record,
Right.
to be published in the
So,
courroom. to be
Basically, right
published
now
in
during the
courtroom and
prelims,
captured
they're
by
not
the
going to show
media.
this, but
So,
during
Mr.
the trial,
Sturgill,
they will
As
show
it's
it.
your request, what are you requesting?
First of all,
I don't
clearly
know,
have
man.
to admit the exhibit. I'd ask, and Judge, the presumption is that this is a.
It doesn't sound like they're going to let us see it at all. But
So
I
the
she
state's position
said
is
it's
that
going to
it should be
show a
published here in the
big.
courtroom, and it should
It's
be
going to play a
published in
big
such
part
way
in the
that
trial, but she didn't
media
say the
can
public is going to get to
capture
see
it
it.
on video.
All right.
Do you know
You may,
if
if
your
you
on the ground
approach the
reporter
lectern,
made it in
please.
today?
And state your name.
I'm David
I
Ryman.
do
represent
not.
the news
I
media.
messaged
didn't make an
her. She
appearance
hasn't
because
messaged
the
me
news media
back yet.
technically
So
aren't
as
parties,
soon as
but
I
you
get
know,
a
I do have the right to be heard on issues like this.
update
and
from
I've
her, I'll
tried
let
to
you
keep my
guys
finger on
know.
them, but since this is the
Hopefully she
first one
did. She
coming
said
up
she was
today, I
going
thought it might
there
be helpful
at
to just
5
address it.
a.m. to try to get in
Um,
today.
There is a presumption, not just that it be published in the courtroom, as we talked about yesterday, because the participants or the spectators in the courtroom have a.
And by the
right
way,
to
that's
know
Billy
what is
Webb. If you
viewing
make
so
sure you
that they
guys
can
are following
understand how
Billy
you're
Webb
being
on
considered.
X,
This seems like a very
3
important piece
Bs,
of
Billy
evidence. It
Webb,
doesn't seem like there
BBB.
is a basis in the
Excellent
courtroom
investigative
today
journalist,
from
good friend of
understanding
mine.
why it's being introduced. It is not like the videos yesterday, and my understanding at least is, and you can correct me if I'm wrong, but we didn't object to the videos that weren't published yesterday that were graphic. We didn't object to the non-publication of the autopsy report. The argument here that Ms. Nestor just made is this seems really relevant, and that is precisely why it needs to be public. With the last thing I'll address is just EMC. There is a presumption, that's a rule presumption, not a constitutional one, that EMC is allowed. And I think that for all of the reasons that we've briefed this for your honor several different ways, there needs to be a really good reason why. You know, if it's being published in a public proceeding in the courtroom, it should not also be, and it should not also be allowed to be published to the media. So,
Thank you.
thank you.
Mr. Sturgill, did you wish to respond?
That was that media
Perhaps
attorney, right?
give a little bit more detail on what
You know what? This
video
is
purports to show.
yeah. This is the compilation video where they have images that clearly show
Would you
Tyler,
prefer that
and then
judge or
blurry
the
ones
witness?
that they're
I'll
trying to
defer to
make
you.
out,
Okay.
pretend they're Tyler,
Well,
and they're
well,
trying
first
to
of
put them
take
all
one step
together
back.
to
Let-
fool
let me
people, to
ask you,
psyop people. So yeah, I
you
don't.
have misheard,
I'm actually.
but let's
This
just be
one I don't think
clear
should be
about this
shown to the
video,
public, because
compilation video.
if
It
they show it to
includes
the
video
public,
surveillance from
all the
UV
media is
cameras
going to run with it and be like,
witness.
"We have Tyler
September
on video.
10th,
See,
2025
see,
into the morning
see."
of the 11th, 2025.
And that's not going to be the case.
And if you wouldn't mind just describing in a bit more detail what this compilation includes.
The compilation shows the movements of the individual believed to be Mr. Robinson on Utah Valley University campus, arriving and leaving in a vehicle.
Yeah,
arriving and
blurry
leaving
ass
on foot,
footage if they
and
can't
then
tell for
returning
sure it's
and
him.
leaving, and then attempting to gain access again in a vehicle. And
And they're going to
his
say
movements
they're going to
throughout the
say it's
day,
Tyler.
are included in the videos also.
Is there any footage of the alleged shooting?
There is not, Judge.
Okay, I just want to clarify that. Ms. Nestor, given that additional information and anything further from defense?
Mr. Burt's he's the one who's been litigating all of the First Amendment issues, if he could address Mr. Ryman's argument.
Yes, Mr. Burt, if you wouldn't mind coming forward.
Judge, I wanted to clarify one argument that was made by counsel for the media yesterday, and that was the rules, the rule 4-202.02 does not apply to the situation we're in right now, and that is wrong. The rule says that this rule applies to the judicial branch, and 4-202.02J says the judge may regulate or deny access to exhibits to ensure a fair trial. So I think that rule does apply to our situation, and the Supreme Court in the Algier, ALLGIER case, 258 Pacific 3rd, 589, applied the rule in the context of an evidentiary exhibit. And I know the court has not mentioned, since counsel made that argument, this particular rule, but I think it does apply here. And also applicable is the Supreme Court's decision in the Kearns case, which we talked about when we argued the motion for denying access to the cameras. And that case, Kearns versus Tribune Corporation, 685 Pacific 2nd, 515, says that the standard the court ought to apply in determining whether an exhibit at a preliminary hearing should be sealed is one of a, quote, realistic likelihood of prejudice. And we rely on the
And this is a
evidentiary showing we've
massive
made in
prejudice.
connection with our
This
motion
whole
to
video
exclude
is
cameras,
specifically
that there is a
intended
realistic
to
likelihood
try to
of
fool the public
prejudice
into
in this
believing that's
way.
Tyler Robinson.
The court knows and has access to the media coverage up to the time when we
I guarantee
litigated
you
the
it's
motion
too blurry
concerning, closing this hearing to the
to
cameras. And the court
perfectly
knows that one
identify him.
feature of the media coverage has been a very
There's two things that aren't
pro-prosecution
free in
bias
America.
of
That's
every story
elections.
that has
Fair.
been published.
There's two
on
things
this
that aren't
account.
fair in America.
Court also knows from that
Elections and a
coverage
courtroom.
that information is being
Very
widely
true.
disseminated, and you have found in connection with the shackling issue that the publicity in this case is likely to reach jurors who will be part of our jury pool. And we've also submitted to the court a public opinion survey, which shows that the prejudicial publicity that the media has already generated in this case has affected the jury pool. And so those are all factors the court can point to and rely on and conclude that publication of this particular exhibit should not be allowed because there is a realistic likelihood of prejudice.
If the
to
judge
Mr.
allows this
Robinson's
video
right to a
in,
fair trial.
this will
So under
tell
that
you for
standard,
sure
and under the
that
rule,
he
the
is
court ought to
corrupt,
deny
that he's
publication.
working
Thank you,
for the
Mr. Burt.
deep
Thank you.
state.
Any final argument from the parties before the court issues its ruling?
Your Honor, can I be heard on that briefly?
Yes, you may.
Thank you, Your Honor. David Ryman. I just wanted to clarify. I don't know that Mr. Burt and I necessarily disagree about what he said about the rule. What we were talking about yesterday was something different. That is the portion of the rule that classifies records that are in the court file. You know, it's not the same as what happens in a public hearing. And Mr. Burt referenced the portion of the rule that essentially just tracks the constitutional standard, which of course, you know, controls here as to whether in this public proceeding, it can be closed in any way, and non-publication of exhibits as a form of closure. So I don't necessarily disagree. I would just underscore a lot of what Mr. Burt just said has been briefed ad nauseum at this point. Their position that publicity is incompatible with a fair trial. The Allgaier case he mentioned, you know, I know that case. I litigated that case. It involved a confession that the court found public because you have so many other tools to seat a fair and impartial jury. And we have cited that case repeatedly, and so has Your Honor, I think, recognized it in your ruling, saying pretrial publicity can coexist with the defendant's right to a fair trial. So the last thing I'll say is just that the constitutional standard that I think we're all agreeing applies here is weighty and difficult to overcome. And it is never satisfied, as we've explained, by just generalized assertions that there's a lot of publicity out there. It's got to be something really specific, and they just haven't made that showing. And I certainly don't think that a video that apparently just shows the defendant walking around the UVU campus qualifies.
Thank you.
Because it's a blurry video
Anything further?
that hasn't been authenticated, and you're not even going to be able to tell whether it's really him or not because we've seen the surveillance footage from UVU. It looks like it's filmed on a potato. You can't make shit out.
There's no video of that. There is video, however, and you've heard testimony related to this, where the shooter goes to the top of the Low-C building.
Yeah, I saw that, by the way.
Building, low crawls, and then leaves after what we assume is the shot being fired. That's as close as it gets. I don't know if that makes a difference, Judge. I just wanted to make the record clear, and I want to be crystal clear with Your Honor.
Thank you. I appreciate that.
So they're claiming the video they want to show shows him the missing piece that we have, which shows him low crawl out to the Low-C building ledge and then run away.
To Utah. Well, let me pull this up.
We know that's the same footage that we saw before, and we know that that's not clear. There's no way to tell that that's really Tyler Robinson.
202.02.
I don't think it is Tyler Robinson.
I go down to, well, first it says statement of the rule. 1, presumption of public court records. Court records are public unless otherwise classified by this rule. 2, public court records include but are not limited to, and I'm going to go down to 2J, exhibits, but the judge may regulate or deny access to ensure the integrity of the exhibit, a fair trial, or interests favoring closure. And the court recognizes the importance of the constitutional rights of Mr. Robinson being upheld and protected. At the same time, the court also recognizes the importance of transparency and a proper balance to ensure that the constitutional rights of all parties are upheld. As it relates to this exhibit, I believe it's 12.4.
12.4, yes.
Based off the representation of what is in that, the court differentiates this exhibit from the exhibits from yesterday, namely Exhibit 7.
So he's going to allow it.
8 and Exhibit
Completely
9,
ridiculous.
as those are different in nature, and those go to issues relating to Utah Constitution, Article 1, Section 28, as it relates to the Declaration of the Rights of Crime Victims. And the court also recognizes Utah Rule of Evidence 1102, as that is the foundation that's being laid for the admission of this exhibit. Having taken in consideration all factors, the court rules that Exhibit 12.4 is
I think so
admitted into
too.
evidence and shall be played in the courtroom and may be broadcast by the media.
And you can see that by all of the
You can
people
proceed.
that were captured on camera that day
Agent
wearing
Hall,
the
before
exact same
we actually
maroon
watch,
t-shirt as Tyler
State's Exhibit
Robinson.
12.4, I have just a few questions.
Absolutely.
Yesterday, you testified at the very beginning of your
And
investigation.
did you hear that
that
they
you
said that
focused
they're
on the
going to show the
video that
video of
captured the
him
shooter on
supposedly
top of the Losi
belly
building. Is that
crawling
correct?
out to the
Yes.
corner of the
I believe you
Lucy
also
building and taking a
testified
shot?
that you began by working your way, and this
I
is
would
what I
love to
remember
see
you
that
saying,
video
so correct me if
footage.
I'm wrong. But you in
Well, they
essence
say they're going to
testified
show
that
it
you
today.
began with that
But the
video
problem
and you
is,
started working your way backwards
we've
and
seen the
forward
rest
with
of that
the
footage.
surveillance
It's so
video
blurry.
in an effort to
We
trace
know
the
it
shooter's
doesn't.
steps
There's
on
no
campus.
way
Is
to
that right?
tell
Correct.
who it is.
Would you mind
Yeah, you can't
explaining
see.
in a little bit more detail
We
what
should
you meant by
even
that?
on the break
Try and
during
keep going
lunch
backward
when they
on
have
that
their
video.
lunch, we should
Yeah,
run that
we had
video
a
on here and
we had a
slow it down
known
when he's running off the roof just to
when
show
the
the
shooting
people
occurred,
that he had no rifle on
and as
him.
the officer testified, there was a video of an
Yeah,
individual on the
okay, for
roof at the
sure.
time of the shooting. And so the philosophy that we applied was to take what we knew and then work that forward through the timeline and backwards through the timeline to try and establish where the individual had gone from the rooftop or how the individual had come to be on the rooftop.
And did that, for lack of a better term, did that bear fruit?
It did,
you
yes.
actually see from, at least in part, where he came from and where that shooter went?
Yes, more so where he came from. It was very limited after the fact.
You testified yesterday that in reference, I believe, to what's marked State's Exhibit 21, that you believe Mr. Robinson visited campus at least 4 times on the 10th and the 11th.
Correct.
And I think you reaffirmed that today. Did you do the same attempt, that is, to track Mr. Robinson through UVU surveillance video during each of those 4 visits?
Yes.
Or those other 3 visits, I guess.
Yes, on each occasion, we attempted to follow the movements of the individual throughout campus.
And did you in fact see Mr. Robinson on campus in surveillance video that is not included in State's Exhibit 12.4?
Yes, there is additional footage of him on campus, yes.
Okay. I'm going to have displayed on your monitor. What you're going to see is a paused or a still.
The reason I don't want, I'm not saying I don't want to see it, but the reason I don't want it shown
You see that now?
today
Agent Hall?
is
I do,
because
yes.
it will
Okay.
prejudice
Do you
the
recognize
jury.
what's displayed on your
They're
monitor?
the media. They're going to eat that up.
Yes,
They're
it's
going to
footage
run with it
from,
and all claim that
the
that for
university that
sure
was
is
provided
Tyler
to us, particularly
Robinson
the parking
that fired the
structure.
shot.
Okay.
When there's
Does it
no
appear
way
to
to
be
tell who it
State's
is
Exhibit
because it's
12.4?
it's too blurry to
It
tell.
does, yes.
So I'm going to go ahead and I'm going to have this video run. And if you don't mind, as it's running, I'm probably going to be asking you some questions. And so this video has no audio. Is that right?
They
I know
don't.
there's no
That's the
audio on
problem.
cameras.
Okay. Let's go ahead and start the video.
Your Honor, it's just not up on the screen yet.
Oh.
Let's go ahead and put it on all screens. No, I appreciate it. Is so it is admitted and may be published to the screens. And just want to make sure it's on your.
Let's not
screen,
talk during
agents.
this so I
All
can
right.
record it and put it out on my
All right.
channel.
Mr. Sturgill, you may proceed.
Appreciate that, Judge. Thank you. Go ahead. Okay, what are we seeing here, Agent Hall?
That's the vehicle that is believed to belong to Mr. Robinson arriving in the parking garage on campus.
At what time in the morning? What time of the day?
It's approximately 8:30 in the morning on September 10th, 2025.
And what leads you to believe that this particular vehicle belongs to Mr. Robinson?
Information that was provided regards to driver's license and Department of Motor Vehicle records. The vehicle fits the description of a vehicle owned by Mr. Robinson.
Is there anything unique about that vehicle that stands out to you?
The shape of the vehicle is very distinct, but predominantly the wheels were very distinctive on this version of the vehicle.
Now what do we see?
The driver of the vehicle exits the vehicle and then walks on foot to exit the parking garage. It's the individual in the red T-shirt and the shorts and the shoes.
And do you believe you recognize who that person is?
Yes,
Who is that?
I believe that's Tyler Robinson.
All right, and where does he go from there?
He heads out of the parking garage on foot into the campus and actually goes to the quad area of the campus. At that time, he makes contact with some representatives from TPUSA.
By quad area?
Sorry, the amphitheater is what I previously referred it to.
So he goes up onto campus, visits the amphitheater area, the courtyard or quad.
Correct.
And then what do we see here now?
He returns on foot back to the same vehicle.
And what time is he returning back to the vehicle?
It's about 9:25 a.m.
And where is this parking structure located on campus?
It's just off of Campus Drive. It's a short walk from the amphitheater.
What do we see now?
That's the vehicle exiting with Mr. Robinson driving the vehicle.
Now what do we see?
This is Mr. Robinson returning to the campus on foot from the neighborhood to the northeast. You can see he's wearing the same clothing as in the previous video. And he's carrying a blue backpack.
Describe the clothing.
It's a maroon colored t-shirt with gray or olive colored shorts and then Converse shoes.
And what time did he return to campus?
Just after 10 a.m.
And does he leave the parking structure eventually?
He does, yes.
Okay. And during this visit, do you know where he goes after he leaves the parking structure?
Yes, we were able to track his movements on campus. He went to Chick-fil-A in the Sorensen building and purchased some food, sat and ate the food. Then,
And
I'm sorry,
Where did he purchase the food from?
Chick-fil-A in the Sorensen Center.
And where is that in relation to the amphitheater or the courtyard?
It's kind of on the northeast side of the amphitheater. It would be on the upper back edge of the amphitheater, furthest away from where the tent was that Mr. Koch was in.
And from there, where does he go?
From there, he moves across campus, out across Campus Drive into a wooded area on what would be kind of the northeast side of Campus Drive. Then returns back onto campus. We noticed at this point that he's no longer carrying the backpack that he was originally wearing. He moves through the Gunther building and the computer science building. And
goes where?
then, I'm sorry?
And then goes where?
Then goes across to the railing that gives access to the roof of the Losi building.
And from there?
From there, he comes back down the stairs and walks off campus from that point.
And about what time was that he left campus that second time? Do you know?
I believe it was approximately 11 a.m. or just after, if I recall. I could verify from my notes if you need an exact time.
Yeah, if you don't mind. That'll help you remember, refer to it. Don't read it out loud. Let me know when you've had a chance to look at that, would you?
Fed slap.
Were you able to refresh your memory as far as the time?
I was, yes.
And what time was it?
It was just prior to 11 a.m. when he walked off campus.
And before we go any further, the parking structure that he left initially, where is that parking structure in relation to the LDS Institute building?
I'm sorry, in relation to?
The LDS Institute building on campus?
I think it would be just to the north of the LDS Institute building, if I recall.
Do you recall whether it was adjacent to the LDS Institute?
Yes, it is.
Okay. All right. What do we see displayed here now? Go ahead.
This is a video of Mr. Robinson returning back to campus the same way that he did previously on foot.
And this takes just a moment. And why, well, let me ask you this. You believe this is Mr. Robinson returning to campus?
I do, yes.
Okay. And why do you believe it's Mr. Robinson?
The shoes are the same, and the images that we have are from my viewing and seeing Mr. Robinson on the video, it's the same person.
He's noticeably wearing different clothing.
He is wearing different clothing, and he also is walking with a gait or a limp in this video.
With a gait or what?
A limp.
Okay. Now what do we see?
So this is Mr. Robinson coming up the stairs of the parking structure. Again, he seems to be having issues walking.
And again, we're able to track, we're able to track Mr. Robinson when he leaves this parking structure?
Yes, we were able to.
Okay. So when he leaves the parking structure, where does he go?
He comes up around Campus Drive. As you can see on the video here, there is a cut through there north of the Losi building, and that's Mr. Robinson coming up the sidewalk. He has the noticeable gait or limp in his walk. And then he moves south across the front of the Losi building.
On the sidewalk?
Yes, correct.
Okay.
He would be the rear of the two individuals in this particular video.
So right now, if you were to break this picture into quadrants, where would he be?
He would be in the top left quadrant, walking to the left of the image.
Now what do we see?
This is an image looking across the parking lot to the Losi building, and Mr. Robinson is appearing on the exterior staircase, which gives access to the Losi building roof and the area where the railing was.
And again, let's break that image into quadrants. Where would he be located if you broke it into quadrants?
It's in the top right, and the individual can be seen moving under the notations that are on the video.
And what time is this?
It's just afternoon, about 12:15
On what day?
on September 10th, 2025.
What just happened, or what did we just see happen?
The individual actually kind of rolls over the railing onto the roof of the Losi building.
All right. Go ahead, sir.
And again, in the top left corner, the individual is now seen running across the rooftop of the Losi building to what would be the southwest corner of the building, crouching down and then crawling to the corner of the building.
Funny they didn't zoom that part in.
And
Where?
this is at what time?
Around 12:23. I think the timestamp on the video is 12:22.
And they're just going to claim it's Tyler Robinson,
On
even though
September 10th,
there's
yeah.
no way to tell.
2025.
So we're clear, this is the roof of the Losi building.
Correct.
Can you still see that individual?
Yes, you can, laying prone.
You believe this to be Mr. Robinson?
I'm sorry?
You believe this to be Mr. Robinson?
I do, yes.
And how long is he out there on the edge of the building?
Just until the reported shot was fired at 12:23.
How? I want to know how.
Individual then stands up and then moves
We're
across the
seeing
building
what
to
they're
the
seeing.
north.
Where
Is
is
that what we're
there
seeing
any
happening right
Tyler Robinson in
It
a
is,
prone
yes.
position taking a
And moved
shot?
behind the atrium area on the rooftop to the northeast corner where the white triangle is.
Do you see Mr. Robinson now?
I do, yes. He's just arriving at the corner of the building, almost the top center of the image.
What are we seeing now?
And Mr. Robinson lowering and jumping off of the roof of the Losi building onto the grass area, and then moving away towards Campus Drive. And he appears to be carrying some kind of an object in his hand at this time.
A jacket? A jacket?
So he's approaching,
Campus Drive.
and again, broken into quadrants. Where is he currently?
Be in the top right quadrant.
And the time?
It's 12:24 and 42 on the timestamp.
What do we see now?
He then crosses Campus Drive and drops down into the wooded area on the far side of Campus Drive.
And that is located in what part of the video? What quadrant?
It would have been just off center on the top left side.
What do we see now?
This is the intersection of Campus Drive and 800 South. There's a vehicle attempting to turn right onto Campus Drive. That's the vehicle that's driven by Mr. Robinson.
And on the screen, where is that vehicle that you're referring to located? If you broke it into quadrants.
It's on the
Why is the
left
defense
side.
not
on the
objecting to
upper
any of this?
side, the upper quadrant.
He repeatedly says this is Mr. Robinson. There's no way to tell.
Now, what do we see?
That vehicle's now pulling away and heading east on 800 South.
And why do you believe that that vehicle is Mr. Robinson's vehicle?
When that vehicle was stopped, it actually made contact with an officer who was doing security detail.
And do you know who that officer is? or
Officer
was?
Goforth,
Okay. And do you know which department he works for?
Spanish Fork Police.
And did you have a conversation with Mr. Goforth regarding this interaction at that intersection?
I did, yes.
Okay, and what time was that interaction? I'm sorry, did I ask you that?
It was approximately 12:30 a.m.
On the 11th?
on September 11th, 2025.
Where's
So
the
you
body
talked to
cam?
the Officer Goforth about that contact.
Exactly.
On the corner on that, or during, I guess, during the early morning hours of the 11th.
Correct.
And what did Officer Goforth tell you about that interaction?
It was an interaction that I guess cop intuition, but there was something about the interaction that made him make a note of the license plate of the vehicle.
Oh,
And
big
then
time.
subsequently, when information was available that that vehicle or a vehicle matching the description of that was involved in the incident, he ran the information that he had obtained from the stop and was able to identify that it was registered to Mr. Robinson, and he had in fact had contact with Mr. Robinson on the morning of September 11th, 2025.
The
I
information
call
that he
complete
ran,
bullshit.
do you want
And by the way, we know
Can you say that
American
he ran
Forest Police are
information?
corrupt.
Yes, he ran a partial
because we
plate.
saw what happened with
The
the
license plate?
bricks and
Correct.
minifigs
And based on that partial
thing.
license plate, he was able to identify the owner of that vehicle.
Yes,
And did he tell you who the owner of that vehicle was?
he did, yes.
Okay, and who did he tell you that it belonged
So
to?
This
there
is
were two
CIA
registered
set
owners
up
of the
through and
vehicle,
through.
Tyler Robinson and an Amber Robinson.
Anybody who's
Did he-
seen
did he say
Tyler
anything about the person
Robinson
he
in
actually
any of the
interacted with?
footage that they just
Yes, it
showed,
was a male that he
please
believed
let
to be
us know
Tyler
in the
Robinson.
comments.
Yep.
Let's return again to what's been marked State's Exhibit 12.1. Again, you've reviewed that video.
Yes,
And the difference between 12.1, or what's been marked as State's Exhibit 12.1 and 12.4 are, if I understand you correctly, are these enhancements that we've been talking about.
yes.
And specifically, what be specific about the enhancements, and let's go one at a time.
Okay,
I think there's a reference to either red circles or red highlights. I think
Correct.
That's how Mr. Olson described it, red highlights.
yes.
Do you know what he's, or what is he referencing by the red highlights, or what do you believe he's referencing?
I believe he's referring to red ovals or circles that were placed over the image to identify specific individuals of note.
And these red circles, are they permanent red circles? Are they temporary?
I'm
Different.
I would assume they are temporary. I'm not very technological, but I believe they would be overlaid over the image.
And that is a bad question. What I mean by that is do they appear and disappear quickly, or do they linger or last for a period of time?
They're there for a notable period, but I believe they come off the video. But
All right. And other than, well, and you said that the circles, what do the circles do?
they identify an area or a person of interest within the video.
And other than do that, do the circles or the highlights, do they do anything with regards to the video itself as far as its accuracy?
Not to my knowledge, no.
I think the next enhancement that has been mentioned that we've talked about is there's some blurring.
Yes.
Do you know what that, tell us what that is. What blurring do you see in what's been marked as State's Exhibit 12.1 that you now don't see in 12.4?
If I recall, there were some individuals in the parking garage footage and their faces were blurred.
Is anything other than faces being blurred?
Not that I recall, no.
And how often do you see the blurring throughout the video?
I believe it's just in the original sequence in the parking garage.
The other than the blurring, does the blurring, other than obviously blur out part of the image, does it change or impact the accuracy in your mind of that part of the compilation video?
Not to my knowledge, no.
And then the last thing is, I believe, is there's some zooming in and zooming out that's in 12.1 that has been removed
Yes.
from 12.4. What can you tell us about the zooming in and the zooming out?
Predominantly, it's in the area that was referred to as viewing the Losi building rooftop. I believe it focuses on the area where Mr. Robinson comes up the stairs and onto the rooftop. Those portions of that particular footage were zoomed in for clarity.
Other than zooming in and zooming out, does at least that enhancement to the video, does it change the content of the video?
No.
The accuracy of the video in your mind?
No.
Okay. Are the enhancements in State's Exhibit, well, it's been marked as State's Exhibit 12.1, are they helpful in any way, or what do they add or take away from that video?
I think for people who are not familiar with the area and what's trying to be shown, they allow an opportunity for people to look at an individual who we believe to be Tyler Robinson, and also specific movements with more clarity than the original focal point gives.
So let's talk about the zooming in and the zooming out. It sounds like it's specific to the Losi rooftop, if I understand you correctly.
Yes.
Okay. And I think we've all watched that exhibit.
Correct.
And although you can see Mr. Robinson and his movements, is it fair to say that it's difficult to really see what's going on?
That would be fair, yes.
Okay. And the version that's in 12.1, does it facilitate at least that part of the video, seeing Mr. Robinson and tracking, I guess, his steps?
I believe so, yes.
Okay. Judge, at this point, I think in combination with yesterday, the foundation that was laid yesterday, including the written statement from Mr. Olson, which has been admitted into evidence and is, well, it's already been admitted to evidence. We believe there's enough foundation that at this point, we'd also ask the court to admit what's been marked State's Exhibit 12.1. We think it would be well, beneficial for Your Honor to view it.
Ms. Nestor.
Thank you, Your Honor. We renew our authenticity objection, and we also object to for admission purposes. And then we also object to the publication for the same reasons, the fair trial issues that we raised with the unaltered version that was just submitted.
And Judge, sorry, I neglected to mention the other two. Again, Judge, we believe that the presumption is that this is a public record, that it should be not only admitted, but it should be published here in the courtroom, and it should be published in such a way that the media can have access to it.
All right. I do have a question in just directing your attention to the Utah Rule of Evidence 403, to the last phrase, the last 4 words in that. Do you wish to address that?
Judge, I'm going to have to look at 403 specifically for those last 4
Well,
words.
I
unless
can
you want to
read.
share that
I
with
can
me.
read that. Or
Okay, go ahead and read
needlessly
that.
presenting cumulative evidence. So the court may. Let me just read the whole rule for completeness. The court may exclude relevant evidence if its probative value is substantially outweighed by a danger of one or more of the following: unfair prejudice, confusing the issue, misleading the jury, undue delay, wasting time, or needlessly presenting cumulative evidence. I'm not looking at anything else other than that last portion. I recognize there is no jury. I am the magistrate. I am the fact finder, but just addressing that last point of Rule 403.
Right. Judge, well, I don't believe that the evidence is cumulative. I think that each of the 2 videos, although they portray basically the same footage, there's characteristics of the one that has been enhanced that I think makes it easier for Your Honor to truly see what's going on, and for the public to see what's going on. I mean, we've displayed 12.4 on the video, and unless you have very, very, very good vision, or you've zoomed in on that monitor, you really can't see what Agent Hull has just described. The character of 12.1 is it enhances that at least important parts of that exhibit, and it just makes it easier to see, not only by Your Honor, but also by the public. And specifically as it relates to the zooming in and the zooming out.
Okay. Anything further from the parties as it relates to 12.1? All right. Well, I will admit 12.1 into evidence, but as it relates to playing it in the courtroom or on television, well, for the media, I find that it is, well, as the fact finder, I will look at the evidence and weigh it as a magistrate is required to do, but I do not find it is I don't find it's necessary to replay this video, given the representation that's the exact same video, the difference being enhancements made. If it was different in any way, or if it added to or subtracted from, that would be one factor. But because it's simply the same video, simply zooming in with circles or notations, the court does not find that the interests of justice requires it being played again. But it is received into evidence and will be reviewed by myself in determining a probable cause determination.
And I appreciate that, Judge. And just so we're clear, State's Exhibit 12.1 has been admitted.
It is received into evidence, yes.
And your intent is to review it in its entirety, but not here in the courtroom.
Yes.
Can I make one suggestion, Judge, or maybe one request? I believe the most important part of the most helpful part of this video is the zooming in and the zooming out. And that is a portion that, if you want, we could isolate that and only play that portion of the video if you'd be willing to publish that portion of the video. And that's really
You could tell how
the
bad they're
thrust of
fighting to
why
get this
we are
published, that
trying
they're
to
trying to
present
set this up
we
for a
see- we
psyop. This has
believe
been
that
their whole
it's
plan the whole
helpful
time,
to see
is
it
to
up
try to
close.
contaminate the
And
jury
unfortunately,
and to
because of the way
psyop
it's
the public
formatted
into
and the way it's
thinking
been
this is
recorded,
Tyler Robinson when there's no way
any of
to
us
tell who
can
it
zoom in and
is.
zoom out on this video to get a better look at what's going on. And that's the reason we
I mean, you could tell just
did.
how hard this
We
guy's
had to
fighting to
memorialize
get
it and
this
save it.
published.
And then present it in that way rather than just present it in its raw form and then have the ability to zoom in and out, if that helps Your Honor
Oh.
understand why we're doing what we're doing.
All right, Ms. Nestor, to the second request of not playing the whole video in its entirety, but simply the portion with the zooming in, how long is that, Mr. Sturgill?
I think it's a couple of minutes.
Ms. Nestor?
We object to the prejudice of that, Your Honor, and ask the court to stand by your previous ruling on that.
All right, thank you, I appreciate
Let me rephrase on why we were bringing it.
and there is nothing on this video from what's been represented that the public hasn't already seen. It's simply zooming in, and I don't find that that is necessary or and so in balancing the constitutional rights of all parties, I'll view it on the monitor. Council's free to view it with me as I'm looking at it, but it will not be broadcast in the courtroom or by the video camera.
I appreciate that, Judge. I respect that. I think there's a natural break where we
Sure.
can start. And what I'm going to ask is just we simply play you will have this entire exhibit in evidence, though.
Thank you.
Is that right?
Yes, I
Okay.
will. All right, whenever you're ready. Council, as it relates to your monitors, just as a caution, if you don't want it to be wished to be picked up, and I'm not saying it will, I know there are camera operators being diligent in ensuring that complying by the rules. In abundance of caution, this is just your moment to take care of your screens if you feel the need to do so.
So if I could just have one moment, hold on.
Exactly. Like I said, this is clearly a
So we're
setup.
power
They
button.
had this plan all along. This is nothing more than a psyop
There we go.
for the Fed sloppers to be able to go out there
All right,
and
counsel,
push.
for
See,
defense,
they have
are
video
we
of
prepared?
Tyler
And
Robinson
for the
firing
state?
the shot. Blah 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 blah.
All right. Thank you. Having heard from both
When there's
counsel,
no
I'll
way
go
that
ahead and review it
there's
on my
no way to
screens. It is
tell
not
who
being
that
displayed in the
is.
monitor in the courtroom. And you may present 12.1, the portion you wish for me to view.
The stream's kind of going
Just for the benefit of
funky,
the
huh,
record,
bro?
you want to put on the record the timestamp of what you're playing, at what point you're starting and stopping, as we go. Or
Yeah,
when
I
we
don't know.
finish is
I don't know.
fine.
I knocked it down to 480p. That
Just want the
seems to have
record to be
fixed it. But
complete.
I don't know what happened. It got weird for a minute.
Just the difficulty in doing that is because we've zoomed in, it's removed the timestamp on it. And so-
Well, you can just give me the
count
The
on the
count
video?
on the bottom. There's a timer at the bottom of the total length of the video, so that's fine. I'm
No,
just
the
trying to create a
Discord, the
record of what
Discord
exactly
messages
I'm
are
looking at.
completely fake, Sarah. We were able to determine that the Discord messages were authored after Tyler was already at the jail, had already turned himself into the jail, was detained, and had already handed over his devices, so he had no way to do that. So whoever authored those Discord messages, who knows who it was? Probably Lance Twiggs, to be honest with you, but it definitely wasn't Tyler. We know that for sure because Tyler was already in the jail being detained at
Oh,
that
I
time. He had
see.
already turned
No,
himself in.
it's Limitations of technology sometimes. Thank you for letting me know.
He did not confess to his parents. That's a lie. The parents have come out and said that that's a complete lie.
Come on, the video is just.
I'm curious to
The
see if they're
evidence
going to let
is-
Tyler
Go
Robinson's
watch Baron
parents
show.
speak.
Go
This is State's Exhibit 12.1.
Thank you.
Yeah, go watch Baron Coleman. Go watch. He did an entire stream on
I have it
this,
on my screen.
proving
It's so it
that
looks like
Tyler
it's been
Robinson
paused
was in
at 6
custody
minutes and 9 seconds.
at the
Agent Hall, can
time
you see it?
that the Discord
Yes.
messages were altered, backed up by the actual, the probable cause, the charging statements, the arrest record, everything.
So this time we'll play it. Go ahead, Kimberly.
It's playing.
Yeah, basically, this is completely. They're trying to. The way they're working very hard to contaminate the jury. Yeah, well, that's a lie, Adam. He did not admit anything to his parents. The only reason he turned himself in was because he feared they were going to try to kill him, and that's why he turned himself in. It has nothing to. He did not confess to anything. They had already had named him, and they were coming looking for him, and they feared that they were going to kill him. That's the only reason he turned himself in. The parents confirmed that because Billy Webb was actually able to talk to the parents at the trial, not the trial, but at one of the previous hearings, talked to Tyler Robinson's parents, who confirmed that what the media is saying is a complete lie.
Anybody who believes the narrative that the mainstream
They weren't
news media
altered
is
while
pushing,
he was in jail. They were altered while he was in. Go ahead.
anybody who believes the narrative that the mainstream news media is pushing about Tyler Robinson hasn't learned anything from the past 15, 20 years about the media.
Exactly. And you say, how do I know the messages were altered, Tyler? They weren't
and it's been
altered.
paused, it
They
looks
were
like, at
altered,
6
meaning
minutes and
whoever
23
the
seconds.
timestamp on them, at the time that the
Judge,
messages
at
were
8:23,
written,
we stopped the video.
Tyler was
8:23,
already
8:23.
locked
Count.
up in the jail, detained in the jail, in the
All right.
Washington County
Thank you,
jail.
Mr.
He had
Sligo.
already turned himself in at that time and did not have
Agent
his
Hall, you're able to
phone,
watch
so he
that
could not have
zoomed
written
in
him.
version. Is that
Yes, sir.
right? Okay. And was there anything that stood out watching that zoomed version?
For me, on the zoomed version, it's apparent that Mr. Robinson, the individual jumping off the roof, is carrying an item.
Okay. And you can see clear the clothing that he's wearing.
Yeah, and it's
Mr.
not a
Judge, you
gun
wanna
though.
respond to the
It's
objection?
a
Judge, it is
coat
the-
or a towel or
I'll
I'll
something.
go
It's
ahead
not
and, sustain
it's
the
not a gun,
objection and that,
because it flops
may move
around.
forward.
A gun
Is
would
it
be
easier
rigid.
to see?
What he had in his hand was not rigid.
Oh, strike that, Judge. I'll let the video speak for itself. Judge, I have nothing further with Agent Hall.
All right. Ms. Nestor,
One moment, Your Honor,
Of
if I may have
course.
the court's indulgence.
Bingo. Exactly, Sarah.
Thank you. Do you
And-
want to take your?
And I was just going to suggest that. It seems like right now is a good time to take our morning break. Is
They
10:15.
did not.
Let's come
And
back at,
supposedly that's on video, and there's a
back at
girl helping
10:30,
change
and
clothes. So
we'll
where's that
resume with
video?
cross-examination of Agent Holt. Court is now in recess.
You're muted.
We have video when it comes to this comment right here. They address what he was changing clothes at. No. We have video proof that we have video proof of one of the neighbors that live in the area with the ring camera footage saying that she saw Tyler Robinson or somebody that she, whoever it was, changing clothes, and he was with a female suspect or a female accomplice while changing clothes. So where is that? They have video of that supposedly. According to Candace Owens, they have video of that. So where's that video? If they were able to track him all over the place, then why haven't they shown that footage and addressed why he went, all these clothing changes? I think it's multiple people, and I think that what they showed only further points out that this is multiple people. What's your thoughts on all this, man?
Hey, I'm about to get in the car right now, bro, to drive the little one across to her party. So I'll be back in like a few minutes.
Oh, okay.
Complete Fed
Yeah, no
slop.
problem.
I didn't see Tyler Robinson. You cannot depict Tyler Robinson from any of that video footage, bro. None. And this Fed is literally trying to psyop the jury pool by continuing to put Tyler Robinson without a shadow of a doubt in those images. And you cannot, every time, like one of the persons in the chat said, every time that individual walked by the camera, they would tilt their head. You don't think they knew those cameras were there and to do that?
Exactly. Shirt is different from the person in the black shirt that we saw in the stairwell the second time. And that's my opinion. And also, did you notice that they said that the person went up and talked to TPUSA staff? That part is also very interesting. I want to know who they talked to or who they colluded with, should I say. The fact that they colluded with TPUSA staff or talked to TPUSA staff is very, to me, that's an important part. I want to know who it was, because obviously we think TPUSA was involved. Their quote unquote suspect, the shooter, had talked to one of these people. I think that would be pretty damn relevant to see who it was.
Hey, I'm gonna send you a message on X, bro. Go check it real quick.
All right. I'm trying to upload this video so we can look at it again, guys. I want to definitely replay that video with you guys. It's just done uploading here. That could be why it's running slow too, by the way, because I'm trying to upload this video. All right. So they're on break right now. Let me see if it'll let me pull this up. Probably not. Oh, no, it did work. Okay. All right, so I'm going to be on break until 10:30, so we'll come back at 10:30 and check that out. In the meantime, let's go ahead and we will rewatch this video again, because I think this video is very important.
Proceed.
Appreciate that, Judge. Thank you. Go ahead. Okay, what are we seeing here, Agent Hall?
That's the vehicle that is believed to belong to Mr. Robinson arriving in the parking.
Now, I can't tell from here, but that looks like it may be close enough to get a license plate. So that might actually be Tyler Robinson's car. I don't know. We'd have to see whether we can read the license plate or not. But even if it's his car, that doesn't mean he's driving it. You can't see who's driving it. If you look in there, there's no way to tell who's driving it. And by the way, those wheels, they want to say that these are unique wheels, that, you know, these are special wheels. That's how we know it's Tyler Robinson's car. That's a lie too. These wheels, like I said yesterday, these wheels, they are premium wheels, yes, but they are stock premium wheels. They are, you know how when you buy a new vehicle, you get like the regular wheels that come on, or you can get the upgrade package or whatever. They have the upgraded wheel package on Tyler Robinson's Challenger, which honestly, that's not abnormal. Most people that get a Challenger get the upgraded wheels because it's way cooler. If you got the money to buy a Challenger, you're going to buy the one with the upgraded wheels, and you're not just going to have the regular stock wheels. So that's for them to try to say the wheels are how they know it's Tyler Robinson's car is complete bullcrap. But we'll continue.
That's the vehicle that is believed to belong to Mr. Robinson arriving in the parking garage on campus.
At what time in the morning? What time of the day?
It's approximately 8:30 in the morning on September 10th, 2025.
And what leads you to believe that this particular vehicle belongs to Mr. Robinson?
Information that was provided regards to driver's license and Department of Motor Vehicle records. The vehicle fits the description of a vehicle owned by Mr. Robinson.
Is there anything unique?
So when he says the vehicle fits the description, he's merely talking about it's a Challenger and it's gray. That's basically all he means. It's a Challenger and it's
I think
gray.
your mic is muted,
Which,
bro.
you know how many gray Challengers out there are in the world? No, my mic's not muted. It's not muted. It's on your end. So yeah, Challenger and it's gray.
About that vehicle that stands out to you?
The shape of the vehicle is very distinct, but predominantly the wheels were very distinctive on this version of the vehicle.
Now what do we see?
The driver of the vehicle exits the vehicle and then walks on foot to exit the parking garage. It's the individual in the red t-shirt and the shorts and the shoes.
And do you believe you recognize who that person is?
Yes.
Who is that?
I believe that's Tyler Robinson.
All right, and where does he go from there?
You notice he had his...
He heads out of the parking garage.
And you notice he had his phone up to his ear, so you couldn't tell. He had, as he's walking by the camera, he put his phone up to his ear, facing the camera to hide his face, so you couldn't see his face. So I don't know how they're trying to say, oh, we know for sure that's Tyler Robinson. There's no way to tell. As he walks by the camera, he hides his face every time, whether it be in the parking garage area or in the stairwell here. You'll see in the stairwell, every time he goes by a camera, he puts his head down so you can't see his face.
On foot into the campus and actually goes to the quad area of the campus. At that time, he makes contact with some representatives from TPUSA.
By quad area,
He goes to the quad area of the campus and makes makes contact with representatives from TPUSA. That part cannot be understated. That part cannot be said loudly enough. So the alleged shooter that they're saying made contact with representatives from TPUSA. That's wild. Why haven't we heard from that? Why hasn't TPUSA mentioned that fact? Because you know if this person, if the feds or cops or whatever have this video footage of this person making contact with TPUSA, they would have reached out to TPUSA to see who this person was and to get a statement from them. So why hasn't Turning Point themselves come out and said anything about, oh, well, this person had contact with our people? If they were innocent, they would have just said that, this crazy guy came up to us but no, they've kept that part hidden. And I think that's very telling.
Sorry, the amphitheater is what I previously referred it to.
all right. So he goes up on campus, visits the amphitheater area, the courtyard or quad.
Correct.
And then what do we see here now?
He returns on foot back to the same vehicle.
And what time is he returning back to the vehicle?
It's about 9:25 a.m.
And where is this parking structure located on campus?
It's just off of Campus Drive. It's a short walk from the amphitheater.
What do we see now?
That's the vehicle exiting with Mr. Robinson driving the vehicle.
Now what do we see?
This is Mr. Robinson returning to the campus on foot from the neighborhood to the northeast. You can see he's wearing the same clothing as in the previous video. And he's carrying a blue backpack.
Now what do we see?
This is Mr. Robinson returning to the campus on foot from...
Can you make out a face there? I can't see his face. That doesn't look like Tyler Robinson to me.
From the neighborhood to the northeast. You can see he's wearing the same clothing as in the previous video. And he's carrying a blue backpack.
Describe the clothing.
It's a maroon colored t-shirt with gray or olive colored shorts and then Converse shoes.
And what time did he return to campus?
Just after 10 a.m.
And of course, he puts his head down so you can't see.
And does he leave the parking structure eventually?
He does, yes.
Okay. And during this visit, do you know where he goes after he leaves the parking structure?
Yes, we were able to track his movements on campus. He went to Chick-fil-A in the Sorensen building, purchased some food, sat and ate the food. Then,
And-
I'm sorry.
And they say he went to Chick-fil-A on campus and sat and ate some food. Okay, well, that doesn't make any sense either. You know, do you really think this guy, if he was about to murder Charlie Kirk in cold blood, you know, assassinate the biggest political figure in the country, basically, you really think his nerves, and he's not like a career killer or anything, like this is the first time, you know, if this, you know, this is allegedly the first time he's ever done anything like this. He, you know, has no record or anything. So you really think that he would have the nerves to sit down and eat a meal before doing this? Absolutely not. Absolutely not.
Where did he purchase the food from?
Chick-fil-A in the Sorensen Center.
And where is that in relation to the amphitheater or the courtyard?
It's kind of on the northeast side of the amphitheater. It would be on the upper back edge of the amphitheater, furthest away from where the tent was that Mr. Kirk was in.
And from there, where does he?
I'm gonna try to refresh stream because it's pretty wonky for some reason. I don't
From
know
there,
what's
he
going
moves
on here.
across campus, out across Campus Drive into a wooded area on what would be kind of the northeast side of Campus Drive. Then returns back onto campus. We noticed at this point that he's no longer carrying the backpack that he was originally wearing. He moves through the Gunther building and the computer science building. And
goes
then,
where?
I'm sorry?
And then goes where?
Then goes across to the railing that gives access to the roof of the Losi building.
And from there?
From there, he comes back down the stairs and walks off campus from that point.
And about what time was that he left campus that second time? Do you know?
I believe it was approximately 11 a.m. or just after, if I recall. I could verify from my notes if you need an exact time.
Yeah, if you don't mind. It'll help you remember, refer to it. Don't read it out loud. Let me know when you've had a chance to look at that, would you?
Fed slap.
Were you able to refresh your memory as far as the time?
I was, yes.
And what time was it?
It was just prior to 11 a.m. when he walked off campus.
Okay. And before we go any further, the parking structure that he left,
All right, hopefully that's better. Okay, I'm moving a little bit faster now. I think we might have fixed whatever the hell was going on. Yeah, I don't know. Sorry about that, guys. Give me a second to try to pull it back with time. Oh, actually, I think we're starting, the trial's starting again. So let me go ahead. Yep. So let me go ahead and share the stream because we just started back up. Oops. Wrong one. Give me a second. I had to, because I restarted everything. Okay, here we go.
With preparing for big events like this or not? Is that's not typically something you do?
Not something that I've ever been involved with, no.
Okay. And what time did you arrive on campus that day?
I believe it was shortly after 1:30.
So approximately an hour after Mr. Kirk had already been removed from the.
Approximately, yes.
Okay. And were you involved in putting up any drones into the air? Were you part of that or were you not
It's
involved? in
not,
that?
no.
So how quickly after you arrived on scene did you become aware that you were actually going to be in charge of the scene?
I believe it was approximately an hour after, so what would have been approximately 2:30.
So for the first 2 hours, you were not in charge.
For the first 2 hours, I wasn't, I didn't arrive till 1:30, so no.
Okay. And once you came from on high that you were basically going to be in charge of the scene, what was your first priority? What were you focused on?
We were focused on, through our major crimes team and our lieutenant, putting together an investigative team and developing initial assignments and a plan as to what we were going to do moving forward.
And part of that is protecting any potential forensic evidence that may be found on the scene. That's clearly important, right?
Correct.
Preserving the scene, right?
Correct.
But it sounds like that's not really your area. That was more maybe Agent Falmina's area.
Agent Falmina was assigned to process and document the crime scenes. It was my understanding that the known scenes at that time, amid the chaos, had been contained and had been secured by the on-campus officers who were already on scene.
And what's your understanding of what the known scenes were? In other words, the area where there might potentially be evidence that you needed to process.
I know that the amphitheater area was cordoned off and managed as best it could with the number of people that were there. I was also made aware that there was a rooftop area that had been secured and also an area off of the side of that building that had been secured by an officer.
And that building was the Low-C building.
Correct.
Wasn't there also a bullet found on another building?
I believe an unfired bullet had been found on another building at some point during my time there on September 10th. Yes.
Which building was that, sir?
I don't recall.
Was that considered a scene that was worth preserving?
It was not. My recollection is that that was accounted for as an ejected cartridge from an officer who had cycled his rifle.
Okay, I thought you said it was an unfired
Bull
bullet.
crap.
Now you're saying it was a
That's correct.
cartridge?
When a weapon is cleared,
Uh-huh.
an officer would make his rifle ready, which would chamber around.
Oh,
Bull
I got you.
crap.
And
Bull
my
crap.
understanding was that that's how that was accounted for.
So an officer claimed that bullet belonged to him or her?
That's my recollection, is that was how it was accounted for.
And when was that accounted for?
I don't know specifically.
Do you remember what type of bullet that was?
I don't.
Was it a 30-06? Do you remember?
I don't.
Do you know where that bullet is now?
I don't.
Okay.
Of course not.
So
Of
you
course they don't
had
know
the
anything.
amphitheater area that had to be preserved. And how far out did that stretch? The entire amphitheater or just the area around the tent or what?
My understanding was the entire amphitheater area was cordoned off, and there were attempts to secure the campus itself with a perimeter of officers who were monitoring or preventing people coming and going.
When you arrived on the scene, were you aware that an individual had been taken into custody?
I had heard that, yes.
Did you ever have any interaction with that individual?
I did not.
And were you advised at any point that that person was no longer a person of interest?
Information was passed down that the individual was not considered to be a suspect in the shooting.
And when was that, time-wise?
I don't recall specifically, but I know I was on campus when I had heard.
So whoever arrested him as a potential suspect got that wrong. He wasn't the actual suspect, right?
Sorry, got what wrong?
That he was the shooter.
The person I believe to be the shooter was not the individual who was taken into custody, correct?
And then was there anybody else taken into custody as a person of interest?
There were several people who were detained for questioning and who were interviewed throughout the investigation.
And none of those people were they were all ultimately cleared by you or somebody connected with you.
Correct.
And were there any other guns confiscated on the scene that day?
There were other firearms that were located on the scene, yes.
How many guns were confiscated that day?
I don't know specifically confiscated, but I know that there was a firearm found in a backpack that was accounted for during the day.
What type of firearm was that?
It was a handgun.
Any other guns that were found on the scene?
Not that I recall.
Do you recall an individual named Noah Gonzalez being interviewed?
I don't recall that name specifically.
Let me see if it refreshes your memory that he was an off-duty, I think maybe trooper that was on the scene that day and that was involved in recovering the holster. Does that refresh your memory?
I know that a trooper was interviewed having been on scene. I don't recall if it was Gonzalez. I don't recall the name, but I do know there was a trooper that was interviewed, yes.
Okay, and just a moment, Your Honor. And do you recall the trooper that was interviewed saying that there was actually a gun found in that holster?
I do not.
You do not?
No.
Okay. Can we pull up? Exhibit Hull 13 and just show it only to the witness for right now. All right, can we go to page 2 of that report? Do you recognize this report? Have you reviewed it as part of your investigation duties?
I do recognize the report now, yes.
Okay, and this is a report prepared by actually Mr. Davis, who's going to testify later in this matter. Is that right?
Correct.
Okay, and on page 2, this is the interview of Noah Gonzalez. Is that right?
That's what it's stated on page 1, yes.
And he's an off-duty trooper who happened to be there that day?
Correct.
And do you see on the second paragraph, does that refresh your memory about whether Trooper Gonzalez believed there was a gun found in a holster in that area of the amphitheater?
Trooper Gonzalez included in his report that there was a gun, yes.
Okay. Thank you. Okay. When did you first personally go up to the roof of the Losi building? Do you remember the time of that?
I don't recall. I know it was dark when I went up to the roof, so it would have been later that evening.
And at the time you went up there was already crime scene tape that had been placed around it?
There was an officer standing security.
Right. And to your knowledge, as the head of the investigation, did they ever find any bullets or casings anywhere on the Losi roof?
Not to my knowledge, no.
Did they ever find any bullets or casings anywhere around the Losi building?
When you say around the Losi building, do you mean how close? Like immediately around the Losi building?
Correct.
Not to my knowledge, no.
Okay. And then you've been talking a lot about a timeline here that seemed, you talked about it when you were watching the video, but you also talked about the fact that you developed a timeline. Is that right?
Correct.
And can you pull up hole 1, please? I'm pulling up on your screen your report that you prepared. Do you recognize that?
I do, yes.
And what's the date that you drafted that report?
Looks like September 14th. It says date created.
And that's the place where, if you could go to page 2, please. Do you see down at the bottom where you summarize Sergeant Bricker's report listing the timeline?
Yes.
Okay, and so it was actually Sergeant Bricker that prepared the timeline, is that right?
He prepared a timeline.
And you incorporated that into your report?
No, I created a timeline.
You created your own timeline?
Yes.
Separate from the one that's in this report?
Yes, using information obtained in the investigation.
And when did you create that timeline?
Over the course of the investigation, over a long period of time, after a lot of reviewing video and investigative time.
So as of September 14th, Tyler Robinson had already turned himself in to the authorities. Is that right?
Yes, I believe he turned himself in on September 11th.
So prior to the time that Tyler Robinson turned himself in, had you all prepared a timeline?
A documented written timeline?
Yes.
Not to my knowledge. I don't know when Sergeant Bricker produced his specifically.
And isn't it fair to say that as of the moment that Tyler Robinson voluntarily surrendered to authorities in Washington County, as of that moment, you all did not know who the shooter was. Is that right?
We had identified a person of interest, but we did not specifically know who the shooter was at that time.
Okay. And you became aware that Mr. Robinson was voluntarily surrendering how? How did you become aware of that?
That to the administration at the control center at the university on the evening of the investigation,
Okay.
or the second evening of the investigation.
All right, we're going to get back to that in a minute, but I just wanted to get the timeline down. All right, now I want to go back to the videos that we've seen and the question that I just asked before, which is it fair to say that nothing about the video of the individual on the roof revealed to you, you couldn't see facial features, you couldn't see what they were wearing, correct?
Of the individual on the roof?
Correct.
I know that there was a meeting to discuss perhaps a pattern on the front of the shirt that was observed when the individual was jumping off of the roof.
Okay, that's fair. But at that time, as of the 11th, before Mr. Robinson turned himself in, you all had not been able to determine that. Is that right?
Excuse me.
Answer the question.
Determine who he was. Features.
Determine distinguishing features of the video
Yeah.
of the person on the roof.
Yes, we had a person of interest, and those images were released to the press.
You're talking about the ones in the stairwell from the
Correct.
from the parking garage.
Correct.
But the video on the roof was not distinguishable. Fair?
That video as a standalone
Yes.
was not, no.
Okay. And in fact, the video
Exactly.
on the
You
roof,
can't tell
well,
who
strike
it
that.
is.
Is it true that you had some spectators that you interviewed that had gotten a photograph a few seconds before the shooting of someone on the roof?
Sorry, I'm not sure I understand the question.
Did you at some point in your investigation
Bullshit.
collect
Don't
from two
understand this
young men
question.
who were present at the event a video that they had taken of someone on the roof about 10 seconds before the shooting?
Yes, a video, yes, not photographs. A video was collected from an individual who had a video
And ultimately, some screenshots were taken out of that video. Is that right?
by,
By you?
not by me, no.
Okay. That's fine. It could have been someone else.
Okay.
But did
That's
you
a
see
lie.
the
I'll
video
tell you
that those
why.
young men took?
If you're referring to the video that is looking north and shows an individual dressed in dark clothing on the corner of the roof,
Yes.
if that is the video, I have seen that video, yes.
Did you review the interview of those young men?
I did not.
Do you know how they described the person on the roof?
This is good because
I don't know if I read it
listen
or
to
if I
this.
heard it, but my understanding was they believed it was Overwatch or some kind of a police Overwatch for the event,
Okay.
if that's my
No,
recollection.
And do you
bullshit.
remember anything specific about the person's build that they discussed when they described the person on the roof?
I do not know.
Okay.
All black, wearing tactical gear, black
There
vest,
is
black
a
pants.
portion of the video after the
Was not
individual jumped
matching
off
what
the
Tyler
roof, which we all
Robinson was
saw
wearing.
here, where
Allegedly,
the individual
the
crosses,
person
I
they
believe
say
it's
is Tyler
Campus Drive.
Robinson.
Is that right?
That's why he said he didn't
And
know.
there's a moment where the individual waits and there's two cars that
course.
pass in front of him, right in front of him.
Correct?
And is this the moment where you are submitting that he was holding a gun in his hand?
As across the road?
Yes.
From my observations, would show that he's carrying an object in his hand that's concealed or in a bag, and it is long and has the appearance, based on my training and experience, it could be a firearm.
But do you see
Exactly,
it anywhere?
complete sham.
The actual
In
gun?
the video?
Sham.
Yeah.
No.
All right. And did anybody that was driving by on Campus Drive that day report to you or any other investigative entity, hey, we just drove by a guy with a gun who was leaving campus and he was standing right by my car?
We did not receive any reports to that effect, no.
Okay. Also, when you were revealing the timeline, exactly how long was there between when the person was prone on the roof and when the shot was taken? Do you recall?
If you would like to replay the video, I can time it for you, but I don't recall. It was my guess, I would estimate between 15 and 30 seconds.
So between 15 and 30 seconds to lay flat, take a shot, and get up and run off, right?
You guys
I
just
think you
ignore
asked
the
how long
trolls
he
in
was
the chat.
prone. I
Right.
think it
The
took
trolls
longer
in
for
the
him
chat
to crawl
are a bunch
into
of bed
position
sloppers
Okay.
trying
and then
to
establish a
bed
position
slop. Just
and then
ignore
take
them.
the shot. He appeared to be in prone for approximately 15 to 30 seconds, but the video would verify that.
Okay, thank you. All right. I want to talk to you for just a minute about the video that was taken. And I'm not going to get into I'm not going to show it, just so that in case anybody's concerned about leaving the courtroom, I'm not going to show it. But there was a video that was taken by Mr. Ty Phillips from behind the individual that was speaking to Mr. Kirk.
Correct?
And it showed like a dead-on view of Mr. Kirk and his parts of his security team. Is that right? And then you also have video that you described that shows the back of the tent at the moment the shot happened. Is that right? Behind Mr. Kirk.
You're referring to the UVU video in the breezeway?
Yes.
We have that video, yes.
Okay. And can we pull up the last video, the last clip, 49? I want to show you, just you, this clip. That is a little clip from that video under the breezeway that's behind the tent, right?
Correct?
And just to be clear, this area behind the tent would not have been visible to anybody that was on the Losi building. Is that fair?
I can't answer that question.
Yeah, sure.
And Ms. Nestor, as you're playing this, are you just being cognizant if the sound is on or not?
I don't want the sound. Please.
Okay, I just wanted
not-
to
Thank you for bringing
clarify.
that. Thank you.
All right.
She doesn't want the
I just want
sound.
only the witness to look at it. So can you just watch this clip for just a minute? This one little
What the
clip
hell?
of behind the breezeway at the time of the shot.
That's fine. And so just as a reminder to all the parties, if it's on your monitor, please be cognizant of that. It will not be
Why are we
displayed
not
on the
allowed to
main
see
monitor.
it? This is
Ms.
such
Nestor, you may
bull
proceed.
crap that we're not
Thank
allowed
you.
to see any of this stuff, man. They want to show us the Fed slop crap that, you know, that they're trying to say is Tyler Robinson when it's not, but they won't let us see any of this other stuff that would help prove it's not him, that would exclude him.
Okay. Do you remember that? Does that refresh your memory of what's in that clip?
Yes,
And having reviewed that, at the time the shot was fired, there was no one standing directly behind the tent. Is that correct?
you'd have to show me it again. I wasn't specifically looking for that,
Okay,
but I can answer that question if I can view the video again.
okay. And just before you do that, I think you testified before that Mr. Kirk would have been dead center behind that banner. Is that right?
Approximately.
Okay, so what I'm asking is if anyone behind that banner, dead center behind Mr. Kirk, if there was any people standing there. Go ahead.
So there's a videographer on the right side of the tent. And then I can only see as far as the video allows me to, so I can't speak to whether there's anybody out of frame who could have been behind the tent.
But what you can see, is there anyone directly behind the middle of the tent?
Yes, there's a videographer stood behind the tent.
To the right,
Yes, behind the tent.
correct. But directly in the middle of the tent, is there anyone standing?
There's no one stood in the middle behind the tent, no.
Thank you. All right, I want to talk now about the TP. You can take it down off of the screen. Thank you. I want to talk now about the TPUSA video that you got. That was the angle that was taken from behind Mr. Kirk while he was talking, looking out at the audience during when the shot was fired. Do you remember that video?
The visual impulse videos?
Yes.
Yes.
All right. Is it true that Visual Impulse provided 4 videos?
Yeah, I believe there were 4 total videos that encompassed everything that they provided to us, yes.
But the one that you showed, that's only one of the 4 that they provided to you?
That one that was shown had a Bates number. It was an item that was provided by Utah County Attorney's Office.
Okay, but were there more that you haven't seen in this courtroom, in this prelim, that you got from?
There's the original footage.
Okay. But were there other angles that are not shown here in this prelim?
Yes.
Okay, that's what I was trying to get to. Thank you.
This guy is being so cagey.
All right. Were you involved when the gun was located in the forest area?
I was not involved in the search for the gun, no.
Did you get notice when it was located?
From the footage that we reviewed, we identified an area that we believed could be potentially of evidentiary value. And then it was secured. And then I was notified that as a result of that search, a gun had been located, yes.
Were you involved in the processing of that gun? In other words,
I was not.
boxing it, shipping it, sending it wherever it was going to go to be
I
analyzed?
was not, no.
Okay, thank you. All right, now I want to shift to the autopsy for just a moment. You were not present at the autopsy, is that right?
I was not.
Okay. So anything
there
you
wasn't an
know about the
autopsy.
autopsy was not from personal observation?
No, other than from my meeting with the medical examiner and his report. No, I was not present.
Did you meet with the medical examiner after he had conducted the autopsy?
I did, yes.
And when you met with him, did you provide him information about what you all had learned in your investigation so far?
We didn't have any reason to provide any investigative information to him. The purpose of the meeting was to establish what information he could provide to us.
Well, in fact, on the front page of the medical examiner's report, he talks about the investigation and information he learned. Did he learn that from you or did he learn it from someone else?
It would be my recollection that he did not learn that from us, but I couldn't speak to how he did learn about it.
Okay, so you didn't share with him your conclusions about what happened or how Mr. Kirk was injured or anything like that?
That's my recollection.
Okay, thank you. And isn't it also true that fingerprints that were taken from Mr. Kirk and autopsy photos were provided to you on a CD?
Yes.
Was there anything else provided to you from the autopsy other than that?
Other than the CD and the report?
Yes.
Not to me, no.
Okay. You did mention not to you. Were you aware of anything else from the autopsy going to anyone else?
I believe standard practice is anything of evidentiary value that the medical examiner collects is transferred through a chain of custody.
And are you aware of anything that was transferred after Mr. Kirk's autopsy?
I'm aware that there were items transferred for evidence, yes.
What items?
I believe some fragments of a bullet casing. I know Mr. Kirk's personal items to be returned to the family.
Fragments of a bullet casing.
That's all I can recall off the top of my
Do you
head.
know how many fragments from the bullets?
I don't.
He didn't say bullets, he said bullet casing.
Now, I'd like to talk a little bit about the Ring camera that you obtained. And you interviewed a woman named Ms. Noble, is that right? To get that Ring camera that we watched with the car on the outside?
We interviewed her to verify the authenticity of the video, yes.
And were you involved in that interview?
With Miss Noble,
Mhm.
yes.
And do you recall what they told you about what they remember seeing in and around that car that night?
I don't recall. I just know we were there to verify the video. I didn't conduct an interview with Miss Noble at that time.
Okay. Can we please bring up whole? Sorry, just a moment. Let's see. Whole 48. This is Miss Noble's interview. Do you have it? All right. Do you remember that? Looking at that interview, does that refresh your recollection?
I remember reading the report at some point, yes.
And do you remember that the Nobles told you that the driver of the vehicle was bald?
I do remember that being in the report, yes.
And you didn't mention that today when you were talking about that Ring camera, did you?
I did not.
And did they also tell you there were 3 other people in the car?
Yes, I believe they thought that was the case.
I love it.
I want to go back, if I can, to the scene itself, the preservation of the actual scene where Mr. Kirk passed. Did you all have canine dogs at any point that sniffed that area?
I don't know specifically that area, but I do know that canines were present, or a canine was present on the day.
But you don't know what task the canine was given?
My understanding was that it may have been used in an effort to track an individual that had jumped off the roof, but I don't know for certain.
And obviously that didn't produce any results, or we would have heard about that, right?
Yeah, not that I was made aware of.
Dogs can trace gunpowder residue on a fired firearm.
Do you know
Exactly.
when the tent and the stuff was actually removed from the scene?
I don't. I would imagine it had been at least a couple of days, if not longer than that, before anything was removed from the scene.
You didn't have to give permission to remove the tent?
Me?
Couple of
personally?
days,
Right.
it was
No.
gone like that
you're not
day
sure
because
when it
they
was
paved
removed?
over the whole crime scene 2 days later.
And were you involved in the decision to pave over the dirt that was under the tent?
AUV?
Bingo.
Uh-huh.
No,
Did you know that happened?
only because it was in the news.
All right. But you don't know when or who ordered that?
Thank God she brought that up. At least
She's
that tells you
redeeming
she is
herself.
watching what we do. She's paying attention to this.
And it's true that
Yeah,
during
she's
the
paying
time
attention to
before
the stuff
Mr.
that we're
Robinson turned
covering, that we're
himself in,
uncovering.
you all received lots and lots of tips from the public. Is that fair?
Correct?
You received tips of death threats that Mr. Kirk had received the day before the shooting. Is that right?
I'm sorry, did we receive threats that Mr. Kirk had received before the event, or?
Let me clarify.
Thank
Now
you.
he's trying to play dumb.
As you were
She's
going
talking
through
about the
tips
threats
that
from
the
about
public was
Israel.
giving you, did you receive tips about online death threats that had been made against Mr. Kirk prior to his death?
There was a
Online.
huge variety of tips and information and suggestions that were being provided by the public.
Okay. And a lot of those, some of those filtered through you, right?
Some of them filtered their way down to us, but predominantly that was being handled by our State Information and Analysis Center that had been set up.
And you also got multiple tips about potential suspects, people who thought they recognized people in the picture, right?
Yes, there were different calls and information provided by the public.
And you had quite a few of those.
Correct.
And then Mr. Robinson turned himself in, right?
Yes.
And is it your understanding that the individual they used to facilitate Mr. Robinson turning himself in was someone known to Mr. Robinson personally that had been connected to law enforcement?
I know he was known to the family. I don't know his connection specifically with Mr. Robinson, but I am aware that someone was used to facilitate Mr. Robinson turning himself in.
And were you aware that he was one of his Boy Scout leaders? Did you know that?
I think I had heard that at some point. There was a connection. I didn't recall specifically what it was.
And Mr. Robinson, in fact, no police went to go arrest him. He drove himself, or he was driven with his parents to the Washington County Sheriff's Department, correct?
That's my understanding, yes.
And he voluntarily walked in.
That's also my understanding, yes.
And that was the first moment you ever knew his name connected with this case.
Yeah, aside from the image that we had, that was the first time that we had a name of an individual who had taken responsibility, yes.
No, you had an image. You didn't have a name.
Did you personally ever meet with Mr. Robinson?
I did not.
And as far as you know, Mr. Robinson did what he said he was going to do. He told the police he was coming peacefully, he was coming with his parents, and that's exactly what happened.
I don't know any of the specifics of how he was arranged to turn himself in terms of what you've described. I just know that it was being facilitated with the sheriff's office.
Okay. Court's indulgence for just a moment, Your Honor.
Yes.
He's redeeming herself a little bit.
Yeah, I agree. I mean, she's hitting good questions.
Thank you, Agent
You know,
Hall.
hitting on the
Attend to
key
the witness,
things
Your
that
Honor.
we've been all harping about.
Redirect by the state.
Just going to go back to a few things that Ms. Nestor asked you about. First of all, the unfired bullet that you referred to. It's your understanding that that bullet was accounted for.
That's my recollection, yes.
Okay, and it possibly belonged to an officer that could have maybe been clearing his weapon.
Yes, that's what I recall being told about that particular item, yes.
Are you aware of
bull crap on that?
If on the 10th there were police officers present that were actually securing buildings and securing rooms there at UVU?
I know prior to my arrival, it was a dynamic and active scene that I believe was originally being treated that there was an active shooter on campus. So there was a large rapid response of law enforcement who were actively trying to clear, secure, and ensure that the campus was safe, if that answers the question.
The entire campus?
Yes, correct.
Okay. And what types of officers were there clearing the campus?
Originally, there would have been probably local units who would have responded, but subsequently specialty teams would have been deployed to do a more methodical search of the campus and what we would call a clearing of the campus.
And those specialty teams and any other officers, how were they equipped? Like what type of equipment were they
I
carrying?
believe most officers carry a sidearm, a handgun, and most officers in this day and age are equipped with a rifle platform as well.
When you said that it was possible that round
Yeah, good
was
point.
from an officer
Absolutely.
clearing his weapon, what exactly do you mean by that?
Our standard practice in our department is to carry a rifle cruiser ready, which
I'm
is
sorry?
we carry our rifles in a situation which is called cruiser ready.
What does that mean?
Means we don't have a round chambered. So if an officer deployed with his rifle, he would chamber a round. Once he had done whatever task it was that he was doing in order to put that weapon back, he would eject the magazine and eject the round. Sometimes in doing so, rounds are dropped or not accounted for.
Have you personally done that yourself?
We do that at training, and I've done that in the field as well, yes.
And you're aware of, is that something that's common among police officers in this situation?
So
I
a cop
believe for
would
most
eject a round and
agencies,
just leave
that's
it
how they
there. He
carry
wouldn't
their
cover the
weapons, but I
round.
can't speak
He would just
specifically to
leave an
agencies outside
unfired
my own.
round on the ground, right?
Do you have any
I
idea
call
how many
total bull
officers
crap.
were dedicated or sent out to clear the campus?
I can tell you I had to park on University Avenue and walk all the way onto campus between hundreds of police cars. So I would say hundreds, if not 1,000 officers, high hundreds would have responded to the campus that day.
And I'm going to ask you about, Ms. Nestor asked you about your observation of seeing Mr. Robinson with something in his hand. And I think she was asking you about Mr. Robinson just prior to crossing Campus Drive, following the shooting. Do you remember that question?
Yes, I think I was asked whether he had a gun in, or I had seen a gun in his hand in the video.
And you said that you did see something in his hand.
Correct.
I know,
I
it's
want you to
crazy.
go back as far as you can remember. At what point, after Mr. Robinson stood up on top of the Losi building and ran across, I believe to the northeast corner, when did you first notice in that video something in his hand?
The first time you can clearly notice he has something in his hand, without a doubt, is when he's
Blind,
on the
deaf,
white
and dumb.
triangular portion on the northeast corner of the
Yep.
Losi building, preparing to jump. It is very apparent he has an item in his hand.
And that's based on your observation?
Yeah, they said it was on another roof.
And
So
is it
you
easier
telling
to
me
see in
that
that
cop was on
enhanced
another
video?
roof? That's
The
another
zoom
weird
version of the
thing.
video makes it a lot clearer to see, yes.
And then after he drops down off of the roof of the Losi building, is there any time between that point in time and making his way to Campus Drive that you believe you see, again, something in his hand?
As Mr. Robinson lands on the grass, it's almost like he either drops it or goes into a crouched position. And then when he returns up from that, it is again clear that there is some kind of an item in his hand, yes.
Can you be more specific or describe in more detail?
It
what that
appears
item might
it
be?
appears to be black, and it appears to be longer.
Okay, anything else
So,
about that?
so he just got caught lying again. He said there's something black
No.
and long in his hand, and that's a lie. It was not a gun in his hand. It was like a towel or a jacket or
I believe it was
something.
Exhibit 9.
It was
State's
floppy.
Exhibit 9 that Ms. Nestor pulled up on the screen. And she had you look at that. And I believe what you looked at was.
Yeah, his
I believe
handlers
was
may
still
not
in
let him
within
go back
a few
tomorrow.
Moments or a few seconds of that video. And that's the UVU tunnel video. Is that right?
The breezeway underneath the Hall of Flags, yes.
And the view is from behind where I believe you testified that Mr. Kirk was on the other side of what appears to be a banner.
Yeah,
Sure.
this
In that
is
tunnel.
commentary. That's
Yes.
what we do.
And on
You
the
know,
other
if
side
you
of that
want to
banner
watch
is
it
the
without
tent and the
commentary,
rest of the
there are
courtyard.
many
Is
of
that
other
correct?
channels you can do that on. Okay.
Do you remember
if you
seeing
don't
the
like what
banner?
we got to say, you're
Yes.
more than
In
welcome
the
to
video?
leave and go watch on one of them.
Okay, and
You're referring to the back of the pop-up tent?
Correct, yes.
Okay, yes.
okay, and do you remember? What do you remember about that banner?
It has some kind of an emblem on it, and it forms the back portion of the pop-up tent.
Is it opaque? Is it transparent? How would
No, you
describe
can't see through it. It's white,
it? Right.
and you cannot see through it, no.
And how much of the tunnel does that banner, I guess if it's opaque, obstruct?
I couldn't say. I'm assuming it's a 20 by 20 gazebo, so it would block out the area of the back of the tent that you can see.
Why
And
do you
you'd not
keep
be able to
saying
see through it.
gazebo?
You would not be able
It's
to
a
see
tent,
through it
not a
from the
gazebo.
audience side of the amphitheater.
And what about the tunnel side of that banner? Can you see through the tunnel side in the opposite direction?
You cannot, no.
Can you see Mr. Kirk on the other side of that
Thank
banner?
you.
You can't, no.
Well, we exhibited, or Ms. Nestor had you watch just, I believe, just a brief few seconds of that video. That exhibit is actually much longer than what we just looked at, or what Ms. Nestor had you look at. Is that right?
Correct.
And leading up And again, I'm referring to
It's a
that view,
circus
that
for
tunnel
real.
view of that surveillance camera leading up to the shot. What's going on behind that banner?
There are representatives, I believe, of
They're just putting on
TPUSA,
a
but there
show.
are representatives of TPUSA. There are law enforcement representatives. I don't know if there's any student body, but essentially people are moving to and fro behind that area. A couple of individuals are retrieving items from a vehicle, but there's consistent movement behind and in that area.
Directly behind the banner.
Correct.
Ms. Nestor asked you about the wooded area that Mr. Robinson entered. Well, Ms. Nestor brought that up, and I believe your testimony has been between today and yesterday that you witnessed Mr. Robinson enter a wooded area on at least 2 occasions. Is that fair to say?
Yes, on his second visit to the campus and on the visit where the incident took place.
At least on those 2 occasions, did the wooded area that he entered, were they different parts of the wooded area, or was it the same parts of
They
the?
appeared to be the same.
You're aware that a rifle was eventually discovered,
Yes,
and was it your understanding that that rifle was discovered in a wooded area?
it was in the wooded area where we believe Mr. Robinson entered the wooded area, yes.
And that rifle was discovered on the 10th.
Yes.
Ms. Nestor asked you about a variety of tips including threats to Mr. Kirk, I think before the event.
Yes.
And did you follow up on those tips?
After tips have been put through a process and been analyzed and screened, anything that appeared to have relevance to either the investigation or a credible threat was managed by the various entities involved, yes.
So managed by law enforcement, so.
Correct.
Amen to that.
Did you personally
Absolutely.
follow up on any of the tips?
That part.
I don't think I personally did, but I worked closely with people who did.
The point is, I guess, is that those tips were followed up on. Is that fair to say?
To the best of our ability, yes.
Okay. And then Ms. Nestor also asked you about tips, I believe, of people.
Did I miss something about
reporting to
Barron?
police
Something's
that they
wrong
felt
with
like they
him?
knew who the shooter was.
Yes.
Let me know in the
So,
chat if there
identities
is.
of possible
I must have
shooters.
missed that comment.
Did law enforcement follow up on those tips as well?
They did.
Ms. Nestor, finally, Ms. Nestor asked you, she asked you whether Mr. Robinson voluntarily went to the sheriff's office down in southern Utah. Is that right?
Yes.
Okay. And that was the Washington County Sheriff's Office.
Yes.
And you understood that he turned him.
Oh,
well,
okay. That's
he
his
showed up
friend
there
that died or
voluntarily, is that
whatever,
right?
right?
Correct.
Gotcha.
What was your understanding as to why he was showing up there voluntarily?
He had informed, I believe, his immediate family that he had been involved
Very
in the
good.
shooting
Thanks for letting me know,
and that he
guys.
wanted to turn himself in.
Nothing further. In the video that
Yep,
we've
got
already
it.
talked about, the video
Thank you,
where Mr.
guys.
Robinson stands up and runs across the top of the LOC building. Is there, do you notice whether at that point, after he stood up until you see him last, at least in that part of the video, do you notice whether he's walking or running with a limp?
He is not. From the time he left after going over the railing, when we see him on the video move out to the position
Correct.
and then leave the position, there is no longer a visible limp or gait.
Thank you.
Ms. Nestor.
No follow-up, Your Honor.
All right. May Agent Hull be excused?
Yes, Your Honor.
All right, Agent Hull, thank you.
Thank you.
We have just a minute to meet if, okay.
All right, let's take a 5-minute break and allowing parties to confer.
Yep.
Court is in a brief recess.
Palantir owns all that property around there. Absolutely.
That's not a coincidence.
Not at all.
Man, he looks like he's getting a little bit antsy in that hot seat now.
Oh yeah. We've got some more here. Let me share this real quick while we're on the wait.
Don't forget to share the stream, everybody. Share the stream, comment, whether you're on Facebook, X, wherever you are, share it out.
Yeah, share the stream out. And again, I'm not monetized on YouTube. So if you want to comment, if you want to leave a super chat, you can use the Buy Me a Coffee link, just like Coach Colin does. Scan the QR code down there on the left side of the screen, down the left corner of the screen right there at the bottom. You can scan that QR code. It'll prompt you to leave a donation, whatever amount you want, and then leave a comment, and we will read your comment out just like a super chat anytime we get a break. Which, by the way, we're on break now, so let's go ahead and do that. And, him and I are going to split any of the donations that come in today. So, I would appreciate if you guys could help out. That way we can pay our guest host for today. Give him a little something for coming on here as well.
And I'm going to send 90% of my proceeds to Israel. So make sure you're sending as much as you possibly can.
And I'm going to send mine to Erica Kirk, obviously, because I just love her so much.
I'm going to send it to the settlers in the West Bank.
As if Erica Kirk didn't raise enough money already, millions and millions of dollars off Charlie's death.
Yeah, so she's taking her
All
sugar
right,
mama
so-
applications for you boys out there that are single, and you.
Hey, she's not single anymore, man. She's dating Blake Wynn. She's off the market now.
Oh, dang, that was quick.
Yeah. That's honestly, that's the comment. You were talking about the comment that she left on my page or whatever. That's what it was for. She commented on that when I exposed her and Blake Wynn having a date at the Beverly Hills Hotel. That's what she was commenting on, which she told me to go dust off the Dorito fingers or whatever. Dust the Dorito dust off my fingers or whatever.
She was getting the dust knocked off herself, all right. Her old nasty
She was,
self.
according to the witness, she was. He was all up on that booty.
Oh, they some sick animals.
They are, man. Medusa USI sent us a buy me a coffee. Says thanks for day 2 of the prelim. So thank you very much. We appreciate your support. I saw you donated us yesterday as well and left a comment. So thank you for that as well. We appreciate all your guys' support. Definitely helps us out because we're independent. We don't have the big
Handlers.
bucks. We don't have big huge conglomerates, handlers, whatever, funding us. So yeah, thank you. Definitely. We appreciate that. And let's go back to this one now. Okay, so this here is supposedly, let me read this. What it says. It says Charlie Kirk's family and Tyler Robinson's relatives are pulling up to the Provo courthouse for day 2. So that's what we're about to watch, apparently. The ones walking up now, I believe, are Tyler Robinson's family. That's Tyler's family, I think.
That's his mom or what?
Mom and dad, I think, yeah.
Well, hopefully they see the stream.
And then
Free
this
Tyler.
is Free Tyler, yep. And then this is Charlie Kirk's parents again, right there.
Mm-hmm. Justice for Charlie, man.
That's what it's all about, man. We want to free Tyler and get justice for Charlie. That's our goal from day one, and I'm not going to stop until we do.
I wonder
There's
if they
nothing
got.
that's going to stop me.
I wonder if they got Tyler Robinson all dosed up on psych meds while he's incarcerated.
They probably do. You know, I know when I was in jail, they kept trying to push me on psych meds and stuff. Oh no, that's I think that's Tyler Robinson's father, actually. Okay. And then, of course, we got Talmud Tatum entering the courthouse again for day 2. Can't forget Talmud Tatum. Hold up, did he just get money? Did he just get a big handful of money? Let's go back again. Watch that.
Let's see the hand.
Oh shit. Did he just, it looks like he might have just gotten a big old wad of money, doesn't it? It looks like it looked like he's got bills crinkled up, like he was handed a bunch of bills crinkled up.
He probably got some gum because his breath stank. He talks too much.
Yeah, actually, I don't think.
Stanky breath Tatum.
Yeah, stanky breath Tatum. Stanky breath Tatum.
Cry baby Tatum.
Talmud Tatum. Cry baby stinking breath Talmud Tatum. That dude's a trip, man.
He just lets us know he takes that $7,000 check, man.
Oh, he does, man. He's so obvious about it.
I heard that there was
honestly,
some
the
loss.
craziest-
Did you guys hear? Let
What'd
me
you
know in the
say?
chat if you guys heard about that lawsuit going on. I don't know if it was with Netanyahu over the influencer campaign because they weren't getting paid their money or something. Did you hear about that, bro?
No, I didn't. Is there a lawsuit over that?
I think there's something going on where influencers weren't getting paid. I got to go look into that. Yeah, Mumble Mouth Tatum.
Yep. Yeah, definitely. That's something interesting. I'd like to know about that if it is.
They treated us good in Israel. Only one pastor I was with got spit on.
Yeah, the only thing that's weird about Tatum is, he used to be friends with Candace Owens prior to all this, right?
Yeah.
And he actually owns the merchandise store that Candace sells all her merch through, which just is wild to me. That he's such a hypocrite that he rails on her constantly. He says she's demonic and this, that, and the other, right? But yet he's still profiting off of her merch. Every time she sells merch, he's still profiting off her merch.
Yeah, they might have a contract in place or something, but
Well, I'm sure they do, but you would break that contract if you really felt that way about something. If you really felt she was demonic and all this stuff, you would break the contract. I mean, that's what TPUSA did. Candace still had a contract with TPUSA, but they didn't like that she was talking bad about them, so they broke the contract.
yeah.
So the fact that he still is collecting money every time that she gets merch is like, to me, that just says he's the biggest hypocrite in the world, and he's so fake. He has no values, no morals whatsoever. Basically all he's there to do is just collect the paycheck. That's all it is to him. Just collect it. Whoever pays the money, he'll just spout whatever they want. And as long as he's getting paid, he doesn't really care.
Sounds like a cheap hooker.
Yep. Yeah, exactly. She was on the, I think the committee for the Brexit or whatever, and they canceled her contract. Oh, you're saying Tatum was also? Yeah, definitely. Yep. The Discord confession has been proven to be fake. It didn't come from Tyler because he was already in custody. Yep, absolutely, 100%. Like we talked about that, Barron was the one that was able to uncover that, but the 11th, when he turned himself in, the Discord messages were actually written like 2 hours later in the evening after he had already turned himself in. So there's no way that it could have been Tyler that wrote those Discord messages, because he'd already turned himself in. He was already at the sheriff's office, and they'd already confiscated his phones and everything. So there's no way. Another thing that's just really weird that tells you that this is a massive psyop, a setup, is the surveillance video that we're talking about that they showed where he jumped off the roof of the Losi Center or whatever.
Yeah.
That surveillance video, they did not release until after Tyler had already turned himself in.
Mm-hmm. You should go to that, bro.
Why-
and we
why-
should
why-
zoom in on it and slow it down when he's at the corner about to jump off, so people could see that he had a jacket in his hand. There was no rifle. See if you can find that,
Do
bro.
you have it? Yeah, let me see if I can find it. I don't know if I don't have it right. I don't have it easily
Actually, you know what?
accessible, but
Let me get it out of my phone real quick.
all right.
Let's see, when would I have done that? Maybe.
Tyler jumping off Lucy building.
Yeah, you'll probably find it before me. Candace Owens said, "How tall
Jumping
is Tyler
off.
Robinson?"
Rosie. Where? Here?
No, she said it on X.
Oh, okay. Yeah, he's not. That's why I said that's not Tyler Robinson. It doesn't look like Tyler Robinson.
No.
The height doesn't match. The ears don't match. Nothing matches.
Mhm. I mean, Tyler, that Officer Hull is really making, like, when he talks about
Yeah, Tyler Robinson is.
like, it's for certain, like, that's Tyler, like, nowhere in any of those videos can you man, they're really trying to cook him.
Yeah, Tyler.
You see-
Candace confirms that Tyler Robinson is 5'10". So there's no way that's him in those videos.
I mean, here's the thing, though, is that people need to
There's no
understand.
way.
Before this incident happened that day, they were scouting that campus for months before the event. At least a couple of months before the event, they started scouting. They knew where all the cameras were. They knew where everything was. So when they had their assets in place that they were going to basically depict as being Tyler Robinson, they knew where those cameras were. They knew when they would walk in, there'd be a camera right there. And then when they got to the corner, there'd be another camera. They had that place mapped out perfectly. That's why when you see that guy walking down the stairs, like Gardner said, Gardner Batty, you see him turn his head. Never did he look up at the camera.
Exactly. See, my problem now is I'm getting all the new footage that keeps showing up. I'm not getting all the old, the old footage is not showing up. Now the stuff that they just put out today is the only thing I'm getting showing up now.
All right, let me look. Let's scroll on down. Let's see.
Give me a link to the video. I'm asking Grok now. See if Grok can find it.
Pretty sure it's on my page too. Let me scroll.
Okay, I think I might have found it. Yeah, I found it.
Did you?
The video and that we have of the suspect, as well as some new stills. Those have already been released, but we want to make sure that they get as much attention.
So here you see the suspect ran behind that upper building. He's going to come out on the right, moves to this far right corner. As he does, he's going to climb off the edge and then drop down to the ground. As he did that, he left some palm impressions. There's some smudges, some places we're looking to collect DNA. There's a shoe imprint where we believe the suspect is clearly identified as wearing.
All right, so did you see that, bro?
Yeah, I'm looking for a better one that I have that I zoomed up on.
So it's floppy. You can see it's floppy. You can see what he's got in his hand is flopping around. It's not hard rigid. It's not a gun. It's like a jacket. He's got a jacket or maybe a towel or something, but it's definitely not a gun.
No, it's
See?
definitely
No
not.
way.
Go put a broomstick in a towel, wrap it with a towel, and tell me if there would be that much looseness in that towel if you have something under it like that.
Yeah. All right, we're back on. Let me go ahead. We're back.
We intend to call Jennifer Falmouina, but before I do that, I move the admission of State's Exhibit 5.1, if I can approach the bench.
Yes. Thank you.
Your Honor, there will be an objection, and we want to be heard on the objections. And I didn't know this was coming now. It could be a lengthy call.
All right. Let me just, do you wish to identify what State's Exhibit 5.1 is?
Yes, Your Honor. Exhibit 5.1 is a self-authenticating 1102 statement issued by David Engelhardt from Turning Point USA.
All right.
And
who is David Engelhardt?
Yeah, again,
I've never heard of that guy. Have you?
As you can see there, it's got the admonition on
No,
page
I haven't heard of him.
The body of the 1102 statement is there on pages 1 and 2. I would say number 4 is kind of the foundational statement, paragraph 4, but the self-authentication portion is the notary acknowledgement on page 3.
All right. Turning to Mr. Novak.
Thank you, Your Honor. Thank you, Mr. Finkelrod. So the court, obviously, because the court can decide how much of this we discuss in open court, how much we discuss at the bar, so to speak, sidebar. There's initially a fundamental relevance problem with this 1102. There are also, there are other issues, but I think that just to help the court parse the evidentiary issues, we should start with the relevance. There are sub-issues. There's also a problem under 1102 because if the court looks at the last paragraph of this, Mr. Engelhardt, who is the purported author, refers to himself in the third person. So it's not clear to me who actually wrote this report. And as Your Honor knows, 1102 says
that makes it sound like
prosecutors
Andrew Colbert might have wrote it for him.
Witnesses in writing their own 1102 reports. That's not my primary concern, although I think it is an important issue because that's what the rules require. But the real question is relevance. And I guess the question is, does the court want me to do the speaking objection? Because the court said no speaking objections. Should we approach sidebar? How does the court want to handle it? The people can move their exhibits into evidence whenever they wish. I wasn't aware we were going to do it at this moment. I'm ready to proceed, but the question is how the court wants to handle these objections. I'm prepared to keep going in open court, but it's what the court referred to as a speaking objection.
No, I appreciate that. As it relates to, well, so here's my question for you, Mr. Novak, as you're, and again, I appreciate your discretion in highlighting that point. Do you anticipate your argument being of the nature that would defeat the purpose of, if the court does not admit this, that you've already let the cat out of the bag with your argument, or do you feel that you can make your argument without compromising what is in the 1102, so the purpose of if excluding it is still preserved?
I'll go as far as I think we can go, and then we'll just see. I mean, I do think I am not trying to conceal from anybody in the courtroom or the public our concerns about relevance. So why don't I, taking the court's lead, go forward publicly with my concerns about relevance. And if we reach a moment where it feels like further argument may deprive Mr. Robinson of his fair trial rights, we can approach.
All right, we'll proceed.
Okay, so then what I'm going to do is I'm going to point out that this proposed exhibit, which is the 1102 statement of Mr. Engelhardt, is basically 4 paragraphs. The 4th paragraph identifies Mr. Engelhardt, although I say in the third person, as a pastor and as an attorney who was a friend and a counselor to Mr. Kirk and was involved in leadership of Turning Point USA.
That sounds like a bunch of hogwash.
So that identifies
the guy.
who the author is. Beyond that, it's not really relevant to any of the issues before this court. Paragraphs 1, 2, and 3. Paragraph 1 talks about Turning Point USA's status with the Internal Revenue Service, the purposes of Turning Point USA.
Why is any of that relevant? None of that matters.
Within the context of the Internal Revenue Code.
Oh, this is total.
And,
this is total Fed slop bullshit.
What
that
I'll
has
just refer
nothing
to
to do with the
generically as the
murder.
goals and objectives of Turning Point USA. And it
Who
also then
cares?
talks in the second paragraph about Mr. Kirk's relationship with TPUSA. None of this is unknown information, that he was a founder, that he was the chief executive officer, that he was the president of the board until his death. So I'm still not sure what the relevance is. And I guess actually what I should say is I don't believe there is any relevance of any of this information. Paragraphs 2 and 3 are, and actually I'm going to preface this. My discussion of this is within the context of the rules of evidence. And there's nothing that I'm going to say here that is meant to derogate, criticize, question Mr. Englehart's beliefs. What he says were Mr. Kirk's beliefs. What Mr. Englehart says he believes are tenets of Christianity. That's not what we're talking about. What we're talking about is whether this document is admissible in this proceeding under the rules of evidence. Okay. So paragraphs 2 and 3 include not only Mr. Englehart's opinions, and now I'm going from relevance to opinion evidence. It's not clear to me whether it's lay opinion evidence, whether it's expert opinion evidence, but it's Mr. Englehart's opinions about a branch of Christianity, his opinions about a portion of the Bible. He quotes the Bible, and he talks about Mr. Kirk's religious beliefs. And I could go into more detail, but the court has the exhibit in front of it itself. So none of this is relevant. If the court looks at the information, that is the document which lays out the allegations against Mr. Robinson, when I use the word information, I'm talking about the court document. There are, with respect to certain counts, what Utah Code refers to as a victim targeting enhancement. That is alleged with respect to count 1. It is alleged with respect to count 2. It is alleged with respect to count 7. And may I step away just to get my laptop?
You may.
And as the court knows, but I want the record to be clear, when I refer to the what the information calls the victim targeting enhancement, that's Utah Code section 76-3-203.14, which the code calls the victim targeting penalty enhancement.
Once again, why they chose Utah
the information
to do this, because they got these stupid ass rules.
And this is, I'm emphasizing this, that Mr. Robinson intentionally selected Mr. Kirk because of Mr. Robinson's belief or perception regarding Mr. Kirk's political expression. And I'm going to focus, if I may, the court's attention on two things. One is, whose state of mind are we talking about when, or whose state of mind is the statute talking about? And what aspect of the victim targeting enhancement is being invoked here? The latter is the state invoking Mr. Kirk's political expression, and now I'm quoting the statute, as the personal attribute that the state alleges is the gateway to this penalty enhancement. And if the court will bear with me, because there's a reason why we have these hearings in public, there are various categories for alleging I should say, there are various categories of personal attributes. That's the phrase the legislature uses, which authorize the pursuit of a penalty enhancement. And those personal attributes are listed in the statute A through R. I'm not going to read all of them because the court knows the law, but political expression is subsection K. That is separate and distinct from the personal attribute that the legislature calls religion, which is subsection M. So what we have is an allegation that the personal attribute, which is one of the elements of this enhancement, the allegation that Mr. Robinson selected Mr. Kirk was based on his political expression. That's actually the exact same phrase, political expression, as is in the statute subsection K. The 1102 statement is predominantly about what Mr. Engelhardt describes as traditional Orthodox Christian values that he believes in, that he believes Mr. Kirk believed in. And I understand in today's world that there is a crossover between religion and politics. I think we can all acknowledge that. But the legislature and the information
they're trying to claim that Charlie was, a Jew lover, so therefore Tyler Robinson killed him because he's anti-Semitic.
Mr. Engelhardt goes far beyond the
he's going to use the furry theory,
if the state has it, to prove that Mr. Robinson targeted Mr. Kirk. Because
either way, it's
Mr.
completely unnecessary. I mean, they already seeking a death penalty regardless. I mean, how much more
belief or perception concerning Mr. Kirk's political expression. The second element of this is that the victim targeting enhancement focuses on the allegation of what is in Mr. Robinson's state of mind, not what is in Mr. Kirk's views or deeply held beliefs, sincere religious beliefs.
And this Engelhardt guy at TPUSA doesn't know what Tyler Robinson's state of mind was.
Or said, or what TPUSA stood for. It's what was in Mr. Robinson's head, if anything, about selecting Mr. Kirk because of Mr. Kirk's political expression, because that's the information. So why TPUSA exists, what its founding beliefs are, what its leaders' beliefs are, what Mr. Engelhardt believes Christianity is or is not relevant. And that's why we think it should not be received into evidence. There's a second level here, which is Mr. Engelhardt's statements about what is in the Bible, specifically Matthew chapter 9. And so I would just ask this court the hypothetical question. If the state asked the court to take judicial notice
chapter 9
of a portion of the Bible,
let's look that up real quick,
in order to prove this enhancement.
Yeah, look that up.
I can't see where else it fits into this case.
Why would that matter? That has no bearing or relevance in the case at all.
So instead, what we have is the state trying to use the affidavit of Mr. Engelhardt pursuant to 1102 to get the court to essentially receive into evidence the same information. It doesn't really matter here in this proceeding what the book of Matthew says. It doesn't matter what Mr. Engelhardt thinks. And again, I say this with all due respect to Mr. Engelhardt, who I've never met. The book of Matthew means, or how one reconciles the book of Matthew as he sees it with other views on the topics that are there. I mean, I want to be careful and not suggest what other views are, because I shouldn't be testifying about different perspectives within the sort of the heading of religion. But it doesn't really matter for this proceeding what Mr. Engelhardt's views are, what Mr. Kirk's religious views were, what religious views TPUSA endorses, seeks to encourage
I'm not really
others
seeing where he
to
would
adopt.
be referring to on chapter 9.
None of that really matters. There are multiple opinions in this 1102 from Mr. Engelhardt, and it's not clear whether the state has thought about whether it's expert opinion.
Anybody in
or
the
lay
chat who
opinion.
thinks they know which verse
I
he's
happen to think
referencing
that
to
it's
in
expert
Matthew chapter
opinion
9
that is
posted in the
not
chat.
helpful to the trier of fact in this proceeding. That's your honor. There is nothing in this that helps the court resolve with respect to the victim targeting enhancement, whether Mr. Robinson intentionally selected Mr. Kirk because of Mr. Robinson's beliefs or perceptions regarding Mr. Kirk's political expression. If the state comes back up here and says, no, it's lay opinion, we still have
I
the
think he's
question of
talking
whether it's
about the
helpful to this
alphabet
court,
community comments.
because the court has
Oh,
to
yeah?
decide whether there is evidence of the target enhancement in the way I think I've structured it. So it's not relevant. It's not admissible lay opinion. It's not admissible expert opinion. There are two aspects of Rule 403, one of which I'm prepared to talk about publicly, and one of which I think is appropriately discussed at sidebar, because it does get into undue prejudice. The 403 here is that receiving this document into evidence is going to create confusion. It's going to create chaos, not by the trier of fact, but by the future jury pool in this case. For this court to make a ruling that Mr. Engelhardt's opinions about religion, about TPUSA's views on religious matters, that Mr. Kirk's views on religious matters are in any way what this case is about, is going to create significant confusion. And even if this court doesn't show the 1102 in open court, or the reporters who are here don't get to see it, or if the public doesn't get to see it, receiving it into evidence in light of the victim targeting enhancement that the state drafted and charged is just going to create confusion. There may be, outside of this case, litigation where TPUSA's purposes and its mission and its adherence to its mission are important, and Mr. Engelhardt's opinions about that may be important in some other context, in litigation, in public discussions. It's not important here. When I say important, I'm saying it's not relevant. So there's a 403 issue with respect to confusion. There's a constitutional concern that this type of evidence being sanctioned by the court is going to suggest to the jury pool that this is a case about religion. This is not a case about religion. The state doesn't even allege this is a case about religion. The state alleges one enhancement based on Mr. Robinson's perceptions of Mr. Kirk's political expression. So I'm very concerned that
Matthew
this
9:13,
document even being
go and
sanctioned
learn
by
what
the
this
court
means.
as
I
admissible
desire
for any purpose in this
mercy, not
proceeding
sacrifice.
is going
I have
to
not come to call
interfere
the
with
righteous,
Mr. Robinson's
but
constitutional
sinners.
right to a fair trial, which I think is a sort of an umbrella
I don't
over
know if that,
parts of Rule 403.
I don't really
If at
get
the time,
how
if there
that
is a trial,
has
if
anything to do
Mr.
with the trial,
Robinson
though.
is bound over, and if there is a trial, and if the state wants to proffer Mr. Engelhardt for some specific evidentiary
Yeah, I just went
purpose,
through chapter 9 and I'm not seeing
that I'm
anywhere where he
missing,
could be
um,
referring to.
then we can engage in that. But it seems to me that it's, again, a mixture of lay
Exactly.
and expert opinion, which at this stage is more prejudicial than probative. The other part of the 403 issue we can discuss at sidebar whenever the court's ready.
Thank you, Mr. Novak. Turning to the state. And so just to give an overview, what I'm intending to do is address what Mr. Novak has presented, the state respond. I may have some questions limited to what's been presented now. Of course, that doesn't preclude addressing the second portion of that in whatever means is necessary to protect constitutional rights. But we're just focused on this portion right now.
Understood.
Thank you, Mr. McBride.
Exactly,
Your Honor,
Sarah.
the evidence is relevant to 2 points. One is to the defendant's motive, which is not an element of the offense, but nonetheless is powerful evidence.
They don't know the defendant's
persuasive
motive. That's
evidence.
the whole thing.
And
How
two,
are they
it is
supposed to
relevant
know
to
the
the victim
defendant's
targeting
motive?
enhancement, which has been described and appears in the information. The statement clarifies what Turning Point USA, what Charlie Kirk's business was. And I think as you read this statement, it's clear that Charlie Kirk presented both religious and political arguments and positions in his presentations. And that is what paragraph 3 says, that he engaged others in debate, discussion of traditional family values, Orthodox Christian views on sexuality, marriage, gender, sex, America's founding principles, political doctrines, and so forth. He often spoke specifically and attempted to persuade attendees to follow a mindset rooted in Orthodox Christian and politically conservative values.
Okay, so he's exactly.
The
He's
admissibility
basically
of, and I'd ask the court
he's
to
trying to read
strike
it
his
into the court
statements
record,
and admonish him.
even though the judge is like saying no.
So as it relates to
He's trying to get
reading
that
from the
statement in
actual
regardless.
1102, because it's not admitted into evidence, I will, well, before I do that, let me turn to you about the objection to.
This guy's a
that you were
sneaky
heard as well.
SOB, man.
Yes,
This
Rule
prosecutors are
104
snake.
requires the court to consider evidence before determining its admissibility. How can you determine whether an exhibit is admissible without knowing what is contained in that exhibit?
He
That's
can
what
look
I'm
at
putting
it.
in
You don't
front of
have
Your
to read
Honors,
it out,
explaining
moron.
this is why the exhibit is admissible, because it contains this language that is relevant and probative. I don't know how I can make an argument something's relevant and probative without saying this is what the exhibit says.
Well,
By showing it to
Mr.
him,
Novak,
giving it to him. You don't
and I
have
want
to
to make
say
sure
it.
I do see you have
He's
a
trying to
microphone.
play
Go ahead.
stupid.
Your Honor is not a jury. Your Honor can look at the exhibit and determine for itself whether it's relevant, whether it
Exactly.
meets other criteria for admissibility. It's not necessary for Mr. McBride to read aloud in open court an exhibit which court has available to it. I'm not saying that the court shouldn't read it. I'm saying that it's not admissible. I understand that the court has two roles, one under 104 and one as the magistrate, but that doesn't require Mr. McBride to read in open court the exhibit which we are discussing the admissibility of, especially where I have just expressed our concern that the exhibit has a tendency to infuse the issues in this case and create fair trial risks for Mr. Robinson.
All right, thank you, Mr. Novak. Any final thoughts before I rule on this specific issue about reading from the 1102 by Mr. McBride.
Yes, Your Honor. I have to be able to argue here. I have to be able to refer to the exhibits. I can't do my job as an attorney without being able to refer to the exhibits. If the court doesn't want this to be in public, then we've got to close this proceeding, but I have to be able to argue the exhibits. I don't know how I can make an argument without actually pointing to the language of the exhibits, unless I want to say, you know what I mean, or referring to line 13. It's just so cumbersome to do, Your Honor. And I think my job and my duty to my client, which is the state of Utah, and
this guy is such a
their
snake.
right to fairness requires me to make a good and powerful argument, and that requires me to refer to the exhibit. And I'll submit it with that.
All right. Thank you to both of you. In looking at this, typically in court, when evidence is being taken, until it's admitted, it doesn't come in. For
Gotta
example,
have
there's a
that
witness
cold
on the
brew for this
stand,
kangaroo
and
court.
one is
Man.
going to get a piece of evidence in. That witness cannot read from
It's
the
getting
document
wild today, man. I know.
prior
Big
to
time.
it being admitted into evidence. And so the court applies that same principle here. However, the difference is, in noting Mr. Novak was drawing points from this specifically. He mentioned Matthew, I believe, chapter 19, and talking about certain points in here specifically. There is room for it to be mentioned in argument in order for the court to fully consider what's before it. I'm going to sustain Mr. Novak's objection and simply say, if you want to talk about it conceptually, talk about the points, you certainly may, but simply reading from it exactly saying, and I understand, I don't want to constrain either party from being able to make their full argument, but quoting from it in open court, I fear does risk issues to the constitutional rights of the parties. If the parties prefer to go into a closed evidentiary hearing on this issue in order to be unrestrained, and it appears Mr. Novak is requesting that for a second portion of his argument, we certainly can do so, because I do not want to put out evidence that is not admitted in open court until the appropriate time, until the court has gone through its decision-making process on whether it should be admitted or not. So to the parties, if you feel you can move forward on this first portion of it, I'm happy to entertain that argument. If the parties feel at this point, at this juncture, that a closed evidentiary hearing is needed in order to fully explore all the issues, I will leave it to the parties, because I don't know your arguments, and I don't want to constrain you from saying, well, I don't know what you're going to say, but I can't read your minds, and the court will stay in its lane to ensure that it's in the proper judicial role. So the objection has been sustained to Mr. McBride.
So he did rule in his favor.
Response, the rebuttal to the argument by Mr. Novak.
But I think they're going to go into closed session.
Yes, Your Honor. I do not believe it's necessary to close this hearing. I would argue against closing the hearing on the admissibility of this exhibit. However, the court needs to rule on that issue before I launch into the fullness of my argument, because I do not want to be admonished for discussing an item that I'm asking to be admitted into evidence in public. So I would ask the court to make a ruling on the closure of the argument about the admissibility of this hearing, so that I can make that argument unconstrained. And after that time,
the judge is incompetent. Yes, the judge. And the prosecutor is a snake.
Well, what I'm trying to do is, you've heard the reasoning of the court. I don't want to constrain you. If you're saying, as you stated, that you want to best represent your client, and every attorney should be doing that, that is your duty. I don't want, if you feel that closing this hearing to the public is necessary in order for you to fulfill your duty, the court will entertain that. But I can't have it both ways. If you want me to close the hearing in order for you to be fully be able to argue freely as you feel you need to, I will entertain that. But I don't want to say, well, I'm not going to close the hearing, and then suddenly the issue is, well, I wasn't able to make a full argument. And so do you need a closed hearing to make a full argument to best represent your client?
I think defense counsel is asking to close the hearing so that the argument can be made without the public seeing it. I do not want to close the hearing. I do not believe it's
No,
necessary.
we want to
close the
see
hearing.
it.
That's not my motion. I do, however, want to make a full argument that requires me to rely on the evidence and quote the evidence as I have done. That's my position. If I am not permitted to quote the evidence in my argument, then we need to decide whether or not this hearing should be closed. I would oppose closing it, but I do think it's necessary for me to quote the evidence.
All right. Are you able to make your full argument to the best of your ability to best represent your client by simply referring to the paragraphs and to the lines so it is clear to the court what you're talking about? There's no ambiguity without quoting it verbatim in open court.
No, I don't think so.
All right.
Your Honor, if you're going to make a closure ruling, I'd like to.
This guy's such full.
All right,
He's
I'll
so
hear
full
from
crap,
you
man.
as well. If you would like to come forward, again, just Mr. Reimer, just stating your full name for the record, for the clarity of the record.
Sure. Thank you, Your Honor. David Ryman again for the news media. We have briefed this issue a couple different times so far. Sometimes there is a misconception that I think is running, particularly through what Mr. Novak argued, that suppression hearings, because the evidence may be suppressed or excluded, or in limine hearings, need to be closed unless the evidence is deemed admissible. That is the opposite of the law. That has been settled since the United States Supreme Court decided Waller versus Georgia. You can see it in Kearns Tribune, which dealt with a preliminary hearing and access to a preliminary hearing where, as you know, and as we've heard repeatedly today, all kinds of evidence is presented at the preliminary hearing that may not be admissible at trial. And so the universe of the public's right of access to proceedings is not limited just to what eventually gets admitted at trial, which, you know, if there even is a trial. And we've cited the court to, you know, numerous cases on this, and I don't have the brief in front of me, and the docket is huge, and I can find it for you if you'd like. But I just wanted to correct the misimpression that the public is not entitled to hear argument and to see evidence just because it may not be admissible. Otherwise, we would never have admissibility arguments in public. And I do want to I'll just make one other point. Kearns Tribune also speaks to this, and that is that if you do decide that there's and so let me just make two quick points. To the 403 point, just because evidence isn't admissible is not a basis to close the hearing. There may be a 403 argument. I haven't seen this document. I don't know what's in it. Maybe there is something incredibly prejudicial. You would have to make that decision. I'm at a loss. I haven't seen it. I'm happy to take a look at it and give you substantive argument, but it's the same high constitutional standard that you have to satisfy in order to close it. And then the last thing is just on the scope of any closure. Kearns Tribune speaks, and I know the court is aware of this. If you are going to close it, it needs to be as minimal as possible. And it's my experience, at least, that most of the argument about things in this context can occur in open court.
Exactly.
And
the
if you
whole
want
thing
to have,
is irrelevant.
you know,
This is
a
just
closed
fluff
session
that
or
they want to
sidebar,
read
or
about.
however, you have also done it in chambers. I just ask that it be as limited as possible. Thank you.
Thank you. All right, Mr. Novak, and it appears like, would you like to respond to that before, and then I'll return to Mr. McBride for any final thoughts, and the court will make its ruling.
Well, I just wanted to mention the Utah Supreme Court decision in State versus Archuleta, 857 P. 2nd 234, where this state's Supreme Court reminds us that the First Amendment right of access is qualified, and that what needs to be carefully judged in light of the qualified right of access with respect to preliminary hearing exhibits, that was the issue in State versus Archuleta, is the defendant's right to a fair trial. So we're in this slightly twilight zone situation where counsel for the media is saying, even if the court has decided that the exhibits are not going to be made available for copying and inspection, and the court may decide that this exhibit is either not admissible or admissible for the court's eyes only, counsel for the media is counseling that the court permit Mr. McBride to read the exhibit verbatim in open court. And that basically defeats all of those principles. So I don't think that's the correct path. Counsel for the media is correct that the court's sealing or closure should be narrowly tailored. And the 403 issue, which we are prepared only to discuss because of the sequencing of things in this case, in this proceeding, we're only prepared to discuss at sidebar, has to do with potential future evidence that the court may receive in this hearing, or it may not. So I'm not going to address other 403 issues in open court. If the court wants to defer this entire exhibit and discussion of it until later in the proceeding, then it may be that part of the 403 argument doesn't need to be at sidebar. And I think we're all assuming that sidebar proceedings in this preliminary hearing are going to be part of the sealed transcript until some later point in time. In other words, it's not sidebar just for the moment, it's because the transcript's going to be sealed. So it very well may be that taking this issue up at a later point in time in this proceeding eliminates the need, from our perspective, for that 403 issue to be discussed at sidebar, or at what counsel for the media says in a closed proceeding. However, I agree with the court that Mr. McBride can't have his cake and eat it too. If he wants to make his argument and he thinks that his argument requires that he read an exhibit in court, which we in good faith are saying is not admissible, then we need to have a closed proceeding. I'm not asking for a closed proceeding. I was asking the court to caution Mr. McBride not to read into evidence exhibits that are not received into evidence, because that's the same as Mr. McBride testifying.
All right, thank you.
I mean, you couldn't
Anything
just say
further,
the
Mr.
last
McBride?
2 seconds, bro. You had to do all that talking.
So note, I
and
have
you
not
could've
made my
your
full
point
argument
in
on
20
admissibility, that's
10
all.
seconds.
All right. All right, I
I
appreciate
have,
the arguments by the parties. This is clearly something that's very important to you all and is important for this case, as is every piece of potential evidence. I note that Mr. Novak indicated that receiving this could create confusion for future potential jurors. And that he mentioned that it could suggest to a potential jury pool that this case is about religion. However, what is happening at a preliminary hearing is far different than what happens at a jury trial. The magistrate, myself, is the fact finder.
It's not about religion. It's about the Epstein class.
Whether something becomes admissible at trial is far different than what is admissible at a preliminary hearing. The purposes are different, the standards are different, and different steps need to be followed. Something could become admissible at a jury trial, but given the nature of a jury trial, more steps are necessary. Under Rule 1102, one of the major differences is that reliable hearsay is allowed in a preliminary hearing under the Utah Constitution and under the Rules of Evidence 1102. That is far different than what would happen at a jury trial. Taking this into consideration, I look to the information going to the very beginning, whether this is relevant. And as noted by counsel, looking to count 1, which is squarely before the court, to determine probable cause at the end of this proceeding. And the court is not weighing in whether it will reach that or not. It's not predetermining anything, but what is before this court under count 1, aggravated murder, which is a capital offense, victim targeting enhancement in violation of Utah Code Annotated 76-3-203.14 sub 2. Tyler James Robinson intentionally selected Charlie Kirk because of Tyler James Robinson belief or perception regarding Charlie Kirk's political expression. And so if that was not here, this enhancement, and it also goes to count 2, felony discharge of a firearm causing serious bodily injury. And I'm just reviewing. And then finally, count 7, violent offense committed in the presence of a child, where the victim targeting enhancement also is in play. Because that is part of the information that's squarely before the court, this becomes relevant. Now, trying to determine what is political expression versus
of a child,
religious expression,
because of the prosecutor's daughter who was there.
That goes into different
day,
grounds, but at this point, the court finds it is relevant for consideration, and if for the very least for argument. What the court is going to rule is that the need for a closed hearing is not been met at this point, because what needs to be shown is prejudice, or that the exhibit contains inflammatory information that would prejudice the jury pool. That begins the path where we can consider closing the hearing from the public. However, that's not what's before the court, nor has the court heard that. And so the ruling of the court is, previously I sustained Mr. Novak's objection, and the court will expound upon that Mr. McBride in his argument cannot read the entirety of State's Exhibit 5.1. Can he reference points of it and specifically quote certain points? The court rules that he can, just as Mr. Novak pulled from this, and it was broad, but he quoted Matthew chapter 19. He stated that this came from the Bible. He talked about the going from paragraph 1 where he quoted, or at least drew from, about the Internal Revenue Service and the type of business. And so there is grounds for that
chapter
to occur
19?
in order for the court to consider
Or
the
9?
argument fully and making the determination whether it is relevant and should be
Thought I
admissible.
heard him say 19.
Therefore, the court rules that Mr. McBride can continue in his arguments in order that the court
I think he said 19,
can
but
make its
that doesn't sound
determination
right.
whether State's Exhibit 5.1 is admissible or not.
Thank you. 5.1 is a general explanation of what Turning Point USA, Charlie Kirk's organization, is and was on September 10th. The exhibit describes the events that Turning Point USA holds, talking about at least 200 plus of these events featuring Charlie Kirk as a headline speaker had taken place by that time. That's in paragraph 3. That these events discussed political issues as well as religious issues. Most political issues in the portion I previously quoted talked about gender issues in particular, gender, sexuality issues, the difference, or the
Alphabet
Christian
community
and political view regarding marriage and families and gender identity. And that information is relevant to the motive that we are alleging in this case.
See, that's the picture they're trying to paint of why
it's also relevant to the
he
victim
assassinated Charlie Kirk,
which is
because he
in part
offended
a
his
motive-
alphabet
a motive type
community.
enhancement. And the evidence will
Exactly,
be
and
introduced through,
that's
we
total
will offer
bullshit.
evidence through other witnesses that talks about some of the defendant's statements.
That's the
indicate,
Fed slop narrative that they
his,
wanted to set up, but obviously
gender
that didn't go as
persuasion,
the plan.
and that he falls into some of these political and gender views that Charlie Kirk argued against. That's the relevance of this statement, is it shows Charlie Kirk publicly in front of large gatherings of people debated and presented his views, his political views, which were tied to his religious views about gender identity, LGBTQ rights type issues. And the relevance to that is the defendant's motive is that he was on the other side of those views. And you'll see evidence that talks about that through other witnesses. That talks about that being the inference and the motive that he had, or the inference from that evidence supports that motive, which supports the victim targeting enhancement, and frankly, motive in general, which goes to identity. For that reason, Your Honor, this exhibit is relevant. I don't see the prejudicial effect, unfair prejudicial effect this would have on the fact finder, whether or not it has, some.
How isn't Tyler Robinson jumping out of his seat and saying something?
Completely different question. I don't think it does. I think this case has already highlighted the political issues that
they definitely have him very well trained.
And but my job
and
here
medicated.
Is to present this case
remember, I think
to you, Your Honor, for you to make a decision.
Remember, I think Tyler Robinson is part of MK Ultra. I think he was MK Ultra.
Public for the
along with Lance Twiggs,
or published for.
I believe that too, bro.
To see is a different question, which I'll submit. The
and modern day MK Ultra isn't how the agency was doing it back a century ago. They're doing it through medication now.
Mr. Novak.
Precisely, through antidepressants and shit, SSRIs.
Thank you, Your Honor. For the state to argue that this exhibit says anything about Mr. Robinson's state of mind should be rejected out of hand. This exhibit does not say anything about Mr. Robinson's state of mind, and that's what motive is, and that's what the victim targeting enhancement adopted by the legislature focuses on, is the defendant's perception. If Mr. McBride wants to propose significant redactions to this exhibit so that Your Honor, acting as a magistrate, can consider things that are narrowly tailored to what the information alleges, which is the allegation is that Mr. Robinson perceived that Mr. Kirk had certain political views. That's one thing. But this document talks, and now Mr. McBride, not to be colloquial, has sort of thrown down the gauntlet. This document talks about foreign affairs, political doctrines, America's founding principles, cultural trends, and what Mr. Engelhardt refers to as Orthodox Christian views on sexuality, marriage, and gender/sex. So this document goes way beyond what the state just flagged for the entire world is their view of Mr. Robinson's motive, which has something to do with gender identity, gender ideology, and sexuality. That's what Mr. McBride has just said this case is all about. This document goes way beyond that. And that's why it's not admissible. There may, as I said, be other evidence which Mr. McBride and the state want to rely upon, which they haven't presented yet, and Mr. McBride hinted at that. So I think that it's not admissible at this point in time. I don't think it's relevant in the sense of has a tendency to make a fact of consequence more or less true. That's the definition of relevance. So how does this court go from what the state has to establish, which is motive, or well, actually the state doesn't have to establish motive. Motive is not an element of the offense, but at least with respect to the victim enhancement, according to the legislature, the question is what is in Mr. Robinson's state of mind? The other thing I want to say is that Mr. McBride did not address the admissibility of these opinions. Now, the court talked about 1102, but 1102 doesn't resolve all of the other rules of evidence. It's just a gateway for an affidavit. So what we have in this document are what I think are purport to be untested expert opinions, or at least lay opinions. And the question is, under the rules of evidence, is whether this document is helpful to the court when it makes a determination about whether Mr. Robinson perceived that Mr. Kirk had certain political views. So where is the evidence that Mr. Robinson, in this document, that Mr. Robinson was aware of Mr. Kirk's political views? Where is the evidence in this document that Mr. Robinson had disagreement with Mr. Kirk's political expression? None of that appears in this document. There may be other evidence of that 100%. We'll have to see, but there's nothing in this document which connects up with Mr. Robinson's state of mind, which is the question in the enhancement. And Mr. Engelhardt cannot, of course, express any opinion about Mr. Robinson's state of mind because he doesn't know him, and because that would be improper opinion evidence under any rule of law. So for a document to be received into evidence that quotes one very narrow piece of religious doctrine, and that involves Mr. Engelhardt's interpretation of what that means. I mean, Mr. Engelhardt at the top of page 2 is basically telling this court what he thinks Chapter 19 means. How could that possibly be admissible in this proceeding? And how could it possibly be admissible for the purpose of this court concluding what Mr. Kirk thought Chapter 19 of Matthew means? So it's not relevant. It's improper opinion evidence. It's definitely overbroad in terms of the evidence that the state is proffering to prove a very narrow point. And it actually doesn't get to that point, which is what was Mr. Robinson's state of mind. It also doesn't say anything that Mr. Kirk specifically said on September 10th that Mr. Robinson may or may not have heard, or anything that Mr. Kirk said before September 10th, specifically, that Mr. Robinson may or may not have heard. Nor has the state presented any evidence, and as an officer of the court, I would say I don't think the state can present any evidence that Mr. Robinson specifically heard Mr. Kirk say a specific thing at a specific time. There are some statements which I think that the state will say are admissions by Mr. Robinson, which reference Mr. Kirk, which we will get to later. But none of those reference specific statements by Mr. Robinson about specific statements by Mr. Kirk on any specific issue that would even make a piece of this relevant. So I'm pretty sure that I've reached that point where anything more I say, I'm going to be repeating myself. And so I'm just going to stop unless the court has questions.
I don't. Thank you. Well, I do have a question as it relates to political expressions. Does religion or gender intersect with political expressions?
I think that's a great question, but probably not a question to be answered by me in this proceeding. That's actually a really, really complicated question that the state wants the court to say is a simple yes.
All right.
Because I don't want to be the expert. I mean, the court's basically asking me to testify. I'm not trying to be flippant. The court is asking me to testify about where religion and politics intersect? And that's a fascinating question. The question here is whether this document, the way it's presented, the way it was written, is admissible under relevance and expert 701, 702 rules of evidence to prove what Mr. McBride says the state, what he acknowledges the state has to prove, which is that Mr. Robinson had a state of mind which was, let's just say, hostile to Mr. Kirk's political expression. And I don't think that this court should be deciding, based on the record before it, where, if at all, politics and religion intersect. I mean, if the court needs to resolve that issue, then the court also needs to resolve the question of which religious philosophy are we talking about?
Well, Mr. Novak, I bring that up because you mentioned it. You said you cited directly to the enhancement. You said political expression, and then you went to the Bible itself. And so it appeared to the court that you put it into place. So I just wanted to get a little bit of guidance from your position. And so that's the reason for the question.
No, I totally appreciate the question. I'm not suggesting, Your Honor, that there's a problem with the question. Any question that the court asks is a question that counsel should take seriously. Sure. The legislature separates in the statute religion and political expression. The state selected the victim targeting enhancement based on political expression only. Now the state wants to I didn't bring Matthew in. The state is bringing Matthew in through Mr. Engelhardt. Sure. I didn't bring the Bible to this courtroom, the state brought it. And that concerns me greatly because the state is turning this into a question of whether Mr. Robinson's views, identity, life are anti-Christian. And that's a huge problem. And the state has created that problem. And this hearing is being broadcast to the entire jury pool. And that's what Mr. McBride just did, is he turned this case into whether Mr. Robinson's life is inconsistent with what Mr. Engelhardt calls Orthodox Christian views. I'm going to just stop right here because I think the court knows what the problem is.
Thank you. All right, anything further before the court makes its ruling? I appreciate the in-depth argument and the passion behind the argument. You are advocating for your clients, and I respect that.
Yeah, Your Honor, I'd just say it provides context for the defendant's state of mind.
All right. All right, in making this
It doesn't provide any
determination whether it's
context for the
admissible or not,
defendant's state of
I'm
mind
going to
because you
start at
don't
the
know
beginning,
the
which is
defendant's
this.
state of
This is a
mind.
preliminary hearing. The purpose is to
Engelhardt does
determine
not.
whether the state has
He
established
doesn't know Tyler
probable
Robinson.
cause to
Engelhardt
believe
works for
a crime was
TPUSA.
committed and that Mr. Robinson committed it. As it relates to this case, as I turn to relevance, I turn to the information as previously stated, and is this relevant? What is before me? And without indicating my decision on probable cause, because I am not at that point, I'm withholding all decision-making until all evidence is properly before me. And so in this ruling, it is not indicating either direction that the court is heading. However, the court finds that it is relevant as it relates to the victim targeting enhancement, as it relates to Charlie Kirk's political expression, and the court recognizes the argument made by defense in regards to state of mind. And it is because of both arguments that the court finds that the court is ruling that it is provisionally admitted into evidence. And at such point, when it becomes relevant, based off what Mr. Novak has talked about Mr. Robinson's state of mind about Mr. Kirk's political beliefs, Then at that point, whether it is admitted or not into evidence will be decided upon. So as of right now, it is provisionally admitted. Because of that stance, it will not be published to the courtroom or media, but both parties can weigh in on that when this is brought up again and the request for it to be fully admitted is made by either part. Then the court will re-examine whether it should be published at that time to those in the courtroom and to whether that is displayed or filmed by the camera.
Imagine if we're going through all
right.
this and all
Let
them
us
people
proceed.
that think Charlie Kirk is
Well,
still alive were
Let us
right.
proceed to lunch because it is now 12:40.
I know, right?
It seems like a natural place to stop. I believe everyone looks like they
Although
need a
I
lunch
will
break.
say
So let's go
there
ahead and
is
break for
evidence.
lunch. Let's go.
There
come
actually
back
is
at,
evidence to suggest
let's
that
come
he might
back
be
at
alive, believe it or not.
1:15.
I didn't want to believe it, but
I need
and
to
I
give you a
still
full
don't
lunch
believe
here.
it. But
I need to do my lawyer math and see what that would bring
once
us
he
to.
once
So
he
it's
stops talking, I'll
12:40.
tell you.
Let's come back at 1:45 for lunch. All right. Any party need the benefit of the record before we break for lunch?
No, Your Honor.
All right. Court is in recess until 1:45.
All right.
Also, I just sent you a DM on X. Check out that message real quick, bro. All right, let me go ahead and pause the music on this. Okay.
Yeah, that's crazy, bro.
All right.
I've been checking that periodically, and I just keep seeing it going higher.
Yeah, a lot of people in here, man. And by the way, thank you. I want to say thank you to all 63,000 people watching us right now. You're amazing. My goal today was to beat Andrew Colvett and TPUSA and make sure that we had more people watching our stream than their stream. And we've done that, guys. Matter of fact, let me go ahead and pull that up real quick. I'll show you. Let me pull up my home screen real quick.
Keep on sharing, keep on commenting, liking.
Yeah. Repost the stream. If you're on X, please repost the stream. But if you look over here,
support the free thinkers, not the Fed sloppers.
Yep. But show more. Okay, look. Andrew Colvett is fell off to where he doesn't even show on the top. What is it? The top 1, 2, 3, the top 5 live streams of the day. Andrew Colvett doesn't even show on the top 5 live streams of the day. He got kicked off because he sucks so bad. But anyway, so he's at 44,000. Turning Point is also only at 44,000 viewers, and we're at 62,000. So we've beat both of them out. We beat Turning Point. We have more viewers than Turning Point watching, and we have more viewers than watching Andrew Colvett. We actually have more viewers than, well, not Alex Jones's main channel, but his backup channel.
Let's go.
But yeah, we're in the top 5 live streams. We are number 4. We are the 4th biggest live stream on X today. So thank you all for doing that and making that happen.
Thank you so much.
Absolutely. So keep sharing it out. I see some people reposting the stream here. Tiny Mouse reposted the stream. Thank you. Definitely repost the stream. Hold on. Me says, please read my earlier message. Extremely urgent. I don't see.
Is that on X in the inbox, or where is that at?
Yeah, I don't know where you sent your message. Post it in the chat.
Maybe they don't want it in the chat.
So yeah, I mean, if
sometimes
you
gotta
post
check your
post it in the
spam
chat.
folder. Sometimes you gotta check your spam folder, bro, on X.
Yep. Oh, okay. She's on X. They said you sent it to me. Project Constitution, or did you send it to Yakova, Yakova, whatever? I always mess your name up, bro.
It's all good. It's Yakov.
Yakov.
I'm trolling the. I don't even want to say it to mess with the live, but I'm trolling the chosen people, bro.
Good. I've been posting our live every time Andrew Colvett posts something or TPUSA posts something. I've been posting the link to our live stream underneath just to piss them off. Lion, is your name Lion Bliss? Me? Oh no, because your name's me. I don't see anything from a me. I just went in my spam folder and I don't see anything from you. I see somebody named Lion Bliss sent me a message at 12:52 p.m. but I don't see anything from a me. Yeah. Okay, yeah, email. Just if you got something that you want to say and you can't put it here, just email it to me. projectconstitutionvideos@gmail.com. All lowercase, no spaces, just projectconstitutionvideos@gmail.com. All right, you can send it there. I'll check it out. Let me know when you send it. Just put in the chat, let me know when you send it, and I'll go take a look, all right? Also, want to remind you guys, if you want to send a super chat and have us read it on air, you can scan the QR code right there at the bottom left-hand corner of the screen where it says send a super chat, scan here. That's our Buy Me the Coffee link because the channel's not monetized, so that's how we do super chats, just through Buy Me a Coffee. So
how do they scan? How do they
QR code?
How do they scan that, bro? If they're using their phone, is there like a link attached to that when they click on it, or what?
The link is posted in the chat. So if you're on YouTube, it's pinned to the top of the chat is the link for you. If you're on your phone and you can't use your phone, if you're on your computer, you can just use your phone to scan it. You know, once you scan it with your phone's camera, you know, the link will show up underneath and you just click the link. But if you're on your phone and you can't use your camera to do it, then if you're in YouTube, it's posted at the top of the chat. It's pinned to the top of the live chat is the Buy Me a Coffee link. And also, if you're on X, the post underneath. So you got the main live post, and then there's a post directly underneath of it, which is the Buy Me a Coffee link. So if you scroll down to the second post that's attached underneath of it, like quote posts or whatever, like I quote posted myself. So if you go to the post underneath of it, that is the Buy Me a Coffee link on X. So everybody should be able to easily access it. And I'll just go ahead and, matter of fact, I'll go ahead and drop it in the chat one more time here on both sides, just so you guys, if anybody wants to send anything while we're talking about it, feel free. All right, I just put that in the chat for everybody. Although I can't, the comments don't go to X. So let me drop it in the actual live chat for X as well for you guys. So give me 1 second here. All right. All right, let me go click it live and send a message. There you go. This is, okay, there you go. I just dropped the Buy Me a Coffee link in the live chat on X as well. So if you guys want to help support the stream, you can do that right there. Like I said, we'll read your comments out. You can donate and leave, you know, we'll read your comments live on air. And the good thing about this too, the good thing about the Buy Me a Coffee, it's way better than Super Chat, because Super Chat, you're limited by how much money you I mean, you're limited by how many, you know, how much, how long, how big of a comment, how many characters you can type, depending upon how much money you donate. So if you want to type a big comment, you got to donate like $100 if you want to type like a bigger comment. Where Buy Me a Coffee, you know, you could just donate $5 and you could type however long a comment you want, and we'll still read it, you know. So let me go to that real quick and see if anybody sent anything new since the last time that we read it. Okay, yeah, we got one more from Garner Batty. Thank you very much. Says, thank you for hosting, PC. I appreciate you. Thank you very much for the support. Like I said, me and Yakova, I messed it up again. But me and him are splitting any donations that come in. Him and I are splitting them, because he's not getting paid either. So we're just here because we want to, you know, we're here for the truth. We want the right thing to happen. We want to make sure the truth's out. We want to help get justice for Charlie, and we want to free the Patsy. So that's our goal. Oh wow, what's the hell? Why am I sharing the StreamYard? Wow, that's crazy. Oh no, I'm sharing X. Well, why is, oh, because I'm sharing my live stream. That's what happened. Okay. Okay, so don't want to show my messages. Okay.
Hey, is that Erica Kirk I seen in your DM, bro?
No.
Is she trying to send you a super chat, brother?
I'll take her money now. You know, don't get me wrong. She wants to send me some money. I'll take it.
She could be the super mama the sugar mama super chat of the day.
Yeah, she could be my sugar mama. Absolutely. All right. What do we got? So did you ever find that your better video? Oh, I saw you sent me a video. Is that what you sent me? Did you send me a closer video?
Yeah, I sent it to you in your messages.
Okay, let me pull that down real quick. Download it, and then we can share that. All right. Oops.
If my service cuts on me, I'll be back in a few minutes.
Oh, okay. All right. So let's go to the video file. Let me pull that down. Add this. And okay, this is the
okay. So now tell me where you see a rifle in that jacket. Look at it open up and fall down like to the ledge as he's about to grab the ledge and jump off. There's no rifle in that jacket. That appears to be a jacket to me. I mean, you could see it open up and then close, but there is no rifle in that jacket, stuffed in his pants. How would he have bent down and kneeled like that and then jumped off of a roof with a rifle in his pants? That video right there completely destroys the Fed slop narrative that there was a rifle in his jacket. Bullshit.
I agree. It's very, very clearly evident that that's just a jacket. That's all it is. It's just a jacket.
I think you're muted.
There's no rifle there. No, I'm not muted. It must be on your end. Yeah, there's nothing it's clearly, it's just a jacket. It might be a towel, but it's just a jacket. It definitely isn't a rifle. He said there was a long black, object or whatever. No, there is no long black object here. That's clearly, it's floppy. Guns don't flop. That's the other thing is when he jumped down, that's floppy. Whatever that is, it's floppy. Guns don't flop around like that. Thank you, person in the chat. Thank you very much. Yes, I was muted. Sorry about that. So I was saying is, remember in the chat, remember in the guy's testimony where he said that that the person that they're claiming is Tyler Robinson went out of the parking garage. They parked, went out of the parking garage, went to the corridor, and actually met with or spoke with a TPUSA representative. That to me stood out big time. Like that should be a huge red flag to all of us. I want to know what TPUSA rep that was. Who did they talk to from Turning Point? And why have we not heard about that? Why has nobody from Turning Point mentioned that they spoke to this guy? Because surely they can't claim. That's the thing is they can't claim, oh well, we didn't know it was him, because if the police know that he spoke with a Turning Point representative, I guarantee you that the police went and talked to that Turning Point representative and said, hey, we see you talk to the suspect. What happened? What was that conversation? Do you remember what he said? What were you guys talking about? So they clearly at that point would have known that they interacted with the suspect. So why did we not hear about that? Why have they not said anything about that fact? They're hiding. They've been trying to hide that fact for some reason. And I'm glad that was brought out in trial, because that's very, very important. Especially because, like I said, we all believe that the people at Turning Point had foreknowledge for sure. Yep. Yeah, well, that college that day was filled with a lot of patsies, that's for sure. And that's the other thing. Even George Zinn. Remember George Zinn when they took George Zinn to the hospital? George Zinn was singing like a canary. He was allegedly he was telling all the nurses that he was getting paid to do that. He was getting paid to claim he's the one that did it. Yeah, absolutely. Especially when they have all the people that surrounding him that are working against the guy. Like Lance Twiggs, I believe he set up Tyler Robinson. I think Lance Twiggs is the one that wrote all the messages. I think Lance Twiggs is the one that authored the Discord chat, because like I said, Tyler Robinson had already turned himself in at the time that those Discord messages were even written. So it couldn't have been Tyler. The only other person that would have had access to Tyler's Discord would have been Lance Twiggs, his boyfriend that he lived with. So yeah, I definitely believe Lance Twiggs is, so the people around him set him up, and Lance Twiggs was one of them for sure. And then, like I said, I showed you the map or the crude drawing he did that Lance Twiggs. I showed you guys yesterday the crude drawing that Lance Twiggs made that looks like planning for the assassination, where he drew out the UVU courtyard, and it looks like he's actually planning it. I'll show that to you again for some of you guys that weren't here yesterday, since we got time. Let me pull that up real quick and I'll show you. Okay, bookmarks. This one, yep. Okay, let me make sure I'm sharing it here now. StreamYard, add to, I got to remove it. Add to stage. Okay, so yeah, for those of you that weren't here yesterday, I made this post. Did Lance Twiggs draw what appears to be a planning sketch of the Charlie Kirk's assassination? One of the drawings made by Lance Twiggs, the roommate and boyfriend of Tyler Robinson, contains several extremely suspicious elements that line up with the Charlie Kirk assassination at UVU. Key details in the drawing: the words time equals test or time-test.exe, which is execute. For anybody who knows code, that means execute. Execute, guys, execute. Written clearly at the bottom. This reads like somebody planning and testing timing for an operation. Measurements such as h3.43 times 20 suggest distance or height calculations. Multiple arrows and positioning lines that appear to map out the movement or lines of sight. The highlighted and circled areas at the top or center loosely match the locations of the loci center. Omega symbol inside the yellow circle. This stands out. The omega symbol often symbolizes the end or final stage. In some contexts, it's used in operations or esoteric symbolism. And that's also on the map that he drew. It's the location where Charlie's tent would have been in correlation to UVU's courtyard. So I'll go ahead and show you guys the map real quick. So this is Lance Twiggs' drawing that I was just discussing here. And if you look down the, if we're looking at the bottom, like where it says drop it something, right? Where it says drop it ed something. That flat part down the bottom there, that is the Hall of Flags, that walkway behind Charlie, where where like the trans people were and stuff, where where they had the furry flag and everything. But that's the walkway behind Charlie. The big diamond area looking thing here is the UVU courtyard. And this omega symbol that's highlighted right there inside the courtyard, that is exactly where Charlie's tent was. And then if you look up at the other corner where you see the circle where it's, where somebody went crazy and circled it a whole bunch of times, that corresponds exactly to where the Losi building is. And all these arrows and everything look like either line of sight measurements or whatever. And then down the bottom here, like I said, you see the H34 times 20 and then the Y and everything. And then down all the way down the bottom, you see time test.execute. So all of this to me looks like UVU, and there's like here's the UVU courtyard in the same image. But if you look, there's the diamond, there's the walkway. Charlie Kirk's tent was right there where that Omega symbol was, and then you go to the point of the diamond and go all the way out straight, and what do you get? You get the Losi building roof. Let me show you a side-by-side of them, well, as best as I can. I can't really show you side-by-side, but I can show you like this. But if you look at them, you can see the comparison here. I mean, you can definitely see that sure to me looks like planning. That looks like he's planning the assassination of Charlie Kirk. FBI whistleblower Kyle Serapin has strongly argued that from about the day Brian Cole Jr. was taken into custody, he believes Brian is innocent. Okay. Lance Twiggs is very mentally ill. I think he set up Tyler Robinson also, but I don't think Tyler Robinson is 100% innocent. No, I agree. Tyler Robinson is not 100% innocent. He definitely participated in something that day. He participated in something. As Candace Owens says, she believes that he went to the Dairy Queen and maybe dropped off some clothes. For if she's saying that, she has some evidence to believe that. Maybe that's what Tyler Robinson's family might have said, and she hadn't released it. I don't know. But if she's saying that, she has some evidence to suggest that. But he definitely did not kill Charlie Kirk, and he was not at UVU whatsoever. I do know that much. And that's according to his family. His family said he was not at UVU that day at all. So I think he was involved in something. I also don't think that he knew that Charlie was going to be killed. I think he may have thought it was like a prank or something to scare Charlie. I don't think he knew that they were actually going to kill Charlie. Okay, gotcha. The Omega symbol is exactly where Charlie's tent would have been. So if you look at the map here, this is in the same direction as the drawing. I put this map in the exact same facing the same way. So this map is facing the exact same way as is drawn in Lance Twiggs' drawing. So the bottom part, the bottom of Lance Twiggs' drawing would be, like I said, that walkway, that Hall of Flags walkway right there, which was behind Charlie's tent. So Charlie's tent would be exactly where that Omega symbol is on this. See, this is the back. That's the, I don't think you guys can see my mouse. I wish you could. But that's the, that flat part at the bottom underneath the Omega symbol. That is the Hall of Flags right there. And then the Omega symbol there, like I said, that is where Charlie's tent was relative to the courtyard. And then if you look up, you see how the courtyard, kind of goes out in like a diamond shape and then goes to a point in the opposite corner, just like this one, where you see that the courtyard kind of goes off in a diamond shape and then goes to the point in the corner. And when I say the courtyard, I'm talking about where the crowd's standing, the stairs and stuff. I'm not talking about like all the other buildings and stuff around. I'm talking about just the actual diamond in there, like where the actual amphitheater part in the middle. So if you look at it, it goes to the point. So if you look from where Charlie's 10 is all the way to the very other end of that point, and then go straight out from that point all the way up, that's the Losi Center. That building behind it there, I don't know if you can see my mouse, but if you can, but right here, this building right here is the Losi building right here, with at the top center left is the Losi building right there. Yeah. So that's what I'm talking about. Gotcha. All right, what did you say? What about all the text messages Tyler was receiving from his gamer friends that he met at Furry House? At some point in time, he figured out that he was being set up. Do you recall that? I'm not really sure. I don't remember any other text messages. I know there's the alleged text messages that he sent to his roommate Tyler, which sound made up. They sound like, they read like ChatGPT wrote them. And then you have the Discord message, which also is like a confession or whatever. And that one, like I said, that's completely fake. But even the messages that he's allegedly sent Tyler or whatever, I don't believe that he wrote them. I don't. I think they're made up. I think the cops made them up, to be honest with you. I haven't heard about any other messages though. If Tyler is not convicted, then that'll put a lot of scrutiny on, that'll put a lot of pressure on the prosecutors, the FBI or whatever, to look at alternative suspects, which might force an actual investigation into the people that we are talking about, the evidence that we have uncovered that suggests that there's a foreign nexus to it, that Israel's involved. That suggests that the people at Turning Point had foreknowledge of Charlie's death. The people like Lance Twiggs, who we believe actually is the one that set up Tyler Robinson, he would be the next one to be charged. The other people that had foreknowledge in it, and the other people in the furry community or whatever that posted on X prior to Charlie's death, saying that Charlie's going to be killed on the 10th or whatever, they would be charged next. If Tyler doesn't get found guilty, if they find him innocent, then that opens the door to charges being placed on the people that really killed Charlie, which is our goal. That's what we want. That's the main goal. Is we not only we want to get Tyler Robinson off, but we also want to get justice for Charlie. And in getting justice for Charlie, the only way we can do that is if we can force the government to actually do a proper investigation and look at all the evidence that we have all uncovered, and start holding these people accountable, man. Because we basically know a lot of the people involved. We have evidence that shows they're involved, but the government, trying to get the government to do anything about it, especially when their buddies are the ones that are in power, TPUSA and Trump are all colluding together. Israel and Trump are all colluding together. So trying to get the Trump administration to investigate any of these people while they're in power is like near impossible. I think that'll change in the midterms, though, because the Democrats are going to win in the midterms. There's no ifs, ands, or buts about it. The Democrats are going to win in the midterms. And a lot of that, it's partially because of Charlie's death, but there's definitely a massive fracture in the Republican Party. Some of it is caused from Charlie's death, but not all of it. A lot of it is caused just because of Trump. Trump has betrayed all of us. He's done a complete Benedict Arnold on us, complete 180 flip, and has completely gone against everything that he said. Every one of his promises, he's basically gone against. He's basically a shill for Israel now. And that pisses a lot of people off. We haven't gotten justice with the Epstein files. We haven't gotten any information about Butler. It's just, we went to war with Iran, even though we all voted for no wars. He was supposed to be the no war president. So I think because of all those reasons, the Democrats are definitely going to win in the midterms. And when they do, I think we're going to actually we can force, at least in Congress anyway, we can force Congress to get a proper, to have a proper congressional investigation of Charlie Kirk. And we could force a lot of that evidence into the public light, which will be a big, big, big help. And as far as, actual justice, like getting them to actually charge any of these people, I don't think that will come until Trump is out of office, until at least 2029 or 2028 when Trump's out of power, and maybe somebody else gets in there. Then we might get actually charge these people. But until then, the most we could hope to do is, when the Democrats take over, we get them to, and I know a lot of the Democrats, because I've spoken with some of them, they are on board with this. They are on board with getting a proper investigation into Charlie Kirk's death. I know some of them personally I've talked with that have promised that if they do win if they do win in the midterms, that they promise they will do that. So we'll see what happens there, but that would be a good first step. Yeah, I mean, you got to be optimistic. What's the alternative? Honestly, what's the alternative? You either I've always been a glass half full person. Even when things are negative, you always have to look at the glass half full. Being a pessimist and thinking there's nothing you can do, thinking on the negative side, you're never going to get anywhere. I would rather think big and be optimistic and fall short of that than to never have tried at all. Like, it's better to try and fail than to not try at all. That's how I am. And I think it's important. Although I do see, you said it's about a civil war or whatever. I do think that we are going to. I think Charlie's death. Here's the deal. We're the only way we're going to save this country. Both sides are corrupt, Republicans and Democrats. They are both corrupt. They're both basically bought and paid for by special interests. Israel, like AIPAC, as well as other special interests, like the big pharma lobby, other lobby, big insurance lobbies. So people in Congress are bought and paid for. So unfortunately, and the elections are rigged. So honestly, I don't think we can vote our way out of our problems. The only way we're going to be able to fix this country is having another revolution. And I think Charlie's death is the catalyst for that revolution. And I think Charlie knew that. He said in his text messages, about that he thought his death is what was going to bring people together and make this country great again. And I think he was right about that. I think Charlie's death was the catalyst, because since Charlie died, it has brought together people from both sides of the aisle together, united against our common enemy, which is the elite, the Epstein class. That is who our real enemy is. And we've all realized that. That's why I'm friends with like Z, with the Unfuck America tour. That's why Candace is now friends with Hunter Biden, and Anna Kasparian. Like, we have to make allies, and we have to all come to the realization that it's not, they want to keep us in this war fighting each other, Republicans versus Democrat, or black versus white, or, all of us versus like immigrants or whatever, or Muslims versus, Christians, or like, none of that matters. We all need to come together and face our common enemy. Like I said, the elite Epstein class, they are the real problem. They are the ones that cause this mess. They are the ones that are the puppets controlling the strings everywhere. They are the ones that are making life in this country unbearable and unlivable. They want to turn us all into slaves, and they're doing a damn good job at it, honestly, because we've allowed it to happen. We've just basically been asleep at the wheel and allowed it to happen. And I think Charlie's death was the catalyst, the wake-up call, that people saw what happened to him, and it like shocked people, and woke them up. And I think now people want change, and people are hungry for change, and I think Charlie's death is the catalyst for that, for sure. Good versus evil, that absolutely. This is a spiritual war for sure. Good versus evil. You got anything to say, brother?
I have a lot to say, bro. Yeah, I would say that they're trying to keep us divided, like you were saying, based upon race, religion, our political views. And, now is really not a time for that, with everything, that they're rolling out right now with the totalitarian, total surveillance slave state through Palantir, and all the stuff they're doing through AI data centers. All of this stuff, including the Charlie Kirk assassination, is nothing but one big distraction from what they're doing behind the scenes, right? So everything that goes on that they feel will get the distraction and attention of civilization, they will do it. They are professionals at psyops. They're professionals at distractions. And while all this stuff is going on in the kangaroo court of the Charlie Kirk assassination and all this stuff is going on, there is way bigger things going on in the background. That's why recently I've told friends of mine, like, this case is important. Justice for Charlie is important. But don't get lost at the fact that this is just a distraction, though. This really is just a distraction. And one thing about the elites is they'll never waste a good psyop. They'll never waste a good media story that they could drag on for months and years if they can, to keep us distracted from what's really going on behind the scenes. And I think, there's this thing going on with, the anti-Israel, people who are against Zionism, which, in a religious aspect of it, like, I don't align with Zionists. I just don't. And it doesn't mean that I'm anti-Semitic. And, there's this idea, being somebody who was a stomp down Trump supporter for a whole decade and, pro MAGA and all that. I've seen the movement start to become what we would bash the left for, as far as like, basically.
I totally agree.
They're
basically doing all the
like
exact same things, exact same tactics, everything. That
right. All the garbage, right? And now they want to say that if you're not pro-Israel, you're pro-Islam. Look, check this out. Just because I don't align politically with Zionism doesn't mean that I'm anti-Semitic. Zionism has nothing to do with race. It's a political ideology. Now, this goes the same with Islamism. I am not an Islamophobe because I don't support the political ideology of Islamism. There's a difference, and a lot of people in the mega movement right now are pushing that on those of us who, you know, don't stand that are not pro-Israel. I'm pro-Christ.
They're doing it. They're doing it intentionally. They're trying to use anti-Semitism as a shield to subvert our free speech. They're going after our free speech, and they're using that as a tool. That's basically what they're trying to do. Even though it's not, you know, there's definitely a distinction between, you know, anti-Semitism. You know, you can, you know, like, you're not an anti-Semite just because you have a problem with AIPAC and, you know, Israel having the political state of Israel having so many connections, you know, tentacles in our elections and involved in buying our congressmen out and stuff. Like, just because you have a problem about that doesn't make you anti-Semitic. It has nothing to do with religion at all. It's two completely different things.
No. Now
I want to say one more thing too, though. I think when you say distraction, I think that's actually the wrong word. It's not a distraction. It's more of, it's all connected. And that's what Candace has been bringing out, that everything is connected. It's not just one thing. Like, you know, as you see, like, it's all, like, everything is connected together. It's just one part of the bigger picture is what we're facing now.
Right.
So people are like, why does Charlie's death matter so much? It matters because it unveiled
who's behind
what they're doing. It pulled the curtain. Yeah, it pulled the curtain back, and it showed who they are, how they're doing it, what they're doing, and honestly, it woke people up to their psyop tactics. You know, now, I mean, there's still a lot of people that are a sheep that aren't online, but generally, a lot of the people that are online now, they see how they're doing these psyops. Like, we've lifted the veil. Like, we now see their influencer network, how the White House has their select influencers. You know, that every time they want to run a story and push it, they go to these people, and all these people push the exact same psyop out, and we know what to look for. We know who to look for, and we call it and expose it just like that now, you know?
Yeah. I was talking to my veteran buddy about that. Like, you can see right through to the psyop now, like, just like within hours, like that shooting that happened in Australia at that festival. I mean, within hours, we were breaking that story wide open. The guy who was an actor, who was an Israeli actor, who was at another event, and
crisis actor. Yep.
Crisis actors, right? These things are real. These people are real. You know, these people have experiences in this context. That's why you see that one guy who gave a testimony from the Charlie Kirk incident. He was a crisis actor at another shooting, at another mass shooting. And it's just like, you know, it's easier to see now because we have social. Yeah, there you go. Sandy Hook shooting. So we have social media now. So, you know, something that they created is actually, you know, people are using for good. Like, you know, but it's just wild, bro. It's wild. It is all connected. You know, the Epstein class, I would say, is at the pinnacle. Is at the pinnacle of everything. You see so many different aspects of our society connected to Epstein. Just like, listen, when you know those school photos that you guys get for your children when they're in kindergarten and first grade and second grade, well, go look into Leon Black. I actually broke this story. I had as soon as the Epstein files were released on this last one, when they released a little bit of what they have, I broke a story on Leon Black and his connection to the company that does our school photos as children, with him basically having a company that owned it. And they've been collecting data on us since we were children. That's what this company was. They basically collected data. So why would somebody connected to Epstein have a company that does school photos for children? And I started getting messages in my inbox from various mainstream news media outlets, and it's blown now, but I told them, I said, no, they asked if they could interview me because I broke the story, and I said I wasn't the original one who released that. Sorry, I didn't want nothing to do with it. But then to see all the schools across the country making a stink about it, that's what the fight is about. It's about bringing awareness, exposing the Epstein class, and bringing truth to people, whether they want to chew on it or they don't. It is what it is. At this point, if people can't see what is going on, and even to the point of us being lied to on this second run with Trump, I mean, you just choose to be sleeping in a slumber at this point. It's all intended to wake us up. Now, you want to double and triple down and trust the plan crap. All that Q stuff was an intelligence agency psyop.
Oh, big time. The other thing I put out today, and this is what we started talking about earlier, but I got distracted. When I said we were talking about the Charlie is still alive, the people that are pushing that Charlie's still alive or whatever.
Right.
Hold on, where's it at? Let me find it. There's actually, I uncovered some stuff which, honestly, I'm not ready to say that. I'm definitely not. I haven't, I don't believe that. I haven't subscribed to that theory, but I will say that this is certain. This information that I uncovered, it's very interesting, and it supports that theory, and it should be investigated. Whether he's alive or not, it should be investigated.
I mean, I know that's a little thought in the back of everybody's mind.
Pretty interesting. Yeah, I mean, I want to believe it, but I have a hard time going there because there's just so much evidence, Hold on, where's it at? Why can't I find it? Let me refresh.
Man, we sure did get psyoped with Kash Patel, huh? We thought he was one of us.
I know, man. Okay, this is it. Yeah. Yeah, so I found there's a phone number that recently showed up last week on her People Finder, on Erica Kirk's People Finder, right? And this phone number is a New Zealand phone number. So Erica Kirk has a New Zealand phone number listed now on her People Finder, but it's not a new number. It just, it just showed up, but it's on the People Finder. It says the number
is valid since
February 7th.
Did you say Foot Finder?
No, People Finder.
I'm just kidding, bro.
Yeah, no. Okay, yeah, not Foot Finder. Nah. We're definitely, we're not doing any of that now. But yeah, no, People Finder. But it says that the number's been valid since February 7th, which was 7 months before Charlie was assassinated. So that tells me, if that number was valid before Charlie was assassinated and linked to Erica Kirk in New Zealand, which, by the way, for all of you not paying attention, Valhalla is in New Zealand. People that think, Charlie went to Valhalla, see you in Valhalla, like Kash Patel said, New Zealand. So the fact that the number was valid, connected to her from February 7th, 2025, before Charlie was killed, means that it's not just like some troll or something that's trying to wrongly connect that number to her, because it was connected to her before any of us were even talking about Valhalla, before any of us knew anything about New Zealand at all. And also another thing about that number is when we looked up the number in New Zealand, it's actually a protected number. It's part of a protected block of numbers. It's a government protected number, meaning that it cannot be registered. It's part of a protected block of numbers for the government, that the government holds, that cannot be registered to any single person. It can't be registered to a person or a business. So the only people that would be able to have that number and utilize that number are people within the government. So why is a number that is connected to a protected government number in New Zealand connected to Erica Kirk?
Yeah, that's kind of
And
wild.
there's
I
more.
think Jesse on Fire. I like that, brother. But go follow him, by the way. I think he believes that he's alive too, huh?
Yeah, Jesse's my boy, man. Him and I are tight. He does believe he's alive, and I've always said, dude, you're crazy. You're crazy. You're crazy. But once I found this, I talked to him like, dude, you know, you're gonna love this. And I told him or whatever. But you know, like I said, I'm not there yet. I don't think I'm still not to the point where I think Charlie's alive. But I will say that this is sure very strange, and this is the first time I've at least questioned whether it could be true or not. You know what I'm saying?
Right.
But
I mean,
we'll go ahead and watch this video. Go ahead. What were you gonna say?
I was gonna say, I mean, nobody here has seen an autopsy report. No one here was there when the autopsy was done. No one was, you know, the funeral garbage that, you know, the widow posted, the fake hand, and there's just weird stuff.
Exactly, like you said, the fake hand. Even the, you know, when Erica's doing those emotional blackmail videos of her crying over Charlie, you know, and we see Charlie's supposed hand or whatever, it looked like a fake hand. It looked like a plastic hand or something. It didn't even look real.
Yeah, super weird. But there's all kinds of ideas that could point to that. But you know, there's all kinds of ideas that point to it being valid. He's gone. But go ahead and play that, bro.
Yeah. So I just released this morning. Like I said, this is something I've been working on for like the last 3 days to get everything together. But I found a lot of other things too. Like Kash Patel actually visited New Zealand. He had a secret visit. It was originally scheduled as a secret off-book visit to New Zealand on July 31st, just 10 days before Charlie Kirk was shot, or before he wasn't shot, but before he was killed. And that was supposed to be a completely off-books meeting, but what happened is one of the local New Zealand reporters ended up catching him. You know, they cited, you know, they saw him, so he was outed. So once he was outed, then he came up with an excuse and said, oh, well, we're starting a new FBI office here in New Zealand to combat China. Right. But another weird thing, I'll watch the video too, but another weird thing is, you know where he went when, you know, his visit to New Zealand? He went to go see to their beehive department. Australia has a beehive department. That's what it's called, the beehive department. And that beehive department is specifically their like their spy department, kind of like you know, like not NSA, but CIA. You know, that's like their version of the CIA is the beehive. And that's where Kash Patel went. He was seen, that's where this journalist saw him in, where he was outed, was entering the beehive department. And if you remember the beehive and bees, Candace Owens, originally that was her whole thing, that she had a dream about, you know, that there's about bees and the beehives and stuff, and how it was all connected. So I'll watch this video, but it's really, really strange shit. All you people that think Charlie Kirk is still alive are going to eat this up. Hey guys, it's me, Colin, Project Constitution. So I want to walk you through some interesting information that we came across a couple days ago. It started out with just one piece of information, but the more we looked into it, the stranger it got. Now, I want to preface this by saying I'm not making any conclusions one way or the other on this, but it is interesting and should be investigated. Recently, when running a background report on Erica Kirk through People Finder, a New Zealand phone number showed up under her name. The number is 06-724-2117.
What's wild is that this number has been listed as valid since February 7th, 2025, 7 months prior to Charlie Kirk being assassinated. Even weirder is when I looked into that number, I found out it's a protected number in New Zealand. It's never been assigned to any person or business. It's one of those blocks the government keeps in reserve. So no regular citizen should have access to this number. And when I tried calling it, it says it's not in service. Now this by itself would be strange, but then you start to connect the dots. Just weeks before Charlie Kirk was killed, the FBI opened up a standalone office in New Zealand that they claimed was to counteract China. Now, on July 31st, 2025, just 10 days prior to Charlie Kirk's assassination, Kash Patel himself made a visit to the FBI's New Zealand office. Now, when you add what Kash Patel said in his press conference about, "We've got the watch, see you in Valhalla, Charlie,"
To my friend Charlie Kirk. Rest now, brother. We have the watch, and I'll see you in Valhalla.
and the fact that on Tyler Robinson's computer screen, there was a map of Valhalla, which is in New Zealand, it starts to look a little funny. And Valhalla, by the way, is a real place in New Zealand. It's a Danish retreat that is extremely private. But wait, there's more. Now, many of you know Candace Owens publicly shared that she had a dream on September 1st, 2025, just 9 days before Charlie Kirk's assassination. She woke up with a strong feeling that something very dangerous was about to happen. She even texted people about it and pulled her own children out of school because of the dream. After Charlie Kirk's assassination on September 10th, which by the way happened in Utah, known as the Beehive State, she connected the dream to the events, noting the symbolism of bees and the beehive, nickname of the state where he was killed. She also has spoken publicly about having vivid dreams after Charlie's death in which he appeared to have told her that he was betrayed.
About a week before, or actually, 10 days before Charlie got assassinated, I had something that came over me, and that's the only way I can describe it. And I was just concerned in a way that I had never felt so impacted. And I was going, something isn't right. Something is just not right. And I felt that there was some sort of an infiltration that was happening at schools. And the best way that I can describe it in a sentence is that I sensed that the danger wasn't stopping there and that more was coming. And I did just a cursory online search, and some messages I found, which were not written by a teacher at the school, but someone who was adjacent to some teachers at the school, gave me pause for concern. In fact, explicitly what it was a Polish underground symbol, like a Polish communist underground symbol that nobody would have recognized outside of people who know what it meant. And I just sort of went, okay, that's weird. I kept looking online, and strangely, I'm not kidding, I'm going to show you these messages. I came across what looked to me like a bunch of people talking about bees. You're going, like literally bees, in a way that's the only way I can describe it. She was like, they were speaking about bees, but they weren't speaking about bees. It was very coded. And I'm going, am I going crazy? Or do you think that all these people are really actually quote unquote bee farmers, or saying that they farm bees? What is this lingo that I'm not understanding? Why do I feel like it's related to students? I didn't feel good about it at all. And the feeling just didn't go away. I can show you this actually, because I was thinking, like, I said to my husband, there is some weird underground, it's like I sense like imminent danger is coming. And for some reason, I feel like there is an underground that has emerged at schools, and it's like related to bees. That's what I said. And I messaged multiple people about this. My sister, here are a couple of more text messages to other people. You can look at the time frame here. This is 8:30, August 30th. This is September 1st when we went off air. September 2nd, we were off air. And I started talking about people that were discussing bees in a way that didn't make sense. I'm like, I don't know if this is drugs. I don't know what it is, but it's weird. And so in a sentence, I just said, there's imminent danger coming. Okay. It is relating to a school. I think it's a communist underground, and I don't know why, but it has something to do with bees. Totally sensible thing to say to your husband. Oh, and we need to hire more security. And we did. We hired more security that very week. And I was just frantic about it. And we made the decision that we needed to homeschool immediately, and started the process, pulled our kids out of homeschooling and starting to interview people. but it wasn't enough. Like, despite hiring more security, despite taking my kids out of school, I still had a sense of dread. The Tuesday night, the night before Charlie got assassinated, I had book club, and I felt like I needed to emphasize to people in book club that it was time to take their kids out of school. Like, take your kids out of school. Something danger is happening right now. And I'm going to show you a clip. Obviously, this is all behind the paywall of what I said to people that are in the book club. Take a listen. I'm homeschooling my kids. I'm so excited. I'm like very excited. I'm embarking on this recent decision. And it is just, I feel, I can't explain to you when a weight got lifted off my shoulders. And again, this weight being lifted off my shoulders of like, you don't get my kids. This whole system, this whole matrix, gotta send your kids to school so we can what? Indoctrinate them mentally.
Right.
In some schools, there's abuses that are happening. Like, and I just have to take the risk and give you my child, like my small child, and then you're gonna gaslight me. That was on September 9th. Okay. Then came September 10th. Obviously, Charlie lost his life. And a few days later, I was told, and I sensed instantly that there was like a hive of people that were involved in this. I just knew it. And when it happened, I just went, oh my goodness. And my gut is telling me that this was the thing, that the dread that I sensed that was coming out of school. And I had no idea. I am not a flag person at all. And then someone told me, and I was astonished that Utah recently, extraordinarily, did modernize their B flag. I had no idea that the Utah state flag is a hexagonal beehive, right? And unbeknownst to me, that it has always been the beehive state. So in 2024, they modernized their flag, but they've always been known as the beehive state. And to be clear, it's not because they make honey. It's not because they have a high presence of bees. In fact, in terms of making honey or bee-related products, they rank number 24. It's actually the beehive state. It relates to the Mormon church, the Church of Latter-day Saints. Early Mormon pioneers founded that state, and they liked the idea of a beehive working toward a common good. Now, if that sounds vaguely familiar or communist to you, the idea of worker bees, yes, that's where it's from.
Not only is Utah known as the beehive state, but the official website for the government of New Zealand is beehive.gov.nz. That's pretty crazy. So let's recap what we're looking at. We have Erica Kirk connected to a protected New Zealand number that was active before Charlie's death. We have the FBI opening an office right there in New Zealand before it happened. We have Kash Patel visiting that office in New Zealand 10 days prior to Charlie's death. We also have him saying, "I'll see you in Valhalla" in his press conference. We have the photo of Tyler Robinson where a map of Valhalla is seen in the background on his computer. And now we have this strange overlap with bees and beehive symbolism between Utah and New Zealand's government website in context to Candace Owens' dream. Now, I'm not saying I know exactly what all this means, but when you put it all together, it's hard to call it a coincidence. Kash Patel's visit to New Zealand was originally supposed to be off the books and unannounced. The only reason that he got caught and had to announce his visit is because a local New Zealand journalist caught him red-handed inside of, get this, the Beehive Division, which the Beehive Division is their underground spy center, by the way, in New Zealand. It says Patel's presence in New Zealand had been unannounced until a media outlet spotted him inside the Beehive, where he was meeting with senior officials, leading to speculation as to why he was there. The day after Patel departed New Zealand, the Australian Broadcasting Corporation revealed Patel had a secretive meeting with Australian Home Affairs Minister Tony Burke in Sydney. No government statement announcing the engagement had been released, and it only came to light after ABC made an inquiry. So he was spotted inside of the Beehive department. Again with the bees. Kind of makes you think somebody should FOIA Kash Patel's travel schedule, doesn't it? Also of note, we did a little bit of research on the picture of Goat Island on Tyler Robinson's screen. Microsoft has never used that pic as a screensaver, which means he had to intentionally choose it as his wallpaper. That's important as well. And in case you think that this is pretty far out here, I just want to mention that there are a whole bunch of movies that reference Valhalla as witness protection. You have The Whole Nine Yards in 2000, which is the comedy film with Bruce Willis and Matthew Perry. The mob boss puts his wife into witness protection and explicitly calls the program Valhalla. The Whole 10 Yards, 2004, that's the sequel. Again, references Valhalla as the witness protection code name. My Blue Heaven in 1990, Steve Martin comedy about a mobster in witness protection. Doesn't use the word Valhalla directly, but the sunny, generic suburb of where he's relocated is jokingly treated like a mafia heaven, and some people later conflated it with the Valhalla myth. Good Girls, Season 3 on NBC. One of the characters is threatened with entry into the Valhalla program, explicitly named as the Federal Witness Protection Program. So there's a lot of movies that reference this Valhalla Witness Protection Program. And as we know, the CIA is deeply involved in the movie industry. Now, if there's anyone in New Zealand that sees this, I would like to talk to you and know if you've seen anything suspicious, if you know anything that we haven't discussed already about this Valhalla.
Let's fly
reach out
a drone.
to me through DM or through email, projectconstitutionvideos@gmail.com. Something about this case has never felt right. And every time we dig a little deeper, more strange connections keep showing up. What do you guys think about this? Drop your thoughts below.
I got a thought. If you guys send enough super chats through the coffee to pay for me and Project Constitution's trip to New Zealand, we will fly a drone over this location. Scout's honor. I got my passport. I'm ready. We will go to New Zealand and we will fly a drone over this Valhalla.
Absolutely. I think at this point it needs to be done, man. Straight up honest. I mean, I'll do it too. You know, if we raise enough money to do it, I would absolutely go and do it for sure.
And we'll do it live. We'll do the whole trip live on the plane to there. I'll go. I'll go do it. I'll go do it.
Yeah, I think that'd be a good trip. I think that'd be fun. Yeah, bro. I'm down for sure. Definitely. So if you guys want to support that, hit up that Buy Me a Coffee link down there. Left, I'm not either. Left hand side of the screen there.
Any travel agents in the chat? Any travel agents in the chat?
Man.
Put the cost and let's run it up. We'll fly Valhalla.
Yep. Exactly.
When is trial set for, bro?
I'm not sure off the top of my head, honestly. The person says, "Isn't Q ran by Steve Bannon? If it is, that tells me everything I need to know." Yeah, I think he. I don't know. I think he's in. I don't know. Do you know more about that? I think he was involved in it. I don't know if he's specifically the Q. I don't think there was a the Q. I think there was, you know, a bunch of people that were actually.
Yeah.
Yeah, there might have been one person posting. Yeah, but Q was an intelligence for sure. It was intelligence agency. It wasn't just one particular person.
Yeah, I think it was Mossad and our agency together running that.
Yeah.
Q is real, but also an evil psyop meant to distract and keep people complete. Yep, that's exactly what it was created for. To keep us believing that someone is coming to save us, so we do nothing.
Absolutely. Oh, someone in the chat said very pricey and long flight.
Well, there's 70,000. There's 70,000 of you. Send 50 cents. Send a quarter, and we can make it happen with a quarter.
Yeah, yeah. If all of you sent 50, even just 50 cents, we'd have enough to do it for sure.
Yeah, for sure we would. Everybody send 50 cents, and we're going to Valhalla.
Yep.
What do you think of the big
And by the way,
earthquake?
like I said, if you want to do it, send a super chat or buy me a coffee, really. But down there, the left-hand corner of the screen, you could scan that QR code right there, or it's pinned. The link is actually pinned in the chat at the top of the chat on YouTube, or if you're on X, the post underneath has the link where you can just click on it to go to the.
Somebody just asked. Yeah. Somebody just asked what we thought about the big earthquake.
Yeah, I don't know what they're referring to. What are you referring to? Do you know what they're talking
They're
about?
talking about the one that just happened in Venezuela.
Oh, I didn't even notice. I've been zoned in on this. Honestly, I haven't paid
You didn't know
attention to
about the
any other
earthquake,
news
bro?
going on.
Oh my
No.
gosh, bro. Yeah, I would say that was a HARP scenario for sure. That was a man-made situation right there.
Well,
They do have
check
the
it out.
power.
I don't even.
Yeah, bro. Like a lot of people died. A lot of people are still missing. And guess who was a part of the search team? Oh, here we go.
Who?
They started back.
Oh, they did? Okay, hold on.
Yeah.
Well, we'll have to look at that during the next break.
Israeli military.
Let me unmute it. Give me a second. Oh, shit. That's not surprising. Come on.
Defense is not going to cross at that time, and we're going to call an FBI DNA analyst out of order. It's a defense witness, but that's to accommodate that witness's schedule. State calls Sergeant Jen Falmuina.
I'd like to come forward and be sworn in.
That the testimony you are about to give now before the court will be the truth and the whole truth and nothing but the truth, so help you God. Yes.
All right. After you're situated, there should be a bottle of water to your left, maybe behind the monitor. And if you wouldn't mind just bringing that microphone just a little bit closer to you so it picks up your voice for the recording. Mr. McBride, your witness.
Will you please state your name?
Yes, Jennifer Famuina.
Where do you work?
I work for the Utah Department of Public Safety.
What position do you hold there?
I am currently a sergeant within the State Bureau of Investigation.
What was your assignment September 10th, 2025?
I was assigned to oversee the crime scenes as well as the physical evidence.
And were you a sergeant with the State Bureau of Investigation at that time as well?
Yes.
And do you have any kind of specialty in your assignment there?
Yes, I do. I am currently overseeing, or I am the lead over our evidence response team within our division. That includes not only conducting training, but also attending training and whatnot.
Okay. So if we hear ERT, it means Evidence Response Team?
Yes.
Were you called to the crime scene at Utah Valley University on September 10th of 2025?
Yes, I was.
And were there multiple scenes that you oversaw or helped to process?
Yes.
We've had some testimony about the rooftop of the Low C Center. Did you oversee or are you aware of evidence that was collected in that area?
Yes, I am.
Was there a screwdriver that was collected from that rooftop?
Yes.
And do you know how that was collected and what happened to that screwdriver?
Yes, that was collected by the Utah Bureau of Forensic Services Crime Scene Response Team, or also known as our state crime lab.
And do you know what happened?
Yes, it was packaged, and then that evening there was discussion on who would take custody of the, and I was there along with FBI. Then it was decided that FBI would take custody.
And did that evidence actually go to the FBI?
Yes, it did.
And was it sent for testing?
Yes, it was.
Where was it sent? Do you know?
It was sent back to their, I guess, their equivalent of our crime lab.
Okay. Were there other are there other areas there at Utah Valley University that were also processed for the presence of evidence?
Yes, there was.
Is there a wooded area that's northeast of campus?
Yes.
What was found in that wooded area?
What was found there was a long gun that was wrapped in a dark colored towel.
And you say a long gun. What does that mean, a long gun?
Sorry, that would be a rifle. So for to be more specific, it was a Mauser 98 rifle.
Do you know what caliber that was?
To a 30-06 barrel.
And do you know what kind of action that had? Was that a semi-automatic, automatic, bolt
It was
action?
a bolt action.
What is a bolt action rifle?
I'm not too familiar with guns, but I just know there's a bolt and you have to pull it back.
Okay. And what was done with that weapon and that towel?
That was documented in place, and then eventually pictures were taken. It was documented in place, and then afterwards we rendered that gun safe, and then packaged the gun as well as the towel.
What was done with the towel after it was packaged?
The towel was also provided to the FBI.
And those two items, well, let me tie up that thread. The gun, what was done with the gun?
The gun was packaged. It was taken to FBI custody. Then eventually it was provided to the ATF lab.
Okay. So the gun went to the ATF lab. Is that correct?
Yes.
The towel went to the FBI lab.
Yes.
And the screwdriver went to the FBI lab.
Yes.
Did you receive reports back from testing that had been done on those items?
Yes, I did.
I'd like to show you State's Exhibit 31.
There wasn't no gun in that towel he jumped off the roof with.
No, exactly. That gun was planted. Also, why didn't the dogs find it?
Is there any way to switch it? Thank you. Okay, I'm showing you here on the screen State's Exhibit 31. Do you recognize that?
Yes, I do.
What is that?
This is the FBI report that was provided to me by the FBI that documents DNA testing.
And does that include testing that was done on the screwdriver that we've spoken about and the towel that we have spoken about?
Yes, it does.
Okay, what I'd like you to do, Kimberly, if you'd please just scroll down so that Sergeant Falmuina can observe this exhibit.
I wonder if we're going to find out who the other 5 DNA profiles are that are on the items, because there's 5 other people's DNA they found besides Tyler.
If I can have just a moment. And can you see who that report is signed by?
Yes.
Who's that?
Amanda Baker, I'm assuming is how you pronounce your last name.
Is that, in fact, the report that you received documenting the testing results on these items and some other items from the
Yes.
FBI?
Sorry, yes,
And does it appear to be in an accurate condition as to how you received it?
yes.
I'd move the admission of State's Exhibit 31.
Defense?
No additional objections.
All right, so I'll note the standing objection and as it relates to admission, what is your request as to publication?
I'd move this admission and its publication both to the court and to the public.
All right. Anything further, Mr. Burke? No. All right. The court will admit State's Exhibit 31 into evidence and allow publication of this exhibit to the gallery and to the monitor on screen in the courtroom and for the camera to broadcast.
Okay, if you'll go to, Kimberly, if you'll scroll down to, still on page 1, where the screen will show items 7 and 8. Sergeant Falmuina, do you see the lines that say item 7, that line?
Yes.
And will you read that portion of the report that describes what item 7 is?
Item 7, TOW from around Mauser rifle, serial number 8863.
And there's also some other identification numbers. Is that the towel that you found with the rifle that day?
Yes, it
On
is.
September 10th?
Yes.
Item 8, will you read what that says is a description of item 8?
Item 8, screwdriver from perch.
And is that the screwdriver that you described that was collected from the rooftop?
Yes.
Okay. If we can go to page 3 of 6, please. Will you, item 7, sub 1, will you please read the result there from the title item 7 until the word contributors?
And would you mind repeating that, but with the microphone? I want to make sure that the record picks up your objection. All right. Either way, if you want to come up, that's fine, Mr. Burke.
Judge, the objection is that her reading to the court what's in the report is cumulative, since we have the analysts here who will be testifying to what the report says and what it means. So you've got the report in evidence. We don't need this witness's reading the report to the court. So it's a 403 cumulative objection.
Mr. McBride, do you wish to respond?
My point is only to draw your attention, Your Honor, to the relevant results that will be discussed by the other expert, as well as the results of the items we've discussed, the towel and the screwdriver. That's all.
All right. The court will overrule the objection and allow a brief overview of it, not going line by line, page by page. So if it is brief, I'll allow that.
Thank you. So if you'll read item 7.1 to the word contributors at the top of that page, if you will.
Yes. Male DNA was obtained from item 7 sub 1. Item 7 sub 1 was interpreted as originating from two individuals, one of whom is Twiggs. The DNA results from item 7 sub 1 and what are 1.7 octillion times more likely if Twiggs and T. Robinson are contributors than if Twiggs and an unknown, unrelated person are contributors.
Thank you. Let's skip down to item 8.1. Do you see that bolded and underlined line there?
Yes.
And this is relating to swabs of the handle area of the screwdriver.
Wait a minute.
Is that right?
Yes.
Will you read?
So Twiggs DNA is on it too?
There, male DNA ending with contributors.
Is that what I'm hearing, right?
Male DNA was obtained from
yeah,
item
I think that's
8
what I
sub 1.
caught.
Item 8 sub 1 was interpreted as originating from two individuals, one of whom is Twiggs. The DNA results from item 8 sub 1 are 30 quintillion times more likely if Twiggs and T. Robinson are contributors than if Twiggs and an unknown, unrelated person are contributors.
Okay, thank you. A couple of foundational questions before we finish for now.
So Lance Twiggs' DNA is on this crap.
Yes.
Who is Twiggs?
Twiggs
Why
is
did they
Lance
and
Twiggs. He was a
they gave him
roommate of
immunity.
Mr. Tyler Robinson.
How did they give him immunity?
Do you know if Lance Twiggs's DNA was obtained for comparison in this test?
Yes, it was.
And how was that DNA obtained?
It was obtained by law enforcement officers.
And was that by a buccal swab?
Yes.
What is a buccal swab?
A buccal swab is basically like a Q-tip or a swab that we'll just place in someone's mouth and just scrub the inside of their mouth to obtain the cells.
And then that Q-tip is then packaged and sent to the lab for testing and comparison.
Yes.
And was the defendant, Tyler Robinson's DNA, also collected in the same manner?
Yes, it was.
Okay. Thank you. Nothing else.
Right. Mr. Burt, cross-examination.
I'd like to reserve the right to cross-examine after the witness completes their testimony after the following.
Oh, would you mind grabbing the microphone? I just want to make sure what you say is on the record.
That's crazy. Lance Twiggs' DNA is on these items.
With the court's permission, I'd like to reserve the
And
right
we've
to
been saying
cross-examine
the
on
whole
the
time
area she
that Lance
testified about
Twiggs
until
is
she's
the one that
completed their
set him up.
testimony.
Okay, I didn't, so, okay, I see what you're saying. Any input, Mr. McBride?
Your Honor, that's what we expected to happen. We discussed this beforehand. We stipulate.
All right, that's fine. And so should I have the sergeant step down or?
Yes.
Okay. Sergeant, if you'd like to step down, you're still under oath, and so please don't discuss your testimony with anyone. And is she being asked to exit the courtroom, or what's the request of the party?
Yes, to exit the courtroom at this time.
All right, Agent, if you wouldn't mind exiting the courtroom, and then we'll come get you when we're ready for you. All right? Thank you. All right, Mr. Burt, turning to you.
Your Honor, out of order, the defense would be calling Amanda Baker.
All right, Ms. Baker. All right, Ms. Baker, if you wouldn't mind coming forward right up here by the bailiff and being sworn in.
You do solemnly swear that the testimony you shall give in the case now pending before the court will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, I do.
All right, Ms. Baker, if you wouldn't mind being seated at the witness stand. Once you're situated, there should be a water bottle for you if you'd like behind the monitor. And after you're seated, if you wouldn't mind just pulling that microphone close to you so it picks up your voice, okay?
Okay.
Mr. Burt, your witness.
Your Honor, we're going to need the monitor switched over to our side if we
Okay.
could. While we're doing that, good afternoon.
Good afternoon.
Tell us your name, please.
Hi, good afternoon. My name is Amanda Baker. My last name is spelled Bakker.
Ms. Baker, what do you do for a living?
I am a forensic examiner in the DNA casework unit of the FBI laboratory located in Quantico, Virginia.
And how long have you been a DNA analyst at that location?
A little more than 10 years.
And just in general, what are your duties?
My duties are to manage a case. When a case comes into DNA casework unit, I will review any information associated with that case. I will review any evidence that is submitted for that case, determine which items of evidence need to be tested and which tests need to be performed. I will then create something called an exam plan. You can think of this like a to-do list to let the biologist know which items I need tested. Once that testing is complete, I will review all the data, draw conclusions in the form of a report, and then testify if needed.
Ms. Baker, in this case, were you requested by the state of Utah to do certain testing?
Yes, I was.
And when were you called upon to do that?
That was September of 2025.
And you recall when the case first came into your lab?
I believe we received evidence the first time was September 11th of 2025.
And just in general, when the FBI, your unit receives evidence for analysis, is it true that the turnaround time is about 200 days?
It depends. We've wavered between 90 days and over 200 days. I would say on average, it's somewhere between 180 and 200 days.
However, did this case come in on what's called a priority one level?
Yes, it did. And what that means is we worked 24 hours a day, 7 days a week until examinations were complete.
And is it true that you were still you were conducting the analysis as the evidence was being inventoried?
That is true. Because of the high-profile nature of this case, an item of evidence would be submitted to the lab. It would be inventoried by our evidence management group and then sent to the various units for testing. For example, the DNA casework unit. We would begin testing as additional evidence was being delivered to the FBI lab.
Now, as a result of your analysis, do you produce case files?
Yes, I do.
And document your examination in other ways?
Yes.
Do you have your case file with you?
Yes, I do.
Okay. And in your case file, are there notes of conversations that you have with people that are relevant to your testing?
Yes, that's called our communication log.
Now, do you have your case file there in front of you?
Yes, I do.
I think the pages are numbered. So I'll ask you to go to page 22 of your case file notes.
Okay.
And if I could direct your attention to the bottom of that page, there is a communication log entry dated September 13th. Do you see what I'm referring to?
Yes, I do.
And would you read to the court what your entry is for that date?
Yes. This is my communication date, communication entry on September 13th, 2025. All spoke with FBI Special Agent Folger and Utah SBI SA Dave Hull. Gave technically reviewed results that Robinson was included as a possible contributor to the DNA from the towel and the screwdriver. We discussed the additional examinations conducted by DCU, and they both agreed that no additional immediate comparisons are needed at this time. All remaining comparisons will be in the laboratory report.
Is that an accurate
they didn't
reflection
say
of
it's a
what you told
match.
the agents at that time?
They said
Yes, it is.
possible
And
contributor.
you told them that,
Lance Twigs is
quote,
for
Robinson
sure.
was included as a possible contributor to the DNA from the
There it
towel
is.
and the
Possible.
screwdriver, correct?
Yes.
Was the language that you used in conformity with requirements that you have for reporting out test results?
Yes.
All right. I'd now like to direct your attention, if I could, to exhibit number, State's Exhibit 31, which is in evidence. And I think it's our tab.
Lance Twigs for sure's DNA was on the towel, but
that's in evidence, so
but
if
Tyler
you could
Robinson,
display that
they
on
only
the screen.
can say it's possible that it's his DNA.
You can't use that in a trial as evidence. Impossible.
No,
It's got to
since
be
it's
valid,
not
solid
displayed,
evidence.
to the public.
Exactly.
Okay, let's go ahead and put it on the main monitor as well.
I don't know how they're getting away with half this stuff they're doing, you know, and why is the defense
Okay,
not
could you go to page
calling them out
6,
on this
please?
bullshit?
And highlight the third paragraph. This is your report dated September 15th, 2025, correct?
Yes, that is correct.
So this is 2 days after you had the conversation with the agents as to what your
Yeah,
results
that's
were.
huge.
That is
They've
correct,
been
yes.
claiming they got his
In your
DNA this
report
whole
that
time,
you
and they don't.
wrote 2 days
They
later,
do not have
you
Tyler
included this
Robinson's
language
DNA
that's
on this
highlighted
crap.
there, correct?
They have Lance
That is
Twig's DNA on this
This
stuff.
report conforms to the Department of Justice uniform language for testimony and reports for forensic DNA examinations. Correct?
Yes.
Okay. Now, I'd like you, if you could, to take a look at that.
That's
standard
exactly what
that
I
you
heard.
referenced.
Lance Twig's DNA
And I
is
believe is that-
definitively on the towel and the screwdriver,
And this will be
and
just
Tyler
to the
Robinson came out
not to the
only as
public.
a possibility.
Calling up
So they've
tab
been
7.
lying this entire time where they were saying they've got Tyler Robinson's DNA on the
Do you see
towel
that?
and the
See that
screwdriver and
on
the
your
gun.
screen?
That's a
Yes, I
complete
do.
Do you
lie.
recognize this document?
Yes, I do.
And tell the court what this says.
This document is the approved standards for scientific testimony and reports for autosomal DNA testing.
And is this the document that you were referencing in your report?
One of them, yes.
And is it a true and accurate statement of what the policy of the FBI is in regard to reporting DNA in a case of this type?
Yes.
I move that document into evidence, Your Honor.
So is it just this page or all the pages? Because it says 1 of 6.
Yes, so this would be the entire document.
Mr. McBride?
I don't see the relevance of this document. I object on relevance grounds.
Mr. Burt?
Your Honor, the document is referenced in her report, and it defines the parameters of what her opinion means. So I think it's very important for the court to understand the limitations of the opinions being expressed.
And just for my understanding, when you say in her report, are you referring to State's Exhibit 31?
That's correct.
All right, Mr. McBride, any further thoughts?
No, I'll submit it.
All right, so State's Exhibit, well, I'm sorry, how am I labeling this exhibit for the defense?
Your Honor, we have our exhibits organized by witness, and we would be submitting to the court electronic copies of these under named witnesses. So this would be Baker 7.
All right, Defense Exhibit Baker 7 is admitted into evidence, and as it relates to publication, what is your request, Mr. Burt?
Your Honor, I would ask that this be published since the report is published, and this is important to understanding the limitations of the report.
And so published in the courtroom and on the monitor for the media?
Yes,
Okay.
correct.
Any thoughts, Mr. McBride?
No objection.
All right, it will be admitted and published both in the courtroom and on the monitor for the video camera.
Okay, so this document has various subjects, correct?
That is correct, yes.
And it, in the beginning, tells you how to frame your testimony in terms of inclusions or exclusions, mixtures, sex determination, et cetera.
Correct, yes.
And then there's a section called Statements Not Approved for FBI Autosomal DNA Testimony in Our Laboratory Reports.
That is correct, yes.
Okay, so if we could go to page 5 for that statement. Okay. Under the topic absolute identification, is it the policy of the FBI when you're reporting out results that an examiner may not state or imply that a match provides an absolute identification of the individual from whom the biological material originated?
That is correct.
And you were following that policy in this case when you told the investigators that this was a possible match, correct?
That is correct, yes.
You never said it was an absolute identification of Mr. Robinson, did you?
Correct, no, I did not.
Now, the second guidance under that policy is an examiner shall not use the expressions reasonable degree of scientific certainty, reasonable scientific certainty, or similar assertions of reasonable certainty in either reports or testimony unless required to do so by a judge or applicable law. You're not, in your report, did not use any language that suggested you were giving an opinion to a reasonable degree of scientific certainty.
That is correct, it was not.
Okay. And then the next one, not that one, one more down. I'm not going to talk about race, ethnicity. That doesn't apply to this case, right? But 5.4 says, an examiner may not state or imply that forensic autosomal DNA examinations have a 0 error rate or are infallible.
That is correct.
And you followed that policy in this case, correct?
Yes, I did.
You're not in your report stating to the court that your testing has a 0 error rate, correct?
Correct.
You're not saying that the test is infallible.
I am not, no.
What is the source of error rates in DNA testing?
I'm sorry. Can you clarify your question?
Yeah, when it refers to don't state that there is a zero error rate. What in general are the sources of error in DNA, in the kind of DNA testing that you do?
Human error could be an error.
Mhm. Anything else?
Not that I can think of off the top of my head. One of the big things is potential human error. I guess you could also associate the DNA testing itself and how items are collected or how those items are tested.
Now, to your knowledge, that policy statement that we just read in Exhibit 7, Baker 7, was based on a more general Department of Justice policy, correct?
Correct, yes.
And that policy is called the Department of Justice Uniform Language for Testimony and Reports for Forensic Autosomal DNA Examinations using probabilistic genotyping systems, correct?
That is correct, yes.
And could you display 8 for us, please, to the witness? Let me know when it's on. No, not on the big screen.
Okay, so not to go onto this main big
Correct,
screen.
this is
Thank
just
you.
for the witness. And you're familiar with that policy, correct?
Yes, I am.
Okay. And does it contain a statement that support for inclusion is an examiner's conclusion that there is evidentiary support for the inclusion of a known individual as a possible contributor to the DNA typing results obtained from an evidentiary sample?
I believe it does, yes.
And did you follow that procedure in this case?
Yes, I did.
No, it doesn't. I think
does
that's
this
bullcrap.
Same policy
You can't
state.
use it if he's just a possible, if he's not
At
an
page 4.
actual, if he's, you know, if they can't prove for sure it's him, how can they use it?
Fourth down. One more. No, next one. An examiner, does a policy state, an examiner shall not assert that a likelihood ratio of any magnitude provides an absolute identification or source attribution of an individual to an evidentiary sample?
That is correct, yes. It does state that.
And you followed that procedure in this case, did you not?
Yes, I did.
You're not implying that those numbers that a previous witness quoted in our State of the Union report provides an absolute identification of Mr. Robinson or Mr. Twiggs?
No, I'm not.
Okay. Thank you. You can take that down. Are you also familiar with a concept called formal activity level?
Yes, I am.
Tell the court what that is.
Formal activity level is determining an activity that causes DNA to be left behind on an object.
And does your laboratory have a policy about whether you can express opinions about formal activity level?
We do have a policy, and I cannot give an opinion as far as activity level goes.
And why is that?
That is because DNA can be left behind on an object for numerous different reasons. So just because DNA is on an item doesn't necessarily mean that an individual touched it or utilized that item. So because of that, we do not opine on what activity may have occurred.
And consistent with that policy, you cannot tell, if you interpret a piece of DNA as being present on an item, you can't tell when that DNA was deposited, correct?
I can't give an exact time, but there are some situations, you know, if a piece of evidence has been buried for a long time or is in a river for a long time, it would be my expectation, based on my experience, that I probably won't get DNA off of an item that's been buried for 10 years, for example. However, I cannot give exact timing as to when DNA was deposited on an item.
And I was talking more about a
It's always
situation where you
possible,
actually find
absolutely.
DNA on an object, be it a gun or anything else. You can't say when that DNA was deposited, correct?
Sure, that's correct.
And how long in general does DNA persist on an item? Once you've made contact, how does DNA get deposited on an item in general?
In general, DNA can be deposited a few different ways, via body fluids such as saliva or blood, or skin cells. So touching an item or wearing an item, DNA could be deposited. Once DNA is on an item, if it's subjected to ideal conditions, it's out of heat and high UV, it's not subjected to any kind of cleaning or chemicals, it can persist on an item rather indefinitely. It can degrade slowly over time, but we've certainly worked items of evidence that are 40 and 50 years old, and we've been able to recover DNA.
Now, could you explain to the court the concept of degradation of DNA samples, what that means and what it suggests with your testing?
Sure. So degradation of DNA is breaking up the DNA. So if you think of DNA like a long rope, it's essentially taking that rope and cutting it up into pieces. Seeing degradation in a sample could lend me to believe that there may be, that sample may have been subjected to cleaning or high heat, an extended period of time. So I can't tell why an item is degraded, but looking at my data, I can tell if that sample is potentially degraded or broken down.
And two of the items that you examined were referred to as items 7 and 8, correct?
That is correct, yes.
One was a towel and one was a screwdriver.
That is correct, yes.
Were both those samples degraded to a certain extent?
May I refer to my
Certainly.
data? So item 8 was the screwdriver from the perch. I would say that there was some degradation. As I look at the DNA peaks or the DNA data, in an ideal world, if there's no degradation, I would expect all the peaks to be at the same height. Here I see a ski slope type effect, meaning that the data on the left is a little bit taller than the data on the right.
No,
As far
that's
as
the
item
thing.
7,
Tyler Robinson's DNA is not on them. That's the whole thing. His DNA is not on them. It's Lance Twig's DNA
item
is
7
on
was
them.
the
They're
towel.
saying they're
There
only
was
saying
a slight
Tyler is
amount
possible.
of degradation, but not as
Tyler's
much as item
DNA
8.
is a possibility, but it's not definitively. Tyler
What is the
Robinson
effect
or
of
Lance Twig's
degradation
DNA
on
is
production of
definitively
the
on the items.
Allele? First of all, what's an allele?
An allele is an individual's
it's
DNA
huge.
type. So we inherit half of our DNA from our
Huge.
mom and half of our DNA from our dad. We're looking at something called short tandem repeats, or STRs. These are small segments of DNA that repeat themselves over and over again. We all have those same sections of DNA, but what might differ amongst us is how many times it repeats, and that's actually what we inherit from our parents. So for example, at one particular location,
They haven't
my
said
mom
anything
may
about
give
the
me
rifle
14
yet. They
repeats
said
and
the
my dad may
towel
give me
and the
15.
screwdriver.
So when I'm looking at the DNA types, I would say that I have 2 alleles at that location, a 14 and a 15. As far as degradation goes, it could cause some of those alleles to do something called drop out, meaning when I'm looking at the DNA chart or the DNA data, I do not see information. I do not obtain numbers at that particular section of DNA.
And is it true that in the testing that you were doing in this case, STR testing, what you were looking at is the length of the, what I'll call, have you ever heard the boxcar analogy?
I have, yes.
Tell the court what that is.
So the boxcar analogy is how many times that section of DNA repeats. So that section is essentially letters. So for example, A, C, T, G. So you may have A, C, T, G repeated 10 times or 12 times. Each of those sections of H, C, T, G would be considered one boxcar.
And so when you're looking for alleles, you're essentially
Okay. Well, then,
counting
yeah,
the
his
boxcars.
DNA is not on it
Could be
either.
7 boxcars, and that person would be a 7.
That is correct, yes.
And from the mom and from the dad, he may have inherited 10 boxcars.
That is correct, yes.
And so that person at that particular location would be a 710.
Yes.
And what you're doing in your testing is comparing those numbers to what you get from a known sample to see if they match.
That is correct, yes.
Is that true?
Yes.
Now, is it true that what you mentioned the A, C, T, and G, correct?
Correct, yes.
Is it true that you are not measuring the sequence within the boxcars? You're just measuring the length of the boxcars?
That is correct. So the sequence would be equivalent to letters in a word. What I'm looking at is the number of words versus the letters that make up that word.
And we'll talk about this a little later, but people can vary not only in the length of the boxcars, but in the sequence within the boxcars, right?
And that is correct, yes.
And
yeah, I
what
don't
your
put up with
testing looks
trolls.
at is
I
just
kick
the
them
length.
out. They
Correct,
start
yes.
trying to start shit or come in
Now-
here fed slopping, they get kicked.
For the, and is it also true that you're looking
Fed slop
across
has gotta
many
go.
different locations?
Yes. So at
Yep.
the FBI laboratory, we use a kit called Global Filer, and this is looking
We
at
don't allow no
21
fed
different
slopping here.
locations on a human's DNA, in addition to 3 sex determining locations. That lets me know if an individual is biologically a male or a female.
As between two individuals, 99% of their DNA is exactly the same, right?
That is correct. And that makes sense. We're all humans. We all have arms, legs, and a head. Less than 1% of our DNA is what it differs amongst us, with the exception of identical twins.
But with the within that 1%, you're looking at these length differences, correct?
Correct, yes.
And you're looking at what you called short tandem repeats.
Yes.
How many, you said you looked at 25 locations?
We're looking at 21 and 3 sex determining, so 24 total.
What are the sex determining? They're called the locus, correct?
Correct. So
What are-
locus is that individual section of DNA.
Right. And they typically have names or numbers associated with them, correct?
Yes, they do.
So what are the sex determining loci?
So there is amylogenin, and that lets me know if an individual is male or female. And then there's 2 specific male sex determining locations. One is Y-indel and one is DYS 385. Those just let me know that those are specific to male individuals.
Okay. And then for the other locations you're looking at, those you're just looking for 2 types at each location, correct?
Correct, yes.
We'll be live streaming it all week,
Now,
by the way. So if you like
the
if
samples
you like
that
the
you
chat
looked at, the
today, you like the
7A,
stream, come back tomorrow. We'll be doing it all week for the whole
Did
trial.
you get
every
a
day.
full, what's called a full profile would be a profile where you have all 23 locations present?
That is correct. So a full profile means I have DNA at every single location. It is above our threshold, and I'm seeing 1 or 2 pieces of information at each location. For item 7, I did develop a full profile.
For item 8, you developed a full profile?
Yeah, there's no
And you know
DNA
Tyler Rock,
for
I mean,
furries.
Nope. So you know Lance Twig ain't gonna like that.
Item 8 was a partial profile, so I did not develop DNA at every single location.
Okay, so what that means in your comparisons is you have certain information in the question sample that for whatever reason doesn't appear, correct?
Correct, yes.
So you can't make a comparison at those locations.
That is correct.
All right. What makes it not appear at certain locations?
So it could be that there's degradation. So those larger locations could be broken up so that it wasn't detected during the DNA process. It could be a low level amount of cellular material to begin with. So if I only have a few cells, I may not have enough to detect at every single location.
Okay. And for the 8-1 sample, did you measure Mr. Robinson and Mr. Twiggs's DNA?
Thanks, my
at the
brother.
23 locations.
If you guys aren't following Ryan
For
Mata,
item
go
8,
make sure to follow him on
I
X.
did not have
This
a full
man's
profile,
doing
so
the
I did
Lord's
not
work too,
have
man.
data at all 23
That's the man
locations
right
to
there.
compare to
Follow
either
him.
Mr. Robinson or Mr. Twiggs.
Ryan
Right, but
Mata
you had
is a
full
real
profiles
one.
for Mr. Twiggs and for Mr. Robinson,
Yep.
right?
For their known sample?
Yes.
Yes, so for their known sample, that was a sample that was taken directly from those individuals, and I did develop a full DNA profile.
Okay. And just to illustrate how this works, is one of the loci that you looked at called the DYS 391 loci?
Yes, it is.
And what type was Mr. Robinson at that loci?
Oh yeah, we showed one of his videos today earlier during the break.
At that location, Mr. Robinson was an 11.
And it's, I think you said you inherit one from your mother, one from your father. But when you say he's an 11, technically he's what's called an 11-11, correct?
So for this, so DYS 391 is actually that male location. So he would not have, or anybody would not have inherited anything from their mother. So at this location, I would only expect to see one piece of information, and I did see an 11 here.
Okay. And for the D3S loci, what was his type?
His type was a 17.
Now for that loci, you'd expect two types, correct?
That is correct.
And when you say he's a 17, do you mean he's actually a 17-17?
That is correct. He inherited 17 repeats of that location from mom and 17 from dad.
Other locations, for instance, the VWA, he's type 18-19, correct?
That is correct, yes.
So you're looking at those, and what the machine produces are peaks, correct?
Correct, yes. They're just spikes on a graph, similar to like spikes on a heart monitor.
And you said for 8A, you had certain locations where the test sample didn't have any results.
That is correct.
So at the TPOX location, Mr. Robinson's a type 8-9, correct?
That is correct.
Mr. Twiggs is a type 8-11.
That is correct.
But when you looked at the sample, 8A, it didn't have any of those types.
That is correct. So I could not compare at that location.
Now, are there certain rules for when you exclude someone? In other words, when you're comparing two samples, are there rules which say, here's where I would conclude that he could not possibly have contributed this sample?
Yes.
Your field has a lot of literature written about it, correct?
That is correct, yes.
And do you generally like to keep up with that literature?
I do, yes.
And across time, there have been several books, publications that attempt to educate you and courts and lawyers on the technical aspects of DNA testing, right?
Correct, yes.
One of the books, the early one, DNA Technology and Forensic Science by the National Research Council.
I'm familiar with that, yes.
That's an authoritative book that was really one of the first books on DNA testing.
Yes.
All right. And then by the same organization, National Research Council, the Evaluation of Forensic DNA Evidence, published in 1996. So you're familiar with that as well.
Yes, I am.
And then there's an author, I believe, who did his research work at the FBI named Dr. John Butler.
Yes, I'm familiar with him.
And you have studied his work both in your training and your continuing education.
That is correct, yes.
And he's got 3 current textbooks on the topic that we're talking about, right?
I'm not familiar with how many textbooks he has. I know at least the one.
Fundamentals of Forensic DNA Typing.
Yes.
Familiar with that. Forensic DNA Typing Methodology.
Yes, I'm familiar with that one as well.
And Forensic DNA Typing Interpretation.
Yes.
Everybody in your field relies on these publications and use them as teaching tools.
Yes, I would agree with that.
And then in addition to those books, there have been studies that have been done on particular topics, correct?
Yes.
In this case, we're dealing with mixtures, correct?
Yes.
And mixtures present certain challenges that are not present when the samples are not mixed, correct?
Not necessarily. So first, to define a mixture, that simply means DNA from more than one individual in a sample. So if I were to take a sip from a coffee cup and my husband were to also take a sip, if I were to swab that coffee cup, I would get a mixture, his DNA and my DNA together. As far as it being difficult, you can have some mixtures where there's one contributor that donates a lot of DNA and the second contributor donates a little bit. For DNA interpretation, that is not challenging for me. Where it can become challenging is if you have 4 or 5 individuals within that sample all donating roughly around the same amount, it may be challenging for me to determine if a person is included or not.
And would you also agree that that challenge exists in situations where you have what are called low quantities of DNA?
Again, that could be possible. So I could have low quantities of multiple individuals, which is simply just saying that I can't determine which piece of DNA goes with which individual. So that's possible.
What is drop-in?
Drop-in is where you have environmental DNA that's not inherent to that sample that's detected during our DNA process. DNA testing is very sensitive, so it could be that we have a peak that's detected, like I said, from the environment.
And what is dropout?
Dropout is when you have an allele that is not detected or a piece of DNA information that is not detected. So in the DNA chart, there is no number associated with that particular location.
And degradation can cause dropout?
Yes.
So if you have a person at a particular location that is a type 1415, and because of degradation, that 15 drops out, what you're seeing on your chart is just the 14, right?
That is possible, yes.
And that presents a certain challenge.
Yeah, I hope he
doesn't it?
runs for
Because
president.
If the 15 is not there, you could misinterpret that as a type 1414, correct?
Not necessarily. So we have thresholds. We have something called the stochastic threshold. If that 14 is above that stochastic threshold, I'm confident based on our validation, our testing, and my training that I only, the DNA type there is only a 14. If that 14 falls below that stochastic threshold, that could be indication that there is another peak. So when I'm interpreting, when I'm comparing, if that 14 is below threshold and someone is a 1415, I will not automatically exclude them.
What is stochastic effects?
Stochastic effects.
I'm going to object at this point. I think we've gone beyond the scope of preliminary hearing. I think this is getting into 702 material that's not necessary for the probable cause determination.
All right.
I think
Mr. Burt?
I think it goes directly to the reliability of the testing results that the state introduced. I think the court has to understand the limitations and the potential sources of error in order to assess whether these results are reliable.
And in regards to this line of questioning, how far are you going to go on this line of questioning?
I have this one question and I'm moving on.
All right, Mr. McBride.
I'll hold them to that.
All right, well, Mr. Burt, so the objection is overruled. You may proceed with that question.
You can answer.
Could you repeat your question, please?
Tell the court about stochastic effects.
In other words, shut up and
effects
move
when you
on.
have low-level samples during the DNA copying process, based on how the DNA is copied, you could have alleles that are copied better than other alleles.
Okay. Now, on another topic. I
Exactly.
mentioned studies before. One of the studies that
That's
you're
why he
familiar
shouldn't
with is
be.
called the PCAST report. Are you familiar with that report?
Yes, I am.
And tell the court what that is.
PCAST report is, PCAST stands for the President's Council of Advisors on Science and Technology. And this was a committee that was found, I believe, under the Obama administration that gave guidance on different areas of forensics.
Yeah, I thought you had it confused.
Including how to deal with mixed samples and how to deal with samples that have low quantity of DNA.
I don't know that I would agree that it's how to deal with them. They gave some of their concerns on low-level samples and mixtures.
And they also did a follow-up report to assess whether using the kind of software that you used in this case had been established as reliable, correct?
That is correct.
And what was the software that you used in this case to reach your statistical results?
The software is called StarMix, STRMIX.
And the PCAST report specifically addresses whether reliability has been established with respect to StarMix, correct?
I don't believe reliability came into question. I think PCAST thought that there needed to be additional testing as far as mixtures and low-level samples go.
Mixtures and low-level samples that had certain characteristics, right?
That is correct, yes.
Including mixtures where what's called the minor contributor was in the sample below 20%.
That is correct. So the minor contributor would be an individual that donated less DNA to that sample. So PCAST called into question mixtures of 3 or more individuals with that minor or that low-level contributor making up 20% or less.
7 and 8 samples in this case were both mixtures, correct?
Yes, that is correct.
And did you determine what the proportion of mixture was between what I'll call the major contributor and the minor contributor?
So I did not calculate that personally. Part of the StarMix software, it does a couple different things. One, it takes a mixture and it uses math and biological modeling to try to break that mixture into its individual contributors. And then it also calculates the likelihood ratio, which is the statistic that I report. During that process, it does give an estimate of the breakdown of those potential contributors.
And what was, first of all, for the 7 sample, was the minor in there at less than 20%, according to StarMix?
Yes, it was. For one of the runs when I compared to Mr. Robinson conditioning on Mr. Twiggs, it was a 5% to 95%.
And how about for the other sample?
For item 8, one of the contributors was 11% and the other was approximately 89%.
So below 20%, right?
Correct, yes.
And the concern expressed in this report, which was written by experts in your field, correct?
No, that is not correct. The PCAST report was written by individuals that were not practitioners or any type of laboratory personnel.
Right, but they list the experts who provided input into that report, do they not?
Yes, they did.
One of them was Bruce Bedoli, correct?
Correct, yes.
Who's Bruce Bedoli?
He is a DNA expert within the field.
Well, he was the head of your unit for a number of years before you came on board, wasn't he?
He was, yes.
And he's written extensively on forensic DNA testing, has he not?
He has, yes.
The report also lists Eric Gilkerson, correct?
That name does not, I do not recall that name.
Forensic examiner for the Federal Bureau of Investigation Laboratory.
I don't recognize that name.
How about Bruce McVicker, forensic examiner, Federal Bureau of Investigation?
Objection, Your Honor. I'm going to renew my objection. I think this is beyond the scope of determining probable cause. The standards that apply here are that the court weighs the evidence in the light most favorable to the state and avoids credibility and balancing the evidence at this stage. I think we're far into 702 territory at this point.
Mr. Burton.
I'm not sure I understand the objection into 702 territory. 702 deals with reliability of evidence. That's what the court is here to determine. So again, it's directly relevant to reliability. This report criticizes, for the specific samples she's using here, the reliability of this testing. And her response was, oh, but they weren't experts. But the report indicates that there were experts who were consulted on this report. So I think it is relevant, and I think it goes to the issue of reliability. And it's the only question I have on this area as well.
Anything further, Mr. McBride, or do you wish to respond to that?
Just that 702 deals with admissibility. It does discuss reliability, but it's directly related to admissibility of the testimony at trial under the Utah Constitution and under the robust case law in this area. The court does not weigh the evidence, draws the inferences in the favor most in the light most favorable to the state. And I think we're beyond that point now. We're getting into the admissibility questions.
All right. Anything further, Mr. Burt?
No, Your Honor.
All right. Well, as this is the last question, I'm going to overrule the objection, but as a reminder to all parties that this is a probable cause standard, and as it relates to, well, I will just leave it at that.
Are you familiar with that analyst?
No, I'm not.
Okay. Just to close the loop on the PCAST report, what they said in the report was that published evidence supports the foundational validity of probabilistic genotyping with some programs of DNA mixtures of 3 individuals in which the minor contributor constitutes at least 20% of the intact DNA in the mixture, and in which the DNA amount exceeds the minimum required level for the method. Isn't that what they concluded?
That sounds accurate, yes.
And do you know why the level 20% raises reliability issues?
I do not know.
Okay. But you do know that in this case, both your samples had minor contributors below 20%.
That is true, but in this case, it was also only a mixture of 2 individuals.
All right. Now that's the next thing I was going to ask you about, which is what is NOC?
NOC stands for number of contributors.
And when you use this program, this genotyping program, StarMix, who decides what the number of contributors is?
That's my determination based on my experience and training, looking at the data. That's something I input into StarMix.
Right.
So it's subjective.
A complex determination, is it not?
Not necessarily.
But it can be in some cases, correct?
It could be,
again,
if there's
subjective.
mixtures of a lot of individuals and a lot of the peak heights, the size of the spikes are relatively the same. It could cause it could cause some trouble for me as an examiner.
All right. One of the groups that studies your field is the National Institute of Standards and Technology, correct?
That is correct, yes.
They're in the Department of Commerce,
I believe so, yes.
federal agency.
Yes.
And they published a report in 2024 called Forensic DNA Interpretation and Human Factors, Improving Practice Through a Systems Approach.
Exactly.
You're familiar with that publication, right?
I am, yes.
And was that a publication written by scientists?
I don't recall exactly who the authors of that publication were.
Okay. Just to make sure. That the it's a long report, right?
Yes, it is.
And you've read it.
I've read highlights of it.
Is it true that one of the things that they say in that report is they have a section on the complexity of number of contributor estimations?
Objection.
Are you?
Same objection, Your Honor. This is beyond the scope of a preliminary hearing. Again, we're talking about expert reports. We're talking about scientific studies. These materials are all fine to consider at a 702 admissibility hearing.
at this stage where, again, the evidence is viewed in the light most
You
favorable to the
guys see
state,
why
this
he
is
keeps
unhelpful
doing
for the
that,
court's
and he wants to
determination
stop
that
him
we're
from
relevant to this
from
proceeding.
continuing to talk?
Thank you, Mr. McBride. Mr. Burt.
Your Honor, I think the report
Exactly.
that the state
He's
put in
trying
evidence,
because
as
he's getting
clarified by
to the
this
fact that
witness,
Tyler Robinson
indicates
should
that
not have been
she reached the
included
conclusion
in that DNA
that
profile at all.
Mr. Robinson and Mr. Twigs were, quote,
And they don't want him to make
possible
that point.
contributors to these two samples. And so the one thing the court has to weigh is what is the weight of that opinion given the science or lack thereof? And one of the important issues here is how she derived these statistical numbers. And as an offer of proof, I'll indicate to the court that the numbers derived from this software program, and that software program is dependent in large part on how many contributors the analyst puts into the input of the software. And the numbers can change if the number of contributors is changed. And in this case, as I'll show through the examination, this examiner originally thought there were 3 contributors. And I will show to the court why she changed her analysis.
Busted.
And will indicate through this publication
busted.
that there has been criticism of the way in which she determined
this is the
number of
defense
contributors.
talking
So I
right
think
now.
it's important for the court to assess whether you've got accurate numbers in front of you. The state put in these astronomical numbers and are asking the court to give weight to them. And I'm asking the court to consider how those numbers were arrived at and whether there are reliability issues with regard to those numbers.
So the concern that I have is, I turn to State v. Ramirez, 2012 UT 59 at paragraph 10. It states, furthermore, the magistrate's role does not encompass an assessment of whether such inference is more plausible than an alternative that cuts in favor of the defense. That is a matter of fact finding, which is left for the jury at trial. And so when I'm staying in my role as a magistrate, I hear what you're saying, but my concern is based off case law that dictates what I as a magistrate should be doing.
So he's going to leave it up to the jurors to make the decision.
My fear is, as we go further down this path, which again, it's not precluding if this were to proceed, if there
what
were
he's
a
saying
binding,
is
or if
Tyler
there was
should
a
not even have been
trial,
included.
that
According to the rules,
certainly that
Tyler
could be
should not have
determined,
even
but
been
at this point,
included
at this
as a possible
stage,
contributor. But he doesn't care about any of that. That
How
just shows you how
weigh
corrupt he is, man.
this issue as I'm weighing State v. Ramirez and deciding whether we're going past
We'll leave it up to the
probable cause
jurors that we're going to
Sure.
handpick
And I
and
think
make
the answer
sure
to that is we have to take into account the ruling that you made in this case, which is the law of this case.
So bad.
Which is when we objected to the hearsay aspect of these DNA reports and other reports, you ruled that you are the ultimate determiner of the reliability of the hearsay evidence being admitted. And you will recall that our argument was the statute was unconstitutional because it was dictating that you find certain evidence to be reliable without considering whether it was reliable. And your ruling, as I understood it, was no, you retain the ultimate determination of whether the evidence is reliable. And that's not a credibility issue. Is this reliable hearsay that the state is offering? And so
exactly, it's
issues
not
that go to
reliable.
whether these numbers that the state is putting in front of you are reliable, I think go directly to the substance of your ruling, which is that your role here is to determine reliability of evidence. And I'm familiar with a case that the court cites, but I think that has more to do with weighing evidence and making credibility assessments. Whereas I'm focused on what the court ruled, which is we have to look at reliability here. And that's my job as a magistrate.
Mr. McBride, any final thoughts?
Yes, under Rule 1102B.
And it keeps pissing me off that he keeps giving the prosecutor the last word, because this judge can clearly, whoever talks to him last, he seems to always go with whoever talks to him last.
Credibility determinations are not proper for the court to make here for the whole reason that studies supporting this science, studies opposing this science, testimony from this expert or that expert about what is reliable, what is not, what's more reliable, what's less reliable, factors that affect all those determinations. Those are all very, very complex decisions. There will be probably multiple day hearings dealing with that. And a probable cause determination is just not the place to conduct that kind of thorough, in-depth, and searching analysis. Rather, the case law, the Constitution.
Yeah, it is. You're trying to hold him, saying you got DNA evidence on him when you don't.
The case law, the
I think
rules
I think that
say
is
the court does
very
not
important.
weigh the evidence at this stage, but leaves that for a finder of fact, the jury, in the end. That all supports cutting this line of questioning off at this point, rather than going on for into greater depth, Your Honor.
All right. Well, based off what's been presented before me, I'm going to sustain in part and deny in part the objection made. I'm going to allow this question to be asked, and so that is denying, but sustain in the sense that this would be the last question, and if Mr. Burt would chooses to, may go on to a different subject or a different line of questioning.
Sure.
That's such bullshit.
Did that NIST report
This judge is so corrupt,
conclude that
man.
it remains
This makes-
unclear
I want to
if
just
visual inspection
I'm so mad.
renders consistent number of contributor estimations across analysts over time?
Can you repeat that?
Yeah. Did the report, the NIST report that you referenced, conclude that it remains unclear if visual inspection renders consistent number of contributor estimations across analysts over time?
I think that goes to the DNA evidence. Again, we never truly know the number of contributors in a forensic sample. So like I mentioned before, you could have DNA mixtures that are made up of 2, 3, 4 individuals. I have training, I have experience, I followed standard operating procedures. So I'm making the best determination based on the evidence, the DNA evidence that I have as far as number of contributors
Yeah, I know, right?
goes.
Now, if I could, I'd like to return to your case notes, and could you display for the witness page 365?
Exactly. They're trying to make it fit in it.
And while he's doing that, by the way, it's true that if you change the number of contributors, you're going to get different numbers from the software program.
It depends. So actually, each time you run the software, you will get a different number based on the math that the software system does. But there are studies and validations that show we don't expect that math to be greatly different, usually by a factor of 10. Changing the number of contributors, it depends. If you have a major contributor, someone who's made up most of that DNA profile. If I originally interpret something as 3, calculate a statistic, if that major contributor is the individual that I'm comparing to, if I change the number of contributors to 2, based on the studies and based on my own experience, it doesn't change the likelihood ratio of that major contributor by much.
But it does change, correct?
Yes.
And you just said, I think, that even when you put in the same parameters, you don't get the same answer if you run it through STR mix more than once, right?
That is correct. Based on how StarMix utilizes math and distributions, you will never get the same answer twice, but it will be no more than a magnitude of 10.
So the
Me too.
That test is not reproducible in the sense that you can run it a sample or your assumptions in there 10 times, you could get 10 different answers.
That is true. Again, all within the first time I run StarMix, I'm not going to get a likelihood ratio of 10, and the second time get 10 quadrillion. I might get 10 quadrillion the first time, 2 quadrillion the second time. But even if I run it 10 times, I'm still going to get around the same likelihood ratio value.
Now, could you look at tab number 4?
Amen.
Absolutely. We all need to pray.
If you could bring that up to the witness.
Absolutely. Amen.
Let me know when you have that in front of you. I think you need to scroll up one page. There we go. Can you identify this page from your notes?
Yes, I can. These
They're
were
running late
notes that my
tonight, aren't
technical
they?
reviewer made.
It's
And my
already 5
technical
o'clock.
reviewer, they will
Damn.
review all of my DNA evidence. They will draw their own conclusions as far as number of contributors and comparisons, then compare it back to my conclusions.
All right, so this is regarding the 7 sample, correct?
That is correct. That is one of the samples.
And your original assessment was that there were 3 contributors to this sample, right?
That is correct, yes.
And that conclusion was reviewed by a reviewer, correct?
Correct, yes.
She read the same electropherograms or the name for the output of this technology you use, correct?
She utilized the same electropherogram, which is the chart that the DNA is on.
And does this page in front of you, is that an accurate representation of your case file?
Yes, it is.
I move into evidence page 365. And that would be Baker 4.
Mr. McBride?
I'll object on relevance grounds.
All right, did you want to respond, Mr. Burt?
Your Honor, it's relevant because the witness originally determined that there were 3 contributors. And I'd like her to explain to the court how she reached that conclusion, because I think it does go to the reliability of her testing here.
All right, so as it relates to Baker 4, and this is her personal notes from Ms. Baker as it relates to what I'm assuming is State's Exhibit 31, these notes were prepared as part of the report in State's Exhibit 31. I will find that it is
Your Honor,
relevant and that it is admitted into evidence as regards to publication. What is the request?
Your Honor,
Mr. Byrd?
if I may clarify, I think the testimony was that this was not her notes. That these were the notes of her technical reviewer, is what I heard.
Please correct me if I misheard that from both sides. I want to make sure. I want to make sure, are these Ms. Baker's notes?
Could I clarify that?
Absolutely.
Ms. Baker, these are notes in your case file, correct?
These are notes in my case file, but they're not my notes.
And the way your lab works, you're not the one that does all the different steps in the testing process, correct?
That is correct.
Other analysts have input that then all goes into the case file, which you have access to and rely
So where are
upon
those?
in rendering your opinions.
That is correct, yes.
All right.
And this particular page is.
Then where are the rest of them? Why aren't the rest of the DNA people testifying then?
That you relied upon.
Where are her peers
Correct.
at?
After
Her
I made
peers
my
should be testifying
interpretations
too.
and drew conclusions, my technical reviewer then reviews the data and draws their own conclusions. So this was created after I had already drew my own conclusions.
All right.
So after she made her conclusion of
together
2,
here.
this paper with the technical concluder said there was 3 then. So the technical guy disagreed with her saying that there were 2.
The question I'm trying to get to, counsel, was this particular.
That's what it sounds like to
recognize
me.
it as it being prepared by someone else, but as it relates to State's Exhibit 31, was this relied upon in order for State's Exhibit 31 to be put together as the report? Because I'm trying to determine relevancy as it relates to that, and that's a crucial point I don't have the answer to just yet.
Okay. Let me lay a more adequate foundation. The case file notes are assessed by you at every step of the analysis, correct?
Not necessarily at every step. Before I issue a report, before I write a report, I review all of the case notes. So that will be any communication log entries, any documentation from the laboratory, the biologists that perform the DNA testing. I will review all of that, write a report, and then give that to a technical reviewer. They will draw their own conclusions to determine if they agree with me. If they do, they will sign off, and then my report and my case file will go for an administrative review to make sure that the laboratory number is correct on all the pages, that if there's any cross-outs, there's dates and initials and so forth. Those 2 reviews have to be done before I can actually make it a final report and case file that gets submitted and sent to the field.
And in this case, correct me if I'm wrong, but the sequence was you originally determined in sample 7 that there were 3 contributors. That conclusion got reviewed. Then you ran some further testing, and then you change your conclusion, correct?
That is correct, yes.
Right. And before you change your conclusion, you of course go back and look at what the reviewer said about her review.
We would have a discussion. If I say a number of contributors was 3, he or she notated that it was 2. We had that discussion. She agreed with 3. So for that step of that process, because again, we're piecemealing this. Typically in a normal case, we will work all of the evidence. I will write a report. For this situation, I had DNA evidence coming to me throughout the day, throughout the night. So I had reviewers at different steps, which is not usual for a case. Usually I have 1 reviewer. So in this case, at that particular time, I had a reviewer. Then when I was submitted additional known samples and used those for comparisons, then I did have additional conclusions and additional reviewers.
But you certainly took into account this notation on this page before you changed your conclusion, correct?
I don't know that I would agree that I took into account. We had already had that conversation. And again, once I received additional known samples and additional information from the field, I then did amend my conclusion.
And these notes are kept in the ordinary course of your business?
Yes.
And they're part of the case file that you rely upon in reaching your conclusions?
They are kept with the case file after I draw my conclusions.
So Your Honor, I think there's a foundation for this. The state has offered all kinds of hearsay here, and certainly this is, there's no question about the reliability of the entries.
All right. Anything further from the parties before I weigh in on, well, make my ruling on Baker 4?
No.
The court finds that it is relevant and as it relates to State's Exhibit 31 and Baker 4 is admitted into evidence. In regards to publication, Mr. Burt, what is your request?
That it be published.
All right, to in the courtroom.
In both the courtroom and
all right, go ahead and publish that to all screens and may be captured by the media.
So these discuss 3 NOC and okay with 3. Could you translate that for us, what that means?
Sure. So when my technical reviewer took a look at the DNA evidence, she determined that male DNA was present, and she concluded that she would have called it a number of contributor of 2. She compared it to my conclusions. I said number of contributor 3. So we had a discussion as to why she thought it was 2, why I thought it was 3. And she said she agreed with me calling it 3 based on our discussion.
Okay. So was that an extended discussion you had with her or just?
Oh, no, this was a quick discussion, and this is not unusual. We have discussions like this during the technical process quite often.
And the stamp on the bottom, approved by Tara Benson, is that the reviewer?
Yes, it is.
Talking about? All right, thank you. Now, I want to ask you to look at page 128.
She just admitted 3 again, not 2, 3 contributors.
Right. The other one was saying they found 2, and she's saying she found 3.
Is this an electropharogram?
Exactly. And if you find more than 2, if you find 3,
yes, it is.
And it's under 20, and Tyler Robinson was 11, he should not have been included as a contributor.
I'm sorry, there's nothing on the screen. Am I?
Yeah, 128.
Yes, it is.
I moved that into evidence, Your Honor. This would be Baker 4, page 128.
Oh, I thought I already admitted Baker 4. Is this a different? The previous one was Baker 4, as I understood it.
Yeah, Baker 4, page 365.
Oh, okay. So Baker.
And so this is Baker 4, page 128.
Right, so the previous admitted exhibit is Baker 4, 365. The current proposed one is Baker 4, 128.
That's correct.
All right, Mr. McBride.
If I could have just a minute to update my notes on those page numbers.
All right. 365 was the previous one, unless I heard it wrong.
Yes, that's right.
All right, and the current one is 128.
What's her position called again? A DNA
First,
analyst?
I'll note this is the first I'm seeing these as exhibits. Of course, I have this.
I don't know.
file,
I
but
didn't
was
catch
unaware
it.
that we were going to be.
She's
these are going to be
something to do with the
offered as
DNA,
exhibits, so
though.
I'm looking to find them in my file as we go. Second,
Somebody in the chat
again, I'm going
write
to
her
object on
exact
relevance grounds
position.
to the probable cause determination. We're going through the finite details of the analysis here. And once again, I think these are
If you
appropriate
caught
questions
it.
to raise in a 702 hearing. But when, with the standards that apply at the preliminary hearing that I've already discussed, I think we're beyond the scope of probable cause determination as we dive into this evidence.
All right, Mr. Burt.
Your Honor, I think this exhibit is particularly important because the court does not yet have in front of it what an electropherogram is and how it's interpreted. And this particular page will illustrate to the court how the analysts interpreted the peaks on this electropherogram to reach the conclusions that she reached, that there were 3 and
She
not
said
2
it was the
contributors.
manager.
I think it will assist the court
Forensic
in determining
examiner.
exactly how
It
this
says
comparison
forensic
process
examiner
Oh,
works
yeah.
to her name.
and what the output
Oh,
looks
yeah.
like. So the court
Duh.
Oh, yeah, it does
see
down the
exactly
bottom of it.
how the
That's right.
interpretations are being made.
And is this the dose that were relied upon in?
Yeah, we're
So
we're
I'm
8.5
viewing-
hours
for
deep,
that.
so my
Exhibit
eyes are a
31
little
as a
bit.
summary, and this more of showing the work
Yeah,
of how
for
the
real.
summary was reached. Am I misunderstanding how this fits in?
This fits into how the analyst originally was of the opinion that there are 3 people here and not 2. And she will go on to explain how she changed the interpretation from 3 to 2. And the point of this is to illustrate to the court that this is a subjective process to a certain extent. And that
She said it
people can
says
read these things in
forensic
different ways.
examiner force.
Um,
Can't you see?
And so I think it will help the court understand exactly what's being compared here. You've got peaks on a line, she will say, and just to let the court know in responsive to Mr. McBride's
Thank you.
statement that he was unaware that this is going to be an issue. He and I met with this analyst before the preliminary hearing. The analyst pointed this page out to us as
Bingo,
being
absolutely.
illustrative of why she originally concluded that there were 3 contributors. So this is not something that's being sprung on the state. He was a part of that conversation, and this particular page was identified by the analyst, not by me. So it is important to understand why we went from 3 to 2 and what impact that has on the numbers that the state is offering.
All right. Anything further?
No.
All right, under Utah rule.
Her official
evidence
title is
1102,
dumbass.
B4, it says scientific
good one.
laboratory of forensic reports and records.
That's
I find that this
friggin'
is
funny.
admissible, and
And of
it
course,
is
the
admitted
comments from
into
Seymour
evidence as
Butts.
Baker 4, page 128.
Gotta love it.
And is a request to publish
Oh man,
this
that's funny.
document.
Okay, you can,
Was that a yes? Oh, okay.
yes.
All right, so published, I'm assuming to all, to the
That was
screen as well.
good.
All right,
Correct.
and maybe published.
Oh.
Council, just as a reminder,
Send him a
as this
super
is a
chat.
probable cause, I understand and I appreciate you giving me a pointer of where it's going, but just as a reminder, as probable cause,
Heck yeah.
it is admitted, and you may discuss it, but I definitely want to keep this within the track of probable cause.
Yeah,
Understood.
All right.
Seymour Butts there got the comment of the day.
Okay.
That's you cooked on that
That's
one,
right.
bro.
Is it true what I just told the court, that you pointed this particular
Definitely.
page out as illustrating why you originally thought we had 3 contributors?
Yes, that is true.
So explain to the court, is this an electropherogram?
Yes, this is an electropherogram. Each of those rectangles at the top, for example, D2S441, that is that small segment of DNA that I referred to earlier. And each of those peaks has a corresponding number that is the allele, so that corresponds to the number of repeats that an individual inherited.
And this is what you ultimately, after you get this electropherogram not through running it through STRmix. There's a different device that you use to produce these electropherograms, right?
Correct, yes. During the DNA process, this is the last step of that process. So what it's doing is DNA is found in cells of our body. We're taking those cells, we're breaking them open with chemicals to release the DNA from those cells. We're making photocopies of those pieces of DNA so that we can essentially see them. And then the last step is to separate those pieces by size, and the ultimate output is this electropherogram.
Okay. And is it true that you set the parameters for what the machine will pop up in terms of numbering the alleles?
Personally, I do not set that up. That was done during our validation of the chemicals and the software and the instrument that we utilize. But there are parameters. So the output of the DNA lets me know, for example, the different types of alleles, but that's not a parameter I set.
I want to make sure you answered that. You set, or your lab sets, what the machine does in terms of labeling particular alleles, correct?
Yes, that's part of the whole process and the validation, yes.
So you could tell the machine, give me all the peaks at whatever level and label them as whatever the alleles are.
I see. So yes, so during our validation, we determine our thresholds, our analytical threshold, and that stochastic threshold that I mentioned before. The analytical threshold is a threshold that was determined during validation that we input into the software that I utilize that says, for example, our analytical threshold is 150. Any peak that is 150 or greater, the software system will give me that allele call or that number for that peak. Any peak that's below the 150, the software system will not give me an allele call for it.
Even though it might be a true allele.
Correct, yes.
So you could say, and you referred to a measurement, you refer to that as RFUs, right?
Yes, that is the unit.
What does that mean?
It stands for relative fluorescent unit.
So in your lab, you tell the machine only label peaks that come above 150 RFU.
The software that utilizes the information from the machine, yes.
However, it's true, is it not, that in determining the number of contributors, you look below that 150 RFU level.
And that is true, yes.
All right, now on this is only showing 1, 2, 3, 4 different locations, right?
Correct, yes.
And you see a number of peaks at each one of these locations. Some of them are labeled, some of them are not.
Correct, yes.
So tell us how you originally looked at this and said there's not 2 contributors, there's 3.
Sure. So first what I do is I count how many labels that I see. So how many of those little squares under each of those locations. So for example, at D2S441, there are 3 squares. Knowing that one piece of information comes from mom and one comes from dad, if it's a single source profile from one individual, I expect to see no more than 2 squares. Because I see 3, that gives me an indication that there's at least 2 individuals. Same thing for the next D19S433 and as well as FGA. There were 3 peaks that were called. So I knew this had to be at least 2 individuals. Then what I do is I take a look at the peaks that are not called and determine, could there potentially be a 3rd person included? So for example, at D2, the location farthest to the left, I'm asking myself, that 12 in that bottom box, is it the same contributor as, for example, the 22 under FGA all the way to the right? Because I see peaks that are not labeled, it could be that the 12 belongs to 1 individual and those 2 peaks that are not called belong to a 2nd or 3rd individual. And that at FGA, I could be seeing the 22 from that 3rd person, but that 2nd person has dropped out. Because I'm able to use information below the threshold and I see peaks, that gives me an indication that I can increase my number of contributors to 3, which I did in this case.
Okay, and when did you reach that conclusion, time-wise?
If I recall, it was somewhere around September 12th.
And when did you change your conclusion?
That I would have to refer.
Sure.
I changed my conclusion on September 13th of 2025.
And explain to the court why you changed your conclusion?
I was submitted an elimination sample from Mr. Twiggs, and an elimination sample is a sample in which it's from a known individual, and then there's an expectation that the individual's DNA might be present. In receiving that sample and talking to the investigators, it was decided that Mr. Twiggs should be used as an elimination. When I compared him to this sample, all of the DNA, unlike that major contributor, matched to Mr. Twiggs. So because of that, I determined that there's actually only 2 individuals because those small peaks, there was nothing left for a 3rd individual to be compared to.
You use a phrase elimination sample. That's typically
so
used,
because
is it not,
Twiggs
in a situation
was the
where
3rd
you're
is the
testing
only
a
reason
sample
they say 2
has
because
more than one
the
contributor.
prosecutor said exclude
Not
Twiggs
necessarily.
as a
An
contributor.
elimination is just simply an individual that we're expecting their
Is
DNA
that
to
what
be
I'm
there.
hearing?
So for
That
example,
sounds
if
pretty
we
clear.
have a stolen vehicle, I will request an elimination sample from the known driver of the vehicle so I can subtract out their DNA to see what I have left over. It doesn't necessarily have to be more than 1 individual. There certainly has been times where I only detect that known expected individual.
And you said you had a conversation with the investigators as to whether Twiggs should be included as, or you talked to them about whether you should get elimination samples?
I talked to them with regards to if I should utilize Mr. Twiggs as an elimination versus comparing him and offering a statistic.
Okay, but in your report, you concluded, did you not, that one of the contributors to both samples was Twiggs?
That is correct, yes.
Right. You didn't just assume that, you reached the determination that he was the source of both those samples, one of the sources, right?
I don't want to use the word source, but knowing that there was an expectation that his DNA could be present, when I compared
line,
him to
and
that
sinker.
DNA sample, I did see his DNA types present.
Bingo.
So using the word assumed, that's verbiage that we use when we calculate our statistical calculation. I'm letting the software know, I know this individual is there. I'm assuming that they're there. Based on my comparisons, I did see evidence that that person was there.
But I guess what I'm confused about is we talked before about how your language should never imply an absolute identification. But in the body of your report, you say that one of the contributors is Twiggs. You don't say he's a possible contributor like you do for Mr. Robinson. You say he is a contributor, do you not?
I do, and with elimination samples, that's slightly different. So for example, let's say I have a sexual assault case and I have a vaginal swab from a female. She has a consensual partner. I can request an elimination sample from that consensual partner. If I see that they're present, I can say they're present and say the DNA foreign to that victim and that consensual partner is one person, for example. So it's different than comparing a known individual. If they're an elimination sample, I can say that I expect their DNA to be there, and based on my interpretation and reviewing that data, are present.
And based either on your conversations with the agents or other people, why did you think that Twiggs was someone whose DNA you would expect in those two samples?
So from what I recall, in speaking with the investigators, Mr. Twiggs was a roommate of Mr. Robinson, and it was thought that those items came from potentially Mr. Robinson's home. And I don't recall exactly if it was a situation where a particular towel was known to have been in that house. I don't remember that exactly, but in talking to the investigators, based on their investigation, it was important to assume potentially Mr. Twiggs was present.
Right. Did any investigator ever tell you that the towel did not come from Mr. Robinson's home, but was found in a bush out at the university?
I was aware of that, yes.
So you knew that that towel was not found in a place where you would expect Mr. Twiggs's DNA to be present.
That is correct.
She
It
just
was
caught
found
her
outside of
lying
a
again.
home, but
They're
again,
all
based on
colluding. He just
speaking with the
proven they're all
investigators,
colluding.
they had information to suspect that that towel came from Mr. Robinson's home, and I should utilize Mr. Twiggs as an elimination.
Right. And again, you didn't assume that, you actually concluded it based on the match, right?
Based on reviewing Mr. Twiggs' DNA profile to what I developed from these items, I used him as an elimination sample.
Now, you did various STR mix, what I'll call runs, correct?
That is correct, yes.
And the way this works is you input the number of contributors. You determine that. And then they also have something called HD and HP, right?
Correct, yes.
Tell the court what that is.
So those are different propositions. So in calculating the likelihood ratio compares the probabilities of seeing a DNA profile given one of two different scenarios or explanations or hypotheses. One is that a particular person of interest is a contributor, and the other is that an unknown, unrelated individual is a contributor. So depending on the question being asked is how I set up StarMix, number of contributors. For example, if I'm utilizing someone as a known elimination sample, I will apply their DNA profile both to the HP and HD.
And the theory of this HP is the prosecution hypothesis, right?
Correct, yes.
And HD is the defense hypothesis.
Correct, yes.
So, and these are things you plug in based on your understanding of what the prosecution and the defense are contending.
Correct, yes.
So how do you plug in the HD in a case where you don't yet have the defense postulating what their theory is?
So HD, or the defense hypothesis, is simply the DNA profile, the probability of the DNA profile, given that it's another unknown, unrelated person to the prosecution's potential person of interest.
Mr. Burt, I don't want to interrupt your line of questions, but we've been going for just shy of
She's
2
trying
hours.
to talk in circles and confuse people, but we
break.
get it. You know, we understand exactly what the defense is getting at.
We'll come back at 3:50. Court is in a brief recess.
So yeah, that's a very important. So apparently what they're saying is, let me pause the music so I can talk over myself here. Okay. All right. So basically, excuse me. So basically, what they're saying is that Tyler scored a 12. Okay. The rules, the DNA rules as far as excluding somebody, I mean, as far as including somebody as a possible contributor, say that they have to score 20 or more to be a possible contributor. Tyler only scored 12. Now there is an exception. They said if it's 2 or more contributor, I mean, if it's 2 or fewer contributors, then you can include somebody if it's less than 12. I mean, less than 20. I'm sorry. Yeah, you can include it if it's less than 20, but only if it's 2 or less contributors. If it's 3 or more contributors, then 20 is the hard limit, and you cannot include anybody under 20 as a possible contributor. So the
And that's
fact
why
that they
kept
listed
wanting
Tyler
to
Robinson. Go ahead.
I was going to say that's why they keep wanting to go down to that number 2 and not include the number 3rd person.
Exactly. So that's why they, that's the whole thing. They they should not have included Tyler Robinson, because the difference between 2 versus 3 contributors is a huge issue. And with her saying that she felt there were 3 contributors, and the only reason that she went with 2 contributors is after talking to the prosecutor, and they excluded Lance Twiggs as a possible contributors, meaning they excluded him because they said, oh, we already know he's there, so you don't have to include him as a possible contributor. So they manually, even though his DNA is the only person DNA on that thing that they can definitively say for sure is his DNA. Tyler, remember, Lance Twiggs, 100% for sure, his DNA is on the towel and on the screwdriver. They're only saying that Tyler Robinson, it's possible that Tyler Robinson's DNA might be on the towel and screwdriver. But the thing is, like I said, the fact that they excluded Lance Twiggs as one of those 3 people, based on what the prosecutor told them to do, takes it down to only 2, which then allows them to say Tyler Robinson is a possible contributor when he's not. Because if Lance Twiggs was included like he should have been, because his DNA is on it, it would be 3. And if it's 3 or more, it has to be 20. If it's under 20, it's not a possible contributor. So Tyler Robinson should not have been listed as a possible contributor. They do not have enough DNA points to list him as a possible contributor on these items. That's what this was all about. The defense just was able to pull all this out. I hope people get that. I put out 2 posts. Go share my posts on X, please. I just put out 2 posts about this. This is very important. Make sure you tag Candace Owens on them too, and Baron Coleman. It's important that they know about it, and hopefully they'll share it too. But it's very important to know Tyler Robinson should not have been included as a possible for the DNA. It should not have happened, because if Lance was included, it would have been 3 or more. And 3 or more, you have to hit 20. The number is 20. I forget exactly what it's called, they said, but it's 20. The number you have to hit is 20, and Tyler was only a 12. So he would not have been excluded. He would not have been included as a possible contributor to that DNA had they not colluded to make sure that Lance Twiggs was excluded as a possible for the DNA. If that makes any sense. Hopefully you guys are getting it. Do you get what I'm saying, bro?
100%. And we can consider that whole analysis there as one in the piggy bank for the home team. The conspiracy theorists can put one in their piggy bank, and the Fed sloppers can eat it.
Oh, hell yeah, absolutely. So we can prove we can prove without a doubt now that Tyler not only is Tyler Robinson's not a possible contributor to that DNA, but also Lance Twiggs was the main contributor on that DNA. Main contributor. So now who do you think's guilty? Who do you think was the one that actually and by the way, I still don't think, even though Lance Twiggs' DNA is on it, I don't think, to be straight up honest with you, I don't think Lance Twiggs killed Charlie Kirk either, because like I said, I don't think he was killed with a gun. I think he was killed with the exploding microphone transceiver. However, that proves that Lance Twiggs is way more involved, that Lance Twiggs is the one setting Tyler Robinson up as a patsy. That's what that proves.
Good breakdown on that, brother.
Thanks. It's crazy his own DNA isn't on that gun predominantly. Absolutely.
It's because
Absolutely.
people need to understand that Tyler Robinson was not on campus. And now it's starting to look like Lance Twiggs may have been on campus.
Exactly. It looks like Lance Twiggs was actually the one on campus, and Lance Twiggs obviously would have access to Tyler's car. He would have access to Tyler's computer. He would have access to Tyler's phone, because Lance Twiggs lived with the guy. It was his boyfriend, supposedly. Lance definitely set him up. Absolutely. Yeah, that's another huge red flag right there, where they said that, the person in the maroon shirt, which by the way is not Tyler Robinson. They're trying to claim it's Tyler Robinson. It's not. But the person that they say had the maroon shirt on that went in the stairwell or whatever, they met with TPUSA, somebody at TPUSA. Absolutely. That's another hugely critical point that came out today. Yeah, absolutely. I think so. I don't think Tyler Robinson was there at all, to be honest with you. I think it was, I don't know if honestly, I think it was more than one person, but I still don't think Tyler Robinson was there at all. According to his parents, he wasn't there at all either. I guess while we are taking a break, it'd be a good time to see if we got any of the buy me a coffees. And by the way, once again, if you want to support the stream, if you want to support us, the stream is not monetized, so the only support we get is from you guys right here. So if you want to support the stream, you can scan the QR code at the bottom left-hand corner here. It says send a super chat, scan here. That goes to our Buy Me a Coffee, where you can donate to us, and you could also leave a comment, and we will read your comment out live on the stream here. When we get a break or whatever, we'll read all the comments out, and that's what we're going to do right now. So if you want to donate and you want your comment read, definitely hit us up on that and throw a couple bucks in the Buy Me a Coffee. All right, so let's check out the Buy Me a Coffee here and see if anybody else has donated anything. All right, we got one more. Can you please play the video of Tyler Robinson in the maroon shirt walking up the stairwell? I think I might have found something, from Serena Brown. Thank you for your support, Serena. I appreciate that. Yeah, we can pull that up real quick while we're waiting.
I'm gonna send a guy in a maroon shirt That was play that video and almost. There's so many maroon shirts that day. It's ridiculous. Let's see.
Yeah, I know the one she's talking about, though, the one in the stairwell the one that we just put out from earlier today.
No, this
one.
is another. Let's see.
I just got to get to the part where he's in the stairwell. I try to find the part where he's in the stairwell here.
And then after that, show these pictures I'm gonna send to you right now. And then they came in from Louisiana.
Okay, here it is.
And tell us if this is the same guy.
All right, so here's the picture of the stairwell, maroon shirt in the stairwell. I don't know what you think you saw. You want to tell us in the chat? You don't have to send another super chat if you don't want. You can just tell us in the chat. But yeah, we need, Let me go back to the comments. Oh, I wasn't even sharing it. Shit. Hold on, my bad. Share this tab instead. Okay, so there you go. There's the maroon shirt. I've got it. Now let me see. Whoever said they can, whoever sent me that buy me a coffee that said they see something with the maroon shirt, the guy in the stairwell. Do you have Venmo? Yeah, I do have Venmo. It's at My Buddy Service. It's at capital MY, capital BUDDY, capital SERVICE. So My Buddy Service. It's lowercase except the first initial or the first letter of each word is capitalized, no spaces. So I'll type it out. Hold on. At My Buddy Service. At My Buddy Service. Hold on. Okay, just like that. That's my Venmo. At My Buddy Service right there. So if you want to send something through Venmo, you can do it that way as well. Also have Cash App. You can do Cash App as well at Project Constitution. You can send it that way too if you want. Okay, so this person. Okay, we can watch both knees bend as he walks around with a 30-06 in his pants leg, supposedly. Okay, so that's what they're pointing out.
Got it.
So let's look at that and see if we see both knees bend. Absolutely. Let's check it out. And I'm pretty sure we can.
You may proceed.
Appreciate that, Judge. Thank you. Go ahead.
Oh, it went all the way back to the beginning again. Damn it. Hold on.
Purchase the food from?
Chick-fil-A.
Oh, wrong one. Hold on. Where are we at? Come on.
And he's carrying a blue backpack.
Describe the clothing.
Okay, here we go.
It's a maroon colored t-shirt with gray or olive colored shorts and then Converse shoes.
Okay, well, clearly both legs are bending here. I think she's talking about the guy in black, not the maroon
just after
shirt.
10 a.m.
And does he leave the park?
Because he's in shorts here.
Eventually.
He does, yes.
Okay. And during this visit, do you know where he goes?
Around 12:23.
Let's see if we can get back to the. Oh, whoop, too far. Hold on. Okay, so this is the one she's talking about, I think.
Again, he
All
seems
right,
to be
so
having
yeah, okay. We see.
issues walking.
Yeah, it's bending.
And again, were you able to track, were you able to track Mr. Robinson when he leaves this parking structure?
Yes, we were able to.
Okay. So when he leaves the parking structure,
Yeah, hold
where does
on.
he
Did
go?
it bend? Yeah, both of them bent right there. Do you see that? Both of them bent. As he rounded the corner, both of them bent. Watch this. Watch as he rounds the
Again, he
corner.
seems to be
Both
having
legs are
issues
bending.
walking.
Nope. See, he just lifted the leg. It just bent there. And now, oh, right there, it bent. Did you see it bend?
And again, were you able to track?
I saw it
were you able to
bend.
track Mr. Robinson?
Also, something that Allie pointed out earlier, Allie Top Files, by the way, she's another good researcher. You should be following her if you're not following her. But let me see if I can find her post real quick, because she pointed out that the backpacks don't match either. That the one backpack is blue and one backpack is black. Let me see if I can find it real quick. Yep, right here. So different backpacks. Look at these backpacks. This is a blue backpack with like a brown looking thing in the middle of it there. The guy in the maroon shirt has a blue backpack with like a brown thing in the middle. And the other guy in black has like a black or green backpack, and it's completely different. This has a spot higher up in the middle and then another spot lower up in the middle where it has some kind of writing on it. The other one only had writing on the middle at one spot. See? These are two different backpacks. Do you notice that? You guys see the difference? And then here's another picture where Mel got it too. You can clearly see this is a blue backpack. The one in the maroon shirt has a blue backpack here. This is from the neighborhood footage. See the blue backpack? And then black backpack, completely different. This one has completely different writing on it too. See the difference? Completely different. All right, what you guys say? What am I missing here? Yeah, at my buddy service. Yep, that's correct. All right, very good. I didn't do buy me a coffee message. Okay. I don't know what you mean by that, but that's fine. You don't have to. Yeah, they're not back in session yet. I got it playing down here below. They're still not back yet. Absolutely. It does bend while it's in the 4-2. I saw that. Absolutely. When he gets to the level, he walks up the stairs. Yep, he's definitely, yep, bends the right leg. Yep. Lettering on the backpack is different as well. Absolutely. I put it in Venmo and didn't show up. I'll scan later. Hold on, I'll send you guys the link to my Venmo. Hold on, give me a second. It might not be an ad in the front of it. It might just be My Buddy Service. Hold on. Yeah, okay, so there's no ad in the front of it. My mistake. Oh, no, wait a minute. No, it says not available. That's weird. It showed up for a second there, but now it says not available. Did someone get my Venmo banned or something? No, it works. Huh. All right, well, let me... copy. Let me see if I can do it like this. All right. Let me put the link in here for you guys. See if it'll let me do it this way. Come on, copy. And let me go to the chat. X. My profile. Live. Open live video. Oops. Live chat. All right, now we're back.
379. Very bottom of the page. Did you write there on the 15th of September, 2025?
All right, there you go. I just put it in the chat, by the way.
Gave update on report timeline. Discuss it upon
That is my
review.
Venmo.
It was decided that additional statistics needed to be run. Report will still be issued with Twigs as an assumed contributor per previous discussions with Folger and Carmack. You see that?
Yes, I do.
And what additional statistics needed to be run at that time?
So at that time, I believe I ran statistics with just Twigs comparing that individual to the sample. If I may refer, I think that was the only additional.
Delivery. Did I say My Buddy Service? If I did, that's my mistake. I apologize. Yeah, it's My Buddy Delivery. Yeah, that's me, Colin. Yep, you got it. You found it. Thank you. Sorry about that. That was my fault.
Yes, after discussion with my reviewer, it was determined that I was also going to calculate a statistic or compare Twigs by himself, comparing him to the evidence, and having that run in my case file.
Okay. And could you go to tab 38?
No, it's Colin, not Darren. Colin. It's Colin, definitely Colin.
Oh.
Yeah, it should not be on the screen.
Let's pull it down from the screen. Thank you.
Thank
So
you.
just to the monitors.
Oh,
of
someone
the attorneys and
messaged
the
me
witness,
from
Mr. Burt.
Bahala. I mean, from New Zealand
Just for
too.
the witness.
I'm gonna contact them after the case, by the way, bro.
And this is it. Yeah, page 39. Is this
Also,
the
didn't you say you sent me some
DNA
pics?
report?
Sorry, I forgot you said you sent me
I'm sorry,
some
the
pics.
Star Mix report that was produced as a
We'll
result
look at them
of
the next
your,
break, or when it's over, we'll look at
inquiry
them.
that involved a comparison of the sample to Mr. Twiggs alone.
Yes, it is.
And is that a 6-page report?
Yes, it is.
And is it a true and accurate copy of the STR mix report for that particular sample?
You said you sent me some pics. We'll check them out on the next break or afterwards. I forgot you totally said you told me you sent me some pics or something, right?
Yes, it is.
Yeah, all good, bro.
The Baker 38.
Okay, yeah, I got them.
39.
We'll check it out on the next break.
$44.
Baker 38, page 39 through.
I'm seeking admission as well as publication to the audience and the camera.
I just want to make sure I have the label correct. Baker 38, pages 39 through 44. Did I hear that?
That's correct, Your Honor.
All right. To the state?
Yes, Your Honor, I object on grounds of relevance to the probable cause determination.
All right. And Mr. Burt, would you like to respond?
Submitted, Your Honor.
So I'm not exactly
All right,
sure.
cool. Let me
what
check,
this
see if I
is
got
in
it. Thank
order
you
to
very much.
determine How it fits into the probable cause
And yes,
analysis.
Twiggs did get, he didn't get
so
full
a little bit
immunity
more
deal, but he
information, 'cause
got a
as of right now, I don't
limited
have enough to
immunity.
admit it.
Understood. And
But
I
yes, he
apologize
did
to the
get an
court.
immunity
So
deal.
the report that was admitted into evidence has the conclusion in it that both samples were contributed, that Mr. Twiggs was a contributor to both samples. And this is the report that the analyst ran in order to make that determination, I believe.
All right.
Thank you very much for the memo.
Did these reports?
Not a cat lady. Thank you very
Were
much.
these made prior to State's Exhibit 31 being prepared?
Yes, that's correct.
All right. I will admit, so Baker 38, pages 39 through 44 is admitted and may be published. Again, as a reminder, for all attorneys, this is a probable cause standard. So if all parties can just keep that in mind as we're moving forward on this.
Sure.
Thank you.
Thank you.
And so it may be published to all screens.
Yeah, it's page 39.
No, but the actual dates number, I'm having.
So is this the report that you referenced in your notes that you needed to run the sample through StarMix?
Yes.
Now, at the top, this is the StarMix unit dated September 15th, and it relates to item 7-1, correct?
That is correct, yes.
All right. And then down below that, the kit used, if you could go to the summary of the input. You tell the software program, assume there are two contributors, right?
Correct, yes.
You input sample 7A.
Correct, yes.
And when you input it, it's just the raw data, right?
Correct, just the numbers from the graph.
The numbers, and then known contributors under HP, the prosecution hypothesis.
Correct, yes.
Right? And you put in sample 61.
Yes.
Right? That's Twiggs's known sample.
Correct, yes.
And then the known contributors under the defense hypothesis, you left that blank.
Correct.
Is that because you didn't know what the defense hypothesis was?
No, again, the defense hypothesis for this situation, if I'm comparing someone, is an unknown, unrelated individual, and that is taken into account during the calculation.
Okay, and then you input that data, and what you get out from that is a likelihood ratio, right?
Correct, yes.
So let's go to page 2 of that report. And is this a summary of the results from that test on the 15th in terms of a likelihood ratio?
Yes, it is.
What is a likelihood ratio? What does that mean?
A likelihood ratio is a statistic that calculates the probability of seeing a DNA profile given one of two different hypotheses. One is that a particular person of interest is a contributor, and the other is that an unknown, unrelated individual is a contributor. The probability with the higher number gets the support, and the magnitude of the support is determined by the ratio of those two numbers.
That's pretty technical stuff, but the bottom line is that the software computes the numbers, and then you look at those numbers and determine whether it has any significance, right?
I don't know that I would say if it has significance. I report the value that's calculated.
Right, and why is one column, these columns relate to different, what are called population databases, right?
That is correct, yes.
The one in the far left, BAH, is an FBI population database on Bahamians.
And African Americans, yes.
African Americans. Another one for Caucasians.
Correct, yes.
SEH is Southeast Hispanics.
Correct.
And then Southwest Hispanics.
Objection.
That's all I have on that. I'm just trying to explain the chart.
All right, well, there's an objection. Let's pause and turning to Mr. McBride.
Sure.
Your Honor, at this point, I'm going to object on, again, grounds of relevance to probable cause hearing, State v. Drosbeck, State v. Merrill, State v. Ramirez that the court has cited, all hold that the court should bind the defendant over for trial unless the evidence is wholly lacking and incapable of reasonable inference to prove some issue which supports the prosecution's claim. I don't know that any of this analysis goes to whether or not the expert's testimony and her report is wholly lacking and incapable of reasonable inference to prove her result in this case. We're far beyond this. We're hours into this examination. This feels like a 702 hearing to me. I think we're far beyond a probable cause hearing, Your Honor. I would ask the court to sustain the objection, not allow questioning on this or any other matter that does not deal with the issue of probable cause.
Thank you, Mr. McBride. Mr. Burt.
Your Honor, the state
This
offered this
prosecutor is such a
report
whiny
on
crybaby.
a very technical, complex, scientific area of inquiry. And they offered to the court a conclusion in that report that Mr. Robinson and Mr. Twiggs were contributors to two samples that were found at the crime scene. They obviously think that's relevant to the probable cause inquiry, or they wouldn't have offered the report in the first place. So having done that, I think the defense is entitled to inquire whether those conclusions are reliable, because that, again,
Ryan Matta just said he's going to come on here with us tomorrow, by the way, bro.
And the court can decide it's not relevant.
Come on, brother.
I'm sorry, it's not reliable, therefore I'm not going to
Yeah,
rely
man,
on that
that's gonna be
in
cool.
determining probable cause.
The more the merrier.
And that, or the court could say it is reliable and it bolsters up other evidence that the court is going to hear from. So the particular report in front of us goes directly to the issue of whether the expert correctly concluded that Twiggs not was a possible contributor, but was a contributor. And the state's theory here apparently is that both Mr. Robinson and Mr. Twiggs are somehow connected to this crime scene. So I think when the court sees what the numbers were generated and how that compares to her own standards for assessment, the court will see that the conclusion is not justified that she reached.
All right. Well, I understand what both parties are saying, and at a probable cause hearing, the issue is whether we walk 1 mile or 100 miles down the path.
Yeah, he's like,
So
I
wanna keep
understand
it
what
limited
you're
to 1
saying, but I
mile
don't care.
And as
It
opposed to
doesn't
100
matter
miles,
if
because
Tyler
that would
Robinson
exceed the
didn't,
probable
if his
cause standard
DNA
for
is not on
preliminary
it, it
hearing
doesn't
for
matter.
what is
I'm going to let
before
it
me.
go
And
anyway.
so, Mr.
We're
Burt,
just going
as
to
it
pretend
relates
like
to
his
the
DNA is on it.
objection, I'm going to sustain it in part. If you want to briefly address this and move on, you certainly may choose to do so, but as it relates to where we're at, my hope is we can keep this very brief as
Yes, I
opposed to
can do
going
that.
through all this, so we can move on to whatever else you would like to present.
Thank you. We'll do that, Your Honor. And in the interest of doing that, could you bring up on the same screen?
And
part
the
of
only
her
reason the
report,
prosecutor is
People's
pushing
Exhibit
so
31?
hard to stop
let's take
him
that
is because he knows he's
off
cooked. He
of
knows they
I'm gonna
fucked
need
up.
that
He
up
knows
there
they
because I
lied.
need to
Oh,
do
so
it.
is it
Tyler
part of the
Robinson should
same?
not have been included as
Because
a
it was on
possible
that screen. I
contributor
want to
at
make sure that
all.
what you're calling
And
up
they
on the
know it.
screen right now, is it part of this that was already admitted or something else?
It's part of this, which has already been admitted, compared to people or plaintiff's exhibit 31, which
I
has
see.
also been
Okay.
admitted.
Okay,
So
thank
they're
you. I
both-
just wanted to clarify.
Sure.
All right, so if you, and do you want that published on this? all
Yes.
Screens? All right, let's go ahead and do so.
And the chart I would like you to bring up from that report is on page 5. Yeah, and just highlight that. Thank you. So what we've blown up there is from your report, plaintiff's 31, and you provided this chart in the report, correct?
That is correct, yes.
Explain to the court how this works, what this chart is supposed to represent.
Sure. So this is our verbal scale. In addition to the numerical likelihood ratio value that I provide, I also give a qualitative or a verbal equivalent to that numerical value. That gives some kind of context to what that likelihood ratio means.
Okay. And on the left, explain what the greater than 1 million, less than 1 in 100 means. What does that scale relate to?
Sure. So that scale is the numerical value of the likelihood ratio. So if I have a likelihood ratio that's greater than or equal to 1 million, I designate that as very strong support for inclusion. The next example, 10,000 to less than 1 million, I would say that's very strong support for inclusion, and so forth.
So you need to reach a likelihood ratio of 2 in order to get even limited support for an inclusion, correct?
Correct, yes.
Okay. If you could not reduce that. And go to page 2 of the report on the left. So from this chart, when you ran Mr. Twiggs against a sample, what was the likelihood ratio that you determined?
I believe this chart is not the comparison to Mr. Twiggs.
It's not in the report?
The chart at the bottom of the screen is not my comparison to Mr. Twiggs.
Let's verify that if we could. Take that down, the highlight. And repost 38, page 45.
This is funny.
Sorry.
Is that a rifle in your pants, or are you just happy to see me?
Page 39, that is in evidence. There we go. Second page. Is this the likelihood ratio from your Twigs comparison?
Yes, it is.
Okay. Now, what was the likelihood ratio that you calculated based on this chart?
Likelihood ratio was 1.
1.
Yes.
So that doesn't
Oh,
rise to
so
the
it's not
level of
2.
even limited inclusion, correct?
Correct. It would fall under an uninformative.
Uninformative, and yet you concluded that despite this STR mix reading with a likelihood ratio of 1, that Mr. Twigs was a contributor to both item 7 and item 8, correct?
I did. So actually, I didn't utilize this calculation to determine that Mr. Twigs was a possible contributor, or that I could use him as an assumed contributor. I visually looked at the DNA sample, and the DNA, unlike that major contributor, he also had those peaks. So that was one proposition or one hypothesis that I determined that he was an assumed contributor. There are multiple different ways. We don't have a threshold. I don't have to see 2, 4, 8 peaks to determine I think an individual is present. Given that the field submitted him as an elimination, I assumed he was a contributor. When I compared him to that data, I did see his DNA present. So when I calculated the statistic for Mr. Robinson, I used Mr. Twigs as an elimination.
Let me see if I understand that. The STR mix that you relied upon to include Mr. Rob, you relied on the STR mix to include Mr. Robinson as a possible contributor, correct?
Correct, yes.
But when you ran Mr. Twigs's sample through STR mix, the result you got was that he was not a contributor, correct? Or that it was of not even of limited value in including him.
Based on the STAR mix run, it was uninformative, but I did use my own knowledge and training to determine that I was going to utilize him as an assumed contributor.
Okay. Your own knowledge and training. Is there some standard?
In other words,
that you use
bullshit.
for deciding when not to?
When she has to say my own knowledge and training, that means that's her. In other words, that's bullshit. Means it's subjective.
Your training and experience.
I can't say that I disregarded it. When I'm comparing someone, that's my first determination. Do I think this person is potentially included or excluded? If I determine that I think they're included, I will run STAR mix to give weight to that inclusion. Elimination samples are different. If I'm told that an individual is submitted as an elimination sample, I can assume they're there. Visually, I'm able to look at the DNA evidence and determine, yes, I think there's enough evidence there to assume that individual, which is what I did here.
Okay. At D16, Mr. Twigs was a 912, right? According to your electropherograms.
That is correct, yes. Mr. Twigs was a 912 at D16.
Exactly.
912.
That's very important.
And did you find 912 at that location in the 8-1 sample?
I'm sorry, the sample 8 or sample 7?
Sample 8.
She said the prosecutor did.
The only piece of information I had for sample 8 at item D16 was a 12.
And you said Twigs at that was a 912.
Not sure.
Correct, yes.
I think it's
But at
9
that
through
location,
12, yeah.
The evidence sample was not a 912, but a 12.
That was the only piece of information that was recovered at that location.
Let me ask you about your interpretation rules for excluding someone. Is this an accurate statement? This is from Butler's textbook. In forensic DNA analysis, if any STR locus fails to match when comparing the genotypes between 2 or more samples, then the comparison of profiles between the question and the reference sample is usually declared a non-match, regardless of how many other loci match.
I would agree with that if it's a single source sample. So single source, again, meaning from one individual. If I have a DNA profile from evidence and I compare it to a known individual, if there's a difference at even one location, I can say it's an exclusion. If I have a mixture, it's not that cut and dry. I have to take into account how many people are in that mixture, how many pieces of information I have, is there potential dropout? So it's just because someone may not be present in a mixture doesn't necessarily mean that I'm going to automatically exclude them.
I see. At D19S, what was Mr. Twiggs's type?
It was a 1416.
Did you find a 16 allele in the 8A sample?
No, I did not.
Okay. At Tho, what was Mr. Twiggs's type?
He was a 7.9.3.
Did you find a 7 allele in the 8.1 sample?
No, I did not. But again, this is a mixture and there is some dropout. So just because I didn't see a 7, for example, does not mean I would automatically exclude someone.
It's a mixture, so there was some dropout. So did you assume that at that location that the allele that dropped out matched his allele?
At that location, no, there's only one individual represented there. So when comparing an elimination, I would essentially ignore that location. I'm looking at the other locations where there was 2 individuals present.
Okay. Now a couple more topics and then we're done. When you received the evidence, you got more than 7 and 8, correct? You got a number of other samples.
Correct, I did.
You got a backpack, which you labeled as Exhibit 9, and a bunch of items from that backpack. Correct?
Correct, yes.
You were initially told that those items related to things that may have been discarded by the suspect.
So initially, we didn't have any information. So we processed that. Those are items that are good for DNA. Not having any information from the investigators, we process them for DNA. As the investigation continues, it was determined that that backpack was potentially left behind by a bystander, and there was no comparisons needed at that time.
Well, left behind by a bystander, or according to your notes at page 20, the backpack belongs to Kirk's detailees.
Yes, based on the individual that was not my communication log, that was someone else within the laboratory. That was the information that they received.
Before you received any samples, did you request to perform what's called destructive testing on the samples?
Yes, I did. And destructive testing is essentially consuming the sample, cutting the cotton off of the Q-tip or the swab, subjecting it to testing. There's nothing remaining. I have to request permission to consume prior to doing so, and I did in this case.
And why did you do that?
That is part of our protocols, that we have to request permission to consume, and we consume, so DNA, we can't see it. So when an item is swabbed, we don't know how much DNA is on that swab, if anything, or how that swab was used. Did someone just swab using one side of it? Did they roll it and use all sides? Because I don't know that, it's our practice to consume that swab. It's our best chance of getting any DNA evidence.
And that's a determination that you made in this case before you even saw any of the evidence, correct?
Determination to consume?
Yeah.
Yes.
Why would somebody taking the DNA of somebody not know how to use a DNA swab to get their DNA?
Right. You split the swab and you use half, you save half so that your testing results
really
can
weird.
be replicated and retested.
So yes, however, again, I don't know how an item is swabbed. So even if I were to cut that swab in half, it could be that I'm testing the half that doesn't have any DNA and the other half may have some DNA, or the swab may have a little bit of DNA on one side and a lot on the other side. So for the best possible chance of getting a DNA profile, it is our practice to consume the entire swab.
So for the first 6 items, those were swabs that were taken from the northeast corner of the LoSI building, correct?
Correct, yes.
And you used all of the swabs, and you concluded that there was no DNA present on any of those items, correct?
That is correct.
So you couldn't do any comparative testing.
Correct. There was nothing for me to compare to.
Okay. And what did you have left after you did that in terms of the volume of extract? What was left?
So it was approximately 3 microliters. So a very small portion.
Very small portion. And you actually used 10 microliters to do your testing of those samples, right?
That is correct, yes.
So if you didn't get any results with 10, what you left over would not be sufficient to get any sort of independent testing done, correct?
It could be tested. However, my expectation, if I took 10 microliters and did not get any DNA, the remaining 3 would also still not give me any DNA.
In other words, so they made it impossible for them to get independent DNA done themselves as the defense, which obviously the defense would want to do in a case like this.
Railing where the suspect touched the railing, right?
As far as I know, they were swabs from a stairwell.
And correct me if I'm wrong, but I understand from your lab notes that you took those 2 swabs and combined them into one sample and then used the whole sample, right?
That is correct, yes.
Okay. Before you did that, did you inquire whether the 2 swabs came from 2 different areas? For instance, maybe the suspect touched it here, but the other sample was taken somewhere else?
I did not. They were both labeled as coming from the same stairwell, and they were packaged together. So our policies and procedures, we can combine them together.
Do that, right?
I don't know that I would agree that combining the 2 would create a mixture. Given the item of evidence, a stairwell railing, I don't necessarily.
Can you hear me, bro?
Don't necessarily expect that one swab would have one person, the second swab would have a different second person, and combining the 2 of them creates a mixture. However, I don't know that for certain, but again, I don't know is DNA present, so our procedure is to combine and consume those swabs.
Okay, and in this case, when you did that, what you got was a complex mixture, right?
I did. I got DNA from more than 5 individuals, so I could not provide a conclusion.
All right. Now,
Mr. Burt, and we are at the 4:30 point. I just want to inquire, not applying pressure, just trying to understand. Okay.
No, be done with it. We talked earlier about your.
I don't know what happened, bro. That was crazy as shit. My headset, my Bluetooth went out, everything.
Testing.
Can you hear me?
Of the length.
I can't hear you. I don't know if it's me or you.
The length of the DNA.
You can't hear me at all.
Can you guys hear Project Constitution talking?
ACTMB within those.
Can you guys hear me?
Within those boxcars, right?
Correct, yes.
And
you can.
Is it true
okay, so it must be you, bro.
There are different alleles that have the same length when you measure by SDRs, but have different sequences.
Yes, that is possible.
And
thank you.
I'd like to show you a chart that you have reviewed. I believe this is, could you bring up 34? This is not.
Thank you, guys. Appreciate it.
In front of the, on the public screen, just for the witness. And is this a chart that you reviewed that I prepared and you looked at to see if I had correctly stated what alleles were found?
Yes, it is.
And does it, as it's presently existing, accurately state what the alleles are at each location?
Yes.
Okay. I would move that into evidence. It's 5 pages and it's Baker 34.
Mr. McBride.
Hell yes. Bring me some cheeseburgers. Bring some Doritos while you're at it too, since I'm the Doritos finger guy.
Prima facie showing of probable cause. This is irrelevant to the preliminary hearing.
Tiny Hat Mafia messing with my mic. Be right back.
This exhibit and the next one go directly to whether the comparisons being made between Mr. Robinson's sample and the evidence samples are usable and reliable to make a determination that he is a probable contributor.
I'm not sure I'm following with what you're saying on there, right? And maybe it's just because it's late in the day. Could
Yeah,
you
it could
repeat
be.
that?
So this chart illustrates what allele she found at each location for Mr. Twiggs and Mr. Robinson, and for the evidence samples, the 7.1a and 8.1a. The other alleles are on here as well, but we're going to focus on 7.1 and 8.1. And for instance, Your Honor, at the, you'll see that under the first reading there is for Tyler Robinson at the D3 location. He is a 17. Okay. And take that down. And then if you go down to the 7.1 towel sample, which is
Dang, I can't hear anything. Can you guys hear me?
Report introduced by the state.
Yeah, I can hear you, bro.
You'll see that she found
Okay, I can hear
17
you, but I can't hear the screen.
measured only by the length
That's weird.
of the DNA strand. And what she's going to
I
testify
don't see anybody
to
else
is
complaining
that
they
this
can't hear it.
location and 5 or 6 others, there are alleles, all of which measure here 17, but actually contain different sequences. And that her testing that she used does not measure for those differences.
And so as it
Okay, I
relates to
love the
probable cause,
Jews.
that's what I want to keep coming
They're
back
the
to.
chosen people. Please
Again, if
turn
this
my
was a
screen
trial,
on.
this may be a little bit different analysis that the trial judge applies, but as a magistrate, taking a
Yeah,
look
whatever's
at this
going
and
on is
looking at
on
the
your end,
probable
bro.
cause standard, how does this comport?
There is a crazy storm
So it comports
outside.
because it goes to the ultimate opinion expressed in the report that the state is offering, that
Shut
the
everything down,
report
try it again.
offers reliable support that Mr. Robinson is a possible contributor. And we're asking the court to consider that the comparisons are only based on a limited number of length-based comparisons, and that there are sequence differences so that she cannot distinguish. And I believe she'll testify, she cannot distinguish based on the testing that she did in at least 5 separate locations, whether the evidence sample and Mr. Robinson's sample, or for that matter, Mr. Twiggs' sample, matches the sequence differences here.
Because this is super,
And this is
super
my
important. That's
final
why.
area, and I think I can do it very efficiently. And I think it is important for the
No,
court
it
to
should not
consider,
be admitted.
especially as it relates to the comparison to Mr. Robinson.
Mr. McBride.
And she is also going to testify that the analysis she does is based on looking at the totality and all of the different markers that match and are consistent. And that's how she comes to the opinion that she does. The point is, there are explanations that are susceptible to different interpretations and arguments. Ultimately, we're going to have an expert hearing where all of the literature is going to be before the court, and the court's going to determine if it meets a threshold of reliability for admission at trial. But at this stage, even granting that there may be some argument that may come from defense counsel's position, the court can't weigh it. This does not go to the probable cause determination, and I don't think it's relevant. And this exhibit in particular is not relevant without the testimony of the witness
And so the exhibit should not be admitted on its face either.
But that's why I was trying to lay a foundation that she would, and offered a proof to the court that she would testify that in fact there are these sequence differences at the 5 or 6 locations, 6 different locations relevant to the comparison to Mr. Robinson. And when the state says the court cannot weigh it, the court can weigh reliability. The court has ruled that. So we're simply asking the court to take into account the limited nature of these comparisons and the fact that she cannot, based on the testing that she performed, tell the court whether there are differences between at these 5 locations. She can't match Mr. Robinson to the question samples because she didn't do sequence testing, and she'll also testify
because the
that
prosecutor
FBI
told
is
her to.
in
That's
the
what
process of
she said.
implementing this kind of testing.
All right. Thank you to both sides. I'm going to allow the admission of this evidence, but I'm also going to set a limit of
Of course he's going to admit it. Of course.
a limited number of questions. We are now at
Ridiculous,
4:40. This is on the cusp of whether it is applicable to the probable cause standard. I want to afford defense its full opportunity, but I still have to rein it in to keeping it to probable cause and not going into a full exploration, because that's not the purpose of a preliminary hearing. So I will admit Baker 34.
This is total
but
bullshit.
Mr. Burt,
It
I'm
should
going to
not
limit
have
you
been
to
admitted.
how much time do you need to address
I just
this?
need about 4 or 5 minutes. I'm going to, the next chart will be the chart with the, what are called isoalleles displayed for the court, so the court can see what we're talking about, and that's it.
All right.
I'm just going to have her document that, in fact, I've accurately stated what the alleles are that have sequence differences.
All right. So it is Mr. McBride.
Just on a second matter, which is I need to cross-examine this witness. She's got to leave town today. I would like 20 minutes to cross-examine the witness.
All right. Well, I will go with the I accept Mr. Burt's representations the amount of time, and I'm going to talk less because that's consuming more time, and also allow the state the appropriate time for cross-examination given the nature of this witness having to travel. So, Mr. Burt, I'll turn to you. This has been moved into evidence. Do you want it on the screens?
Actually, I don't need it on the screen, just in the interest of efficiency. Pull up the next one, please.
Okay.
I want 35. Take that one down. And is this exhibit the same chart with what are called the isoalleles indicated?
Yes, it is.
Oh, big time.
And isoalleles is a term used to refer to these alleles that have different sequence, but the same.
We all
length.
call it. I'll tell you
Correct,
that
yes.
much.
So across the
People in our
top there
community
for
called it.
allele 17
I've already
and
posted
D3,
about it.
there is a allele 17A, allele 17B, allele 17C, all with the same length, but different sequences for each of those 3.
Correct, yes.
And similarly at VWA, where you say that the Mr. Robinson is an 1819 and 1819 in the evidence sample, there's an 18A, a 18B, a 19A, and a 19B.
Correct, yes.
And similarly for the other areas I've indicated there, I've accurately stated what the different sequence alleles are, correct?
Yes.
So I move this exhibit into evidence, Your Honor, and for publication.
Is this Baker 34?
Yes. 35. Baker 35.
Same objection, Your Honor.
All right. I'll admit it into evidence under the previous statement as it relates to Baker 34. It may be published.
And as you look at these 5 areas, you can't distinguish the evidence samples from Mr. Robinson based on the sequence differences, can you?
Correct. I only utilize length differences, STRs in this case. The FBI laboratory does not use sequencing for nuclear DNA testing, nor am I qualified in it.
Right. What is NGS?
NGS stands for Next Generation Sequencing.
And your laboratory is involved in validating next generation sequencing, correct?
We utilize next generation sequencing for mitochondrial DNA, which is a different subset of DNA testing, but not for nuclear DNA testing, which is what we're talking about today.
Right. But the people who market STR-Mix also market a sequence platform, do they not?
I'm not aware if they do or do not.
Last question, take a look at. There we go. Well, I'll save that for redirect. Thank you.
Thank you.
All right, turning to the state. Mr. McBride.
Oops. Good afternoon.
Good afternoon.
I want to start by asking you what your training and experience is. First of all, do you have any education?
Yes, I do. I have a Bachelor's of Science in Biology from Salisbury University.
And do you, after your Bachelor's in Biology degree, what did you do for your career and in further education?
Upon graduating from college, I began working at the FBI laboratory as a contractor. I was assigned to the Federal Convicted Offender Program, which was a program under the DNA unit. During that time, I did that for approximately a year and a half. It was my responsibility to open and inventory and barcode DNA collection kits sent in from federal agencies across the United States. I then became a biologist in the DNA casework unit. I did that for approximately 6 years. During that time, I did the actual testing of items of evidence, so swabbing, cutting those swabs, producing the DNA profile. And then in 2015, I accepted a position as a forensic examiner, which I am still today.
I'm sorry, what year was that?
2015.
So 11 years, you've been doing more or less the same duties you have now, is that right?
Correct, yes.
I want to ask you about your lab's accreditation. What is accreditation for a laboratory?
Accreditation is a formal recognition that our laboratory is following a very strict set of standards. We're accredited by ANAB, the American National Standards Institute National Accreditation Board. And our accreditation shows that we have to follow standards such as I have to have a certain education background, how we process evidence, how we store evidence. Every 4 years, we're audited to those standards, meaning an outside body will come into our laboratory, look at my training records, look at our standard operating procedures to ensure that we're following those standards.
And you mentioned your training. So what do you have to do as an examiner there, as a scientist there, for your lab to maintain its accreditation?
So for my training program, I had to complete a 2-year training program. During that time, I learned the science behind DNA testing, and I showed that I understood that science by completing oral board examinations and written examinations. I also then had to show that I could relay those scientific results to a jury by completing moot court exercises. And before becoming qualified, I then took something called a competency exam, or it's like a final examination to show that I'm qualified to perform my duties. During that accreditation or that audit process, my training records were reviewed to make sure that I had the proper coursework, the proper college degree, as well as completing successfully that training program.
And do you have to keep up with ongoing education to maintain your, do you have a certification?
I'm not certified. I'm qualified as an examiner.
To maintain your qualification, do you have to have ongoing education?
Yes. On a yearly basis, I have to complete at least 8 hours of continuing
The
education.
media attorney,
And this
right?
can be done by attending conferences or lectures or reading scientific literature.
Do you also have to undergo proficiency testing?
Yes, and a proficiency test is a test that we receive from an outside vendor. I process that test like I would any other case and submit that those answers to determine if I'm satisfactory or unsatisfactory. This tests not only me to see if I'm still proficient in my qualifications, but it also tests the laboratory process to ensure that we're getting accurate and reliable results.
Now, as you discussed your work in this case, you talked about your work needing to be reviewed by another analyst.
Correct, yes.
And is that true in every single case?
Yes, in every one of our cases, they have to undergo a technical review in addition to an administrative review.
And it sounds like during those technical reviews and administrative reviews, there's discussions between you and other analysts. Is that accurate?
Yes.
And is that
Just
an
a
opportunity
reminder,
for
if
training
you
and
guys
learning
want to
as well?
send us
Yes,
a buy
absolutely.
me a coffee,
And I assume
scan the
that training and
QR
learning goes
code,
both
left bottom
directions.
side
You're
of the
learning and you're
screen,
also helping others understand
and
your
leave a
thought
comment,
process,
and
which may
we'll read
train
it
them as well.
out
Is that accurate?
live
That's
on the
true,
next
yes.
break.
The tools
And
you
thank
use,
you for everyone who
are the
has
tools
sent
you use
today. We
validated?
really appreciate
Yes,
it.
they are.
And what
Absolutely.
does that
Thank
mean
you
to
all
have
very
a
much.
tool that you use validated?
So a validation is a thorough testing of a process or procedure. So before we subject any evidence to testing, we ensure that those process and procedures will work within our laboratory. Based on the validation, we create something called standard operating procedures, or SOPs. And these are kind of like cookbooks. It gives us step-by-step instructions on how to do our process and procedures. And then both myself as an examiner, as well as the biologists, were all trained to those standard operating procedures and tested to those standard operating procedures during proficiency tests.
Now, you've talked about, I think, a couple of the tools you use. One you call StarMix, is that right?
Correct, yes.
And is that tool validated?
Yes, it's validated both developmentally and internally. Developmentally it's validated by the creators of the software. And then we, the FBI laboratory, also tested StarMix to ensure that we could use it within our laboratory and produce accurate and reliable results.
Now, when you say it was developmentally validated, is that in a peer-reviewed study?
Yes, it is.
And is StarMix used? How widely is StarMix used throughout the world?
StarMix is used in approximately 120 laboratories, both domestically and internationally.
I want to go back to some of the questions that you were asked on direct examination. You were asked about an exhibit 8.4, Baker 8.4, which is the DOJ Ultra, which is the Uniform Language. What does that stand for?
Uniform language for reporting and testimony, I believe.
Okay. It talks about language that you should use and language that you shouldn't use as an examiner, and a scientist, correct?
That is correct, yes.
Now, I want to ask you a little bit about what you do when you have a conclusion, like you did in Exhibit 31. Do you know? Let's see. The directive from the Department of Justice limits the adjectives you can use to describe the evidence and the conclusions that you reach. Is that accurate?
Yes, it is.
And the thinking behind that is to submit the statistical number and let others decide, meaning the reader decide how they want to describe that number. Is that accurate?
Yes, it is.
So for example, if we can look at Exhibit 31, if you don't mind publishing that. Yes, and that's been admitted. So if we can put it on the screen. And Kimberly, if you could scroll to page 3 when that comes up. Thank you. So item 7 sub 1 is the swabbing from the towel from the rifle. We have the number in written form in the second paragraph beneath the heading. And then beneath that, you have a table, correct?
That is correct, yes.
And the likelihood ratio gives the number, right? That's the likelihood ratio. And that's stated in sentence form in the paragraph preceding the table, correct?
Correct, yes.
The only language you can use to describe what that number means from the DOJ directive is very strong support for inclusion, correct?
Correct, yes.
And the sentence there that says the DNA results from item 7.1 are 1.7 octillion times more likely if Twiggs and T. Robinson are contributors than if Twiggs and an unknown, unrelated person are contributors. The reader can assign whatever value they want to that, correct?
What do you mean?
Meaning adjective to describe what that means.
Sure, yes.
The adjective you can use is very strong support.
For inclusion, yes.
Okay, for inclusion. All right, if we go to 8.1, Kimberly, if you can scroll down just to make that a little bit easier to view. Same question there. The results are from 8.1 are 30 quintillion times more likely if Twiggs and T. Robinson are contributors than if Twiggs and an unknown, unrelated person are contributors. The adjective you're allowed to use is very strong support for inclusion again, correct?
Yes.
Okay, we can take that exhibit down. Thank you. You were asked about formal activity level, and you described this as the lab cannot testify about, or you cannot testify about what action left the DNA on the object. Is that right?
That is correct, yes.
Does that mean that an individual did or did not touch? Well, let me ask you this. How can DNA get onto an object?
DNA can get on an object via direct contact, so an individual touching an object. It can also end up on an item via body fluids such as blood, or through transfer. So if I were to touch an object and then that object is given to someone else, my DNA could potentially be on that other individual through the transfer of DNA.
And your lab you cannot testify as to what precise action left the DNA on the object, correct?
Correct, I cannot.
Okay. Same question about time. You can't testify about the exact time that DNA was left on an object, right?
Correct.
But there are some indicators that may give some information about how long and the conditions under which DNA was placed on an item, like degradation.
Yes, degradation or the condition of the item. So again, if a firearm, for example, is in a river I would expect with the water rushing over that item, I may or may not be able to detect DNA. Also, if there's an item of evidence that is exposed to the elements, something that's been left behind 10 years ago, I don't necessarily expect to recover DNA, but something that may have been left yesterday, I might be able to detect DNA.
An item that has been left in the dirt or has been rubbed in the dirt, could that affect your ability to recover DNA?
It could, yes.
Could it also affect degradation?
Yes.
Can UV rays affect degradation?
Yes, it can.
Does degradation keep you from doing your work?
No, it does not.
Is degradation normal?
Yes, it is.
Does all DNA degrade?
It does, yes.
I imagine if it's kept in a pristine environment, it would degrade less than if it's kept in, or if it's found in a less or out in the open. Is that accurate?
Yes.
Okay. You said with regard to the screwdriver, there is some degradation. Did that affect your ability to reach conclusions in this case?
No, it did not.
You said on item 7, the towel or the swab from the towel, there was slight degradation, not as much as exhibit 8. Is that accurate?
Yes.
Did that degradation affect your ability to reach a conclusion here?
No, it did not.
You're asked about the PCAST report. You testified that that gave guidance on different areas of forensic science. Do you know what year that report was published?
I don't recall the year.
Do you know if it's been within the last 5 years?
No, it is not.
Meaning it's older than that?
Yes.
Do you know if it's been the last 10 years?
I think it was 2016, but I'm not entirely sure. I would say within the last 10 years.
Let me ask you this. Has the science in your area, can I refer to it as probabilistic genotyping?
Probabilistic genotyping is the math in my area. Yes.
The science in your area and in your field, has it developed over the last 10 years?
Yes, it has.
And have there been studies that have made suggestions which have been implemented in the field?
Yes.
You testified about exhibits 7 and 8, that they both had mixtures. Excuse me. Yes, items 7 and 8. In your testing of these items, that they both had mixtures. And you stated, I want to make sure I understood this. You stated, I believe, that the minor contributor was less than 20%, and that it was actually 5%, and the ratio is 5% to 95%.
For one of the samples, yes.
Do you remember that?
Yes.
Does that mean the 5% was from twigs and the 95%, that 95% is assumed from the defendant, the Robinson?
When I calculated the statistic, Twiggs' DNA profile aligned with the 5% contributor, and Mr. Robinson's DNA profile aligned better with the 95% contributor.
Okay. Same question with regard to 8. I think you said the ratio was 11% from the minor and 89% from the major. Is that Twiggs being the 11% and Robinson being the 89%?
Yes, Twiggs better aligned with that 11% contributor, and Mr. Robinson better aligned with that 79% contributor.
You're asked about Baker 4, an exhibit that was titled Baker 4 365. Do you remember this exhibit by chance? I don't have a copy of it, so, well. Do you have Baker 4 365? Put that up.
think we're gonna have to fly down to Utah
And
for the
item
trial,
7
bro.
is the towel, right?
Yes,
Item 8 is the screwdriver.
correct, yes.
Thank you.
Yeah, I'm down. I probably will go to the actual trial. I should probably start a crowdfunding campaign on that.
Yeah, I'm down.
It's 5 o'clock.
I think it
I'm
would be
gonna wrap
worth
up.
it.
We can go ahead and take that down. I'm sorry. Thank you for helping out with that. In reaching your conclusions, did you follow the protocols of your accredited lab?
Yes, I did.
And based on your training and experience and following those protocols, did you in
They do a
fact come to the
burner
conclusions
tonight.
described in
Burn
Exhibit 31?
burner tonight, man.
Yes, I did.
It's already 7 o'clock. They're still going. Holy crap!
We're 10 hours and 18 minutes
How much
deep,
time
bro.
are you anticipating?
For real, it's crazy. Again, if you all appreciate that, they were
You referred on
doing
cross-examination
this
to
right
your
there.
training
Hit
and
that buy me a
experience, right?
coffee right
Yes.
there.
Do
Hit
you
us
agree
on
with
that
this
for a couple
statement,
bucks in our buy me a
in
coffee.
the PCAS report? Experience or judgment cannot be used to establish the scientific validity and reliability of a metrological method, such as a forensic feature comparison method. Moreover, a forensic examiner's experience from extensive casework is not informative because the right answers are not typically known in casework, and thus examiners cannot accurately know how often they erroneously declare matches and cannot readily hone their accuracy by learning from their mistakes in the course of casework. Do you agree with that statement?
I don't. I think experience, they're right in the fact that we never know the true answer. However, my experience means that I've seen a lot of different DNA. I've seen a lot of validation data. So that does help me come to a conclusion.
Do you agree with this statement by that same report? Good professional practices, such as the existence of professional societies, certification programs, accreditation programs, peer-reviewed articles, standardized protocols, proficiency testing, and the code of ethics cannot substitute for actual evidence of scientific validity and reliability.
I don't think I agree with that either. The science has been heavily validated and tested to show that's reliable. Following protocols that are based on validation, again, shows that my results are accurate and reliable, as well as being proficiency tested.
By the way, you said that that report was not authored by experts, but the head of that group was Eric Lander, who is one of the foremost experts in the area of forensic biology, is he not?
That name does not ring a bell. I don't know who that individual is.
You don't know who Eric Lander is?
No, I do not.
Okay. When did you go to school? What years?
2003 to 2007.
You said that STR mix was widely used and then it's been validated. The PCAS report said the problem is it's been validated by the people selling the product, right?
Developmental validation, yes. Internal validation, no. A laboratory that's going to utilize STAR mix has to validate within their own laboratory.
And the PCAS report said that we need validation data, not by the people selling the product, but by independent scientists in order to make this reliable, right?
They do, and that's exactly what happened. There was 31 laboratories that came together in response to the PCAS report and gave their validation data on how they internally validated STAR mix.
And then after that information came forward, the PCAS committee reviewed it and they said PCAS was unpersuaded by those studies. While likelihood ratios are a mathematically sound concept, their application requires making a set of assumptions about DNA profiles that require empirical testing. Errors in the assumptions can lead to errors in the results. To establish validity with a range of parameters, it is thus important to undertake empirical testing with a variety of samples in the relevant range. And they specifically address the studies you're referring to, did they not?
I believe they did, yes.
Yeah. And then lastly, you said that STR mix is widely used, but as I understand your testimony, you didn't use it and rely upon it for your conclusion about twigs, right? The software told you there was no support there for including them, and you ignored it and decided otherwise, correct?
I did not ignore it. Again, given the type of sample, it was an elimination sample. I compared that individual to the DNA profile that I developed and determined that I could conclude that I could utilize him as an elimination sample.
You said
Somebody
your
check her
laboratory was-
monthly deposits in her
But
bank.
you're aware that in 2004,
For real,
the
how
Inspector
can you
General
use him
did
as an
a
exclusion? How
comprehensive
can you
audit
use
your
him
laboratory,
as an
published a report
exclusion
called the
when his
FBI
DNA is the
Laboratory
most
Report, a review of
relevant and the most he's
protocol
got
and
the most
practice
DNA on the damn
vulnerabilities,
items to begin
which
with.
found a number of errors in the way that your lab does testing, correct?
Objection. The 2004 study is hardly
Makes no sense.
relevant to this proceeding 22 years later.
It's relevant because he's relying on accreditation to somehow say that these results are valid. This lab was accredited when this study was done.
I'll allow this single question. I see no response.
Hey,
I see
Scarrica
overruling
Kirk.
the objection.
Good to
and we'll
see you,
continue to move
hon.
forward.
You're aware of that
Everybody,
stuff, right?
another good
No, I'm
account
not.
right here, Scarrica Kirk. Be sure to follow her. She's got a
Anything further for
YouTube
this
and an
witness?
X. She puts out some really good
Yes,
parody
I think there's one
videos.
follow-up needs to be asked.
Great
You were
account.
asked
Follow her,
that-
guys.
Or you testified that you never know the true answer with field work, correct?
Yeah, I was gonna
Correct,
say,
yes.
is that
And
the
that's compared to
she
ground truth
does the
studies where
parody
you
of
do know
Erica,
the true
huh?
answer and you can compare the conclusions. that
Yeah, she
analysts
puts out
draw with the
some
true
parody
answer, the
Erica
ground
bangers
truth.
for sure.
Has she
answer
gotten a
is the
cease and
basis of
desist
the
yet?
study. Is that right?
Yes, and that is what our validation is.
I don't know. Have you?
Validation actually studies is a ground truth test in
Yeah.
essence.
Yes.
Okay, thank you.
Anything further for this witness?
Thank you.
May this witness be excused.
Yes.
Thank you, Ms. Baker. You may step down.
Thank you.
All right. Well, does either party need the benefit of the record before we go into recess?
No, Judge.
All right.
You
having
get any
both parties-
cease and desist letters from them yet,
No,
Scarrica?
we'll go ahead and be adjourned until tomorrow at 1 p.m. We do not have morning court for this proceeding, and we'll start up at 1 p.m. in the afternoon.
1
Court
p.m.
is in recess.
Oh yeah, that's right. Tomorrow's a late stream. Tomorrow's 1 p.m. Oh, she said, haven't got one yet, but my name is all up in Mitch Snow's court case. Yeah, I saw that. That's wild. Mine is too. It's really, they're tripping balls for real.
Why are your guys' in Mitch Snow's court case?
Because his baby mama's insane. She's saying that we're trying to kill her. The fact that we platform Mitch Snow and we talk to Mitch Snow, she's trying to say that because we did that, because we interact with Mitch Snow, that we are a threat to her life.
Are you serious?
I swear to God, this woman is batshit crazy, dude. She's
Oh.
insane.
Dang.
Absolutely insane.
Remind me to stay off her radar.
For real.
That's crazy,
Yeah.
bro.
I've never met him in person either. I only just had him on my stream. That's it. They're nuts.
That's crazy.
Anyway, so yeah, I guess we're stream's over for today. That was a good one, guys.
Maybe we start a little earlier than 1 o'clock.
Oh, definitely. Yeah, absolutely. I'll probably start the stream same time tomorrow. I'll probably start stream same time, like 9 o'clock tomorrow.
What
again,
Ryan
or
Mata made
again.
Ryan Mata commented on here that he was gonna come on, or what?
No, he DM'd me.
Oh, did he? Okay,
Yeah.
for sure.
Although I told him 11, I thought it started 11, so now I'm gonna have to go back and remind him because I forgot. I know one day one of these days this week, I knew it was starting late, but I forgot which day. I thought it was Thursday, but I guess it was Tuesday. I was mistaken.
For sure. Well, everybody who's been stretched out with us for 10 hours, kudos to you. You guys are long run streamers.
You want to look at those pictures you sent real quick?
Yes, show those pictures real quick. These are from Louisiana.
Pictures. All right. And by the way, once again, if you guys want to donate one last time here, you want to send us a super chat or whatever, throw a couple bucks in our Buy Me the Coffee fund, just right here. Send a super chat, scan here, just scan that QR code right there. And yeah, and then you can leave a comment and we will read out your comment like a super chat. But let's look at those pictures real quick. Then we'll check our super chat comments and then we will get off for the day. Okay, so let me pull up these pictures here. I already downloaded them. All I gotta do is pull them up. So give me a second.
What a stream, you guys. Thank you. We whooped TPUSA today on the coverage of
Oh yeah, that's right. Let me show you that real quick too while we're at it. Boom, baby. Someone posted, I forget who posted it. Let me give them credit real quick, whoever did it. Let me say their name so I can shout them out real quick for posting that, because that's awesome.
TPUSA, if you're watching, thank you so much. Thank you. We appreciate it.
At the Roxy Paradox. At the Roxy Paradox. They are the ones that posted this. So I retweeted them and I said, based. Thank you for posting that. And yeah, we whooped their ass today big time. And hopefully we'll do it again tomorrow.
You and your three cease and desist letters.
I know, it's wild, bro.
Oh my God. When you have that kind of money, you think you would just leave stuff alone, but hey.
I don't know why they're so worried about me, but yeah. Apparently they want to blow all their money chasing me. I got no money, man. They could sue me to, even if they were right, even if I did defame them, they can't do shit to me because I don't have anything they could get.
You're an immigrant from Mexico, bro. They're not even gonna find you.
No hablo inglés.
All right, show those pictures, bro. I'm gonna show you guys Tyler Robinson on UVU campus. Okay, hold on, get ready for this. This is Tyler Robinson. We found some pictures of Tyler on UVU.
Oh, damn it. It's in a zip file. It won't let me do it because it's in a zip file. I have to, hold on. I got to take them out of a zip file real quick. I got to take them all out of the zip file and put them individually real quick. Give me a second. Expanding zip file. Okay. Let me take all these and move them to the download file. Okay, there we go. And now we can try it. Let's try it again. All right, so image file. All right, there's the first one. That's the first one right here.
Here's your first. Can you blow it up a little bit?
I can, unfortunately. It won't let me blow it up here.
Okay, it's okay. Scroll to the next one.
But if you see it, yeah, you could see right in the middle with the maroon shirt right here. And by the way, that person has long hair. Tyler Robinson does not have long hair. So that right there looks a lot more like a Lance Twiggs than it does a Tyler Robinson. Don't you agree, bro?
Yeah, I don't know. I think it looks like a military operative, to be honest. All them people wearing the same maroon shirts with the shorts, and I mean, it's just crazy, bro. They knew what they were doing.
Yeah, I mean, It may not be Lance Twiggs either, but I'm saying it looks more like him because at least Lance Twiggs has that long hair.
Yeah,
Tyler
no,
Robinson
right.
doesn't even have the long hair.
No, for sure.
All right. So second one is right here. It's the second
There's
one.
Tyler. There he is, right
Yep.
there with the backpack. Look at the backpack.
Long hair again, by the way.
There's Tyler.
Yeah.
Man, I can't remember how many maroon shirts we counted. Was it like around 6 or 8 or something like that?
It was way more than that, bro. It was like 20 of them there, to be honest with you.
Yeah, it was a lot. I remember. It's been a while since
It's crazy. Honestly, it really is. It's crazy how many there were, bro. It was definitely a military operation, and that was the color. Like, she nailed it. Candace nailed it with the color of the day, 100%. It was a military operation, and that was the color of the day for sure.
Yeah.
All right, so we got one more picture here. All right, this is the second picture.
He's wearing the gray tux too.
Yep, gray chucks too, and this guy's got the skateboard. And also, there's another picture with this guy. There's a closer up face picture of him with a skateboard as well that I remember I posted before because I thought it looked like a drone. Let me see if I can find that real quick. Actually, that would be a good one just to show because that's definitely the same guy. That guy with the skateboard there.
Mm-hmm.
Let me see if I can find that real quick. Holding drone.
Let's see.
Yep, I found it. Bingo. All right, let me zoom. Let me share this tab instead.
88K on the live.
Yeah, baby.
Oh, there's
boom. There's
right
our boy.
there.
No, that's the same guy. That's the one you just showed. That's the guy with
Is
the
it the
skateboard.
same guy?
Because you see yeah, you see the wheels. He's holding the skateboard in his hand. That's the wheels right there. I thought that was a drone at first, but it's not a drone. It's a skateboard. But
Look, he's the only one standing up.
Yep. And
in the picture.
Yeah, and see, there's the skateboard. Same guy. You can see the skateboard.
A lot of little MK Ultras running around.
Yep. And then there's I think I got another picture of him here too. Hold on. Yep, there you go. There's another picture of him.
Does he have no teeth?
Honestly, I never noticed that before, but yeah, it looks like he's missing some teeth there. He got no teeth.
Dang, look at his neck. That looks weird. Look at the neck.
It. Yeah, it does. What the hell's going on there? You know what? Maybe he's wearing a mask. Remember that dude on CNN a couple weeks ago that was caught wearing a mask?
Yep.
Maybe he's wearing a mask. Because that's what it looked like. Remember that like there was weird shit around the neck?
Yeah, what's up with that neck though? There's like that's weird. That's the first time I'm ever seeing that, bro.
I think honestly, it might be a mask because it looks like, honestly, it looks like the part of the how the latex that folds around.
Yeah, it lays on your shoulders.
Up right there. Yeah,
bro,
it looks like it may be bunched up right there.
I have never noticed that, bro.
Me either.
Well, you guys are seeing it here first time. What is going on with that neck?
Oh shit! I can zoom these in now. Yeah. Oh yeah! Look at that, bro.
What is going on there?
There's something weird there for sure.
We may have just discovered another. Where's the teeth at, though, my man?
Yeah, the guy looks like he's missing teeth, and it looks like he's wearing a mask. Honestly, it looks like a mask. It looks like it's bunched up right there. Looks like the latex is like bunched up.
That Schnauzer's a little suspect, man.
Oh,
You might
big
take
time.
off.
Follow
You might
your
take off his.
nose.
You might take off the bald cap and see a little smaller hat over there on his top of his skull. You never know.
That's right.
Oh man. Okay, guys. Well, go ahead, record this, screenshot it. We got something going on with old buddy here. Not just the missing teeth that he might have smoked out, but there's something going on with that neck there. Man, I think you're muted, bro. There you go.
Okay, I just checked one more time. We don't have any more buy me a coffees, so I guess that's gonna be we're gonna end our stream for today. Then I think that's it. Let me check the chat one more time, see if anybody else got anything to say here. This Truth Unveiled, she's actually done some good work. She says this guy is Samir Massey's friend. Okay. That's interesting.
Yeah, I know who Truth Unveiled is.
Yeah, she said it's Samir Massey's friend. I would like to get a name. If you know his name, DM me his name so I can look into him, please, because that is pretty weird. We've never noticed that before.
Yeah. I mean, if it's a medical condition, I repent, but
yeah, it might be. Who knows? This person said that looks like the black backpack. Are they not able to account for the roommate's location during the assassination? Yeah, that's a good point. I would like to know where was Lance Twiggs at during this assassination? Where's his whereabouts? Did they even bother to ask him where he was, or did they bother to check his phone logs or phone records to see whether he was also pinging at UVU or whatever? And then this person said, "Is Erica there today?" I don't think she was. Honestly, I don't think she was. I didn't see anybody. I've been looking all day and I haven't seen anybody post video of her going in there or talk about seeing her going in there today. So I don't think she showed up at all. I think she just showed up yesterday as like a PR stunt, just to be like, "Oh yeah, I'm here. I'm here with Charlie's parents. We're together. See, we're not fighting. We're totally cool, guys." But yet they didn't walk in together. But now she doesn't show up for the rest of the days. All right. Okay. Yeah. She says, "I have pics with them both. I might have his name. Let me check." Yeah, definitely. If you do, like I said, DM me then, please. One more thing before we get off here. This person says, "Look in the corner of his eyes." Okay.
What, it looks like he's been up for weeks or what? Ooh. Looks black.
Yeah. What
That's
the hell's
typically
going
a
on
sign
there?
of smoking meth in a bathroom for a few months.
You know what? Missing teeth is a sign of that too. I think we may have just uncovered we had a meth head at the Charlie Kirk assassination.
Everybody's smoking meth at TV USA events. Allegedly.
Yeah,
allegedly.
they are, allegedly.
This is an alleged opinion.
That's right.
Oh, beings, there's so many damn people on here, Jesus.
Oh, yeah.
Thank you. Thank you.
All right. So that is our stream for today, guys. Make sure you're going, if you're not already following Yakova Renewed, or what, say your name again.
It's Yaakov renewed. Yaakov renewed.
I say it right, but I always put an A at the end of it for some reason. I say
Okay.
Yaakov and it's just Yaakov. Okay, so I got to
It's all
remember to
good.
cut the A out.
Yeah.
Okay, so Yaakov.
I'm a Russian Orthodox Jew, bro.
And we're all being paid. We're all paid Russian propagandists. Okay. Oh, and not we're also. I forgot. We're also paid by George Soros and Act Blue, and we're secretly working for the Democrats. So remember that too, guys.
Oh my God.
You see that retard Andrew Wilson try to say that me and Candace or whatever are working for Act, we're being paid by Act Blue and working for George Soros.
Yeah, I think I seen that.
Get the out of here, man. Ridiculous. Absolutely absurd. Anyway, y'all, like I said, check him out. Go follow him. We're going to be here all week covering the trial. I mean, not trial, preliminary hearing. So check us out every day. The stream most days starts at 11 a.m. Eastern time, like we did today. But tomorrow it starts at 1 p.m. Wait a minute, 1 p.m. their time. Let me make sure. Let me ask ChatGPT, or not ChatGPT. Let me ask Grok real quick. When the judge said 1 p.m., I think he's talking about 1 p.m. their time, which would be 3 p.m. our time. But let me just check. What time does the...
I think it's just an hour behind you.
2 hours.
Oh, is it? Oh, dang.
Yep. Prelim start tomorrow. July, what's today? 7th, so it's 8th. So July 8th. July 8th. Give it to me in Eastern time. Let's check real quick just to make sure. I think it's 1 o'clock their time, which would be 3 o'clock our time. But let me just verify that before we get off so you guys all know. Okay, yep. So tomorrow it starts at 1 o'clock Mountain Time, which is 3 o'clock Eastern Time, which is New York time. So the stream will start tomorrow, 3 p.m. Eastern Time is when me and him will be live again. Ryan Matta also said he's going to come join us. So we'll have a nice three-way. Not no. Wait, what do they say? No homo. We'll have a nice three-way. No homo.
Yeah, you got to clarify that because we got the Clippers on here. You know what I'm saying?
I know, right? That's all we need. Shit. So yeah, no homo. Ryan Matta, Yaakov renewed, and myself will be on here tomorrow, 3 p.m. Eastern time, streaming the trial. Come check it out. Be there, be square, guys. Say hi to my cat while you're at it too. Say hi, Sheba. Good girl. All right, love y'all. See you on the next one. Later, brother.